Hello, Ms. Stevenson. Can you hear us?
Yes, I can hear you.
Great. Thanks for joining us. Will you be with us all day?
As far as I know.
Good. Well, any reason to think you'll be leaving at like 2?
Nope.
Okay, good. So we're on a pretty ambitious schedule that involves not many breaks. I need you to let me know if we have not taken a break at a time you need a break. We'll have a morning break at some point, and then lunch break is going to be around 1, but lunch will probably only be about a half hour. So if you need more time to flex your fingers, take a deep breath, whatever it is, please let me know, because of course we need you making a good record of everything that's going on here. Since you're not in the courtroom with me, you can't look back and like give me the eye roll of like, I need a break. So please just speak up if you need a respite. Will you do that?
Yes.
Excellent. Thank you so much. And if you can't hear any of the lawyers, let me know. We have like 700 lawyers handling this. You're going to need a roster. They belatedly provided a roster to your colleague yesterday. Did she forward that to you, or are you going to need names?
Need names. All I have is a caption and a judge's name.
Okay. That's me, McBurney. But it's the lawyers who will do most of the talking. So if you want to provide an email address in the Zoom chat, I can get some representative from each side to get you the roster of lawyers that are on each side. Does that?
I will need firm information, addresses, phone numbers, email address, and who you represent. And here comes my email.
All right. Do we have someone on each side who can pull that off? I know BME can pull it off the chat. Mr. Prince, are you able to do that as well? Good. So if you two could be responsible from each side, getting to Ms. Stevenson, that's a whole lot of information. So get that to Ms. Stevenson over the course of the day. She doesn't need it right now, but before.
Oh, I'm sorry. I do need that now. I need to know who's who represents who, so I know who's speaking.
Okay. You don't need firm, weight, school, that kind of stuff. You just need the names and what side they're on right now.
Yes.
Okay, great. So let's get that to Ms. Stevenson. In the meantime, I'll identify a couple people for you because we need to get started. Ms. Stone is one of the lead counsels for plaintiffs. Good morning, Ms. Stone. How are you?
I'm doing well. How are you?
Anything procedurally from plaintiff's side?
Nothing from us.
And Mr. Scher, which is spelled, Stone is spelled as you would spell it, like rock. Mr. Scher, it's spelled SCHAERR. Mr. Scher is one of the lead counsel for the state. Good morning, Mr. Scher.
Good morning.
How are you?
I'm doing well, thank you.
Great. Anything we need to work through procedurally for the defendant?
No, Your Honor.
Okay.
And Mr. Ed Trent will be handling the cross-examination of Dr. Fetal.
All right. Hello, Mr. Trent.
Morning, Your Honor.
Good morning. So I think we're ready to get started if there's nothing procedural remaining. If it's not going to be Ms. Stone who does the direct examination of Dr. Bedell, then that lawyer should introduce herself, full name, rank, serial number for our court reporter. And if Dr. Bedell is here, if that's, unless you switched it up and we're doing Nesmith first.
No, Dr. Bedell and I'll be handling her examination.
Well, look at that, so easy.
Easy.
Oh, that's some alignment. Okay, then let's get started, please.
All right, plaintiff's call Dr. Martina Bedell, please.
So who will be doing the speaking in these examinations? Will it be Mr. Trent and Ms. Stone?
Ms. Stone for the plaintiffs.
Okay.
And Mr. Trent for the defendant.
And could someone spell the doctor's name for me, please?
She'll spell it once she's sworn in.
Okay.
Do you swear or affirm that the testimony you will give the whole truth and nothing but the truth so help you?
I do.
Go ahead and state your name for the record.
Hello, I'm Dr. Martina Bedell, Martina, last name Badell.
Good morning, Dr. Bedell.
Good morning.
You stole my first line. Good morning, Dr. Fetal. Could you please walk the court through your educational and professional background?
Of course, I went to undergrad at the University of Texas in Austin, and then I went to medical school at the University of Rochester in New York, where I spent 5 years getting my MD degree and doing an additional year of research in clinical OBGYN. I then couples matched here at Emory University in residency in OBGYN. After completing my 4 years of OBGYN residency, I matched into Emory's Maternal Fetal Medicine Fellowship, which is a 3-year fellowship.
And what are your current positions?
So currently, I'm an associate professor in the Department of Obstetrics and Gynecology and the Division of Maternal Fetal Medicine at Emory University. I am the director of the Emory Perinatal Centers, which are 2 regional referral centers for high-risk pregnant women in Atlanta and around the region. I'm also the Maternal Fetal Medicine Fellowship Director for the Emory MFM Fellowship, which is the only MFM fellowship in the state. On a national level, I am an elected member of the Publications Committee for the Society of Maternal Fetal Medicine, which is an organization that helps set practice guidelines, reviews evidence to set the standard of care in maternal fetal medicine. Additionally, I'm an oral board examiner for the American Board of Obstetrics and Gynecology in the subspecialty of maternal fetal medicine, which helps determine if physicians are board certified in our fields. My area of research is in infectious diseases and pregnancy, and I have guest researcher status at the CDC to help give expert advice on infectious diseases and pregnancy. And I also serve on the panel for the Department of Health and Human Services to develop guidelines for the management of HIV and pregnancy.
And do you have any positions at Grady Hospital currently as well?
Yes, I also staff the HIV and pregnancy clinic at Grady Memorial Hospital.
Are you board certified?
Yes, I am board certified in obstetrics and gynecology and also maternal fetal medicine.
So you've used the phrase maternal fetal medicine a few times. Could you explain to the court what that is?
A lot of times.
Maternal fetal medicine is a subspecialty of obstetrics and gynecology. It's a 3-year additional training in taking care of high-risk pregnant patients.
Are you a member of any professional organizations?
Yes, I'm a member of the American Congress of Obstetricians and Gynecologists and also the Society of Maternal Fetal Medicine.
Is the American College of Obstetricians and Gynecologists sometimes referred to as ACOG as well?
Yes.
So if I refer to it as ACOG, you'll know what I'm talking about. Yes. What, on a weekly basis, can break down what your professional responsibilities look like?
Sure. I spend on average 3 to 3.5 days a week taking care of patients, and I do that at the Emory Perinatal Centers. And then I spend a half a day a week at Grady Memorial Hospital taking care of patients in that clinic. The other day and a half, I spend doing administrative work to help train our fellows, conduct research, and also help run the perinatal centers.
And have you published any research?
Yes.
Have you published in peer-reviewed journals?
Yes, I think I have over 50 peer-reviewed publications in the field of obstetrics and gynecology.
Your Honor, we would like to ask this court to qualify Dr. Bedell to speak as an expert on maternal fetal medicine.
All right, I need you to pause for 1 second. We'll do that. I just remembered one thing I need to do. The countdown timers.
My colleagues tell me I started at 9:17, so.
So we'll give you a minus 4 minutes. Hold on 1 second. So when we left off yesterday, plaintiff was at 3:29:43. I'll make that 3:25. So 3 hours and 25 minutes. And defense was at, we'll round it up to 2 hours and 50 minutes. There's a static. Yours will start in just a second. And think we're good. Okay. Back to you.
All right. Your Honor, we'd like to ask the court to qualify Dr. Bedell to speak as an expert and give her expert opinion in maternal fetal medicine.
Trent, any objection to having Dr. Bedell qualified as an expert in the field of maternal fetal medicine?
No objection, Your Honor.
Great. Dr. Bedell, you're qualified for purposes of this trial as an expert in the field of maternal fetal medicine.
Dr. Bedell, does abortion care come into play in your practice at all?
Yes.
How so?
I counsel patients on abortion in certain clinical situations in which that may be recommended for her pregnancy.
And what about training students?
So I currently don't perform medical abortions or surgical abortions. However, with the training of my residents and fellows and the management of high-risk pregnancies does involve counseling on options, and abortion may be an option. And so part of training them is in how to have those conversations and weigh risks and benefits that may involve abortion care.
So you mentioned counseling patients about abortion care. Can you describe what that process is like?
Yeah, so in general, I see patients not prior to 6 weeks. They generally would have seen a general OB and then get referred to maternal fetal medicine for a variety of reasons. I sort of think of it as three main reasons. One is that there is a maternal complication or the pregnant person has a medical condition that makes their pregnancy high risk. For example, high blood pressure, diabetes. And then I would meet with them to counsel on that medical condition and its effect on pregnancy or pregnancy's effect on the medical condition. I also see patients who have obstetric complications in pregnancy, so specific medical conditions that occur just in pregnancy, like preterm birth, preeclampsia. And then I also see patients if there is a fetal diagnosis in pregnancy, such as a birth defect or congenital anomaly. And so across those three areas, there can be medical conditions in which discussing abortion as a safe way to take care of them can come up.
Can you help me better understand the difference between number one and number two? I get number three. That's a medical concern about the fetus.
Yes.
But the other two are concerns about mom. And what's the difference?
Yep. So there can be some overlap, but medical complications in pregnancy can occur in a woman who has a pre-existing medical condition.
And that was category one.
Yeah.
You come in and you've got high blood pressure. That could make your pregnancy, already you have high blood pressure. That could make your pregnancy more complicated. Number two would be during pregnancy, all of a sudden my blood pressure spiked.
So the obstetric complications like preeclampsia would be that due to being pregnant, you've developed a complication that's directly related to pregnancy.
Okay.
We can also see women who may not have an underlying medical condition, but develop cancer in pregnancy, which the pregnancy didn't necessarily cause the cancer. And that's a medical condition that we would also be involved with taking care of.
And when you're counseling patients in one of these categories, high-risk patients about abortion care, what are your goals in doing that counseling?
So my goal is always to provide compassionate care to my pregnant patients. And part of that is to give them the data and evidence regarding the risks and benefits of continuing a pregnancy, carrying to term, sometimes a preterm birth, and then also the risks and benefits of pregnancy termination.
Do you take care of patients who are pregnant with multiple fetuses?
Yes.
And in your experience, what type of circumstances result in multifetal pregnancies?
Multifetal pregnancies can occur, we say, spontaneously with natural conception. And then they can also occur as part of fertility treatments, which involve both an in vitro fertilization and also ovulation induction.
What is ovulation induction?
That is where a patient takes medications to try to stimulate the ovary to produce eggs to increase the chance of pregnancy.
And in your experience, when are ovulation induction agents used on a patient?
They're offered and used in patients who suffer from infertility, meaning they're unable to conceive naturally on their own and desire to have a child.
And when using an ovulation induction agent, is there any way to control the number of embryos created in pregnancy at that point?
So I'm not a reproductive endocrinology and infertility specialist, but there are some ways they can monitor using ultrasound to assess how many eggs they think may be released, but they can't directly know how many embryos may develop.
And does the risk or the chances of having a multifetal pregnancy, is that spread evenly among women of childbearing age?
So it's more common in women who are older and in women who use infertility treatments.
So I'm going to pause you all. I got a note from Ms. Stevenson that says we need to be the court reporter. Says we need to slow down or no rough will be readable. So I don't know if the sides asked for rough. I think I know what that means. That's before it's final. I didn't get the sense people were going too fast, and that comment came about 10 minutes ago. So maybe we started fast.
Okay.
But let's make sure, especially when we're using complicated words like, well, less common words like preeclampsia, that we speak slowly.
Okay, I'll do my best.
Okay.
Are there any risks associated with multifetal pregnancies?
Yes, multifetal pregnancy would be an indication to see a maternal fetal medicine specialist. It is considered a high-risk pregnancy, and that's because there are increased risks for the mother during pregnancy. Some of those include preeclampsia, gestational diabetes, cesarean delivery, and then also a significantly increased risk of preterm birth and the neonatal consequences of a premature delivery.
And what are the neonatal consequences of a premature delivery?
So they're varied depending on the gestational age at delivery. So a preterm birth is defined as a birth prior to 37 weeks of gestation. Late preterm births, which are between 34 and 36 weeks, can have some complications, including respiratory distress of the newborn, difficulty with feeding, jaundice, very preterm births, and certainly those between 24 to 28 weeks or so have significantly increased risk, including neonatal death, cerebral palsy, prolonged NICU stay, need for intubation.
And do the risks associated with multifetal pregnancies, is it the same regardless of the number of fetuses a pregnant person is carrying?
No, just as twins is higher risk from what we call a singleton pregnancy, or where a pregnant person is carrying one fetus. As the number increases to triplets and quads, the risk increase substantially.
Now, you mentioned abortion counseling earlier. Do you offer abortion-related counseling to patients with multifetal pregnancies?
I do.
And can you explain that counseling?
Yes, so if a patient's carrying a multifetal pregnancy, so triplets or higher, I counsel them regarding the risk of triplets in pregnancy to their health and the health of the fetuses, and then counsel on the option of what's called multifetal pregnancy reduction, which is an ultrasound guided procedure that can reduce the pregnancy from triplets to twins, with the overall goal of increasing the gestational age at which the patient will deliver and improve the neonatal outcome for the fetuses.
And what's the basis for the risks and benefits that you're providing to the patients in that counseling?
It's based on studies evaluating the expected rates of adverse outcomes in patients who continue triplet pregnancies versus those who undergo multifetal reduction to twins.
And what does the medical literature say about multifetal pregnancy reductions?
Overall, it's considered standard of care to discuss multifetal reduction with a patient who's carrying a higher order multiple. It is ultimately her choice how she would like to proceed with the pregnancy. And it's my role as an MFM to make sure that she has the information about the risks and benefits to make the best decision for her health and the health of her fetuses.
In your experience, is it an easy decision for a pregnant person to make whether to undergo a multifetal pregnancy reduction?
No.
What is it? Can you speak a little bit to that?
Yes. So When these patients come to see me for referral, these are often very highly desired pregnancies, whether they're a result of infertility treatment or occur spontaneously. And the families that come are there to gather information to try to make the best decision for themselves in a complicated and high-risk situation. And I can say in my experience that I have never had a patient take that decision lightly, and they consider it and weigh the risks and benefits and try to make the best decision for their family.
There's always a risk. Is there a meaningful risk to the other fetuses? Let's say it's triplets. It's a woman who's been trying to conceive for a long time and through medical procedures is able to conceive, but as triplets, gets the counseling and concludes based on all the risks that have been described that she wants to engage in multi-fetal reduction. What is the counseling you give about the risk if it's going to be to reduce to twins, the risk to the remaining twins?
Yeah, so there is a risk of pregnancy loss of the entire pregnancy. There's also a risk of that occurring with triplets that are not reduced. And so, reviewing the data, it's somewhat specific on the type of triplets that they are and other conditions and if there's bleeding and so forth. But we certainly discuss that as a risk.
Are you familiar with HB 481?
Yes.
And in your experience, now that HB 481 has gone into effect, is multi-fetal pregnancy reduction an option for patients in Georgia?
No.
Why not?
The House bill and the way it's written, it is unclear if it would support that as a lawful procedure
And
after 6 weeks.
is there any way to do a multi-fetal pregnancy reduction before 6 weeks pregnancy?
No, we do not perform them before 6 weeks. And there's a number of reasons for that. One of which is that higher order multiples are at risk for miscarriage, just as a singleton. And if that's going to happen spontaneously, it usually happens prior to the end of the first trimester, in which case then they may self-reduce to twins or a singleton, and they don't need that procedure. Additionally, it gives us some time to evaluate using ultrasound, some of the fetal anatomy, which is impossible to do prior to 6 weeks. And then just the technical feasibility of doing it also.
So how has HB 481 impacted your counseling of patients who have multi-fetal pregnancies?
So my counseling is the same, as the risks have not changed, but now I can no longer offer that service, and patients in Georgia have to travel out of state.
So you can explain the benefits of it and the risks and whatnot. But then if a patient says, that's what I would like to do, you say, you have to leave Georgia to do that.
I'm very sorry, I cannot provide full scope of care. Yes.
You're not prohibited from talking about it. You just have to explain that you, patient, family may decide this is the best option for you, not a service we can provide in Georgia.
Correct.
And for those patients who want to undergo a multi-fetal reduction and can't travel outside of Georgia, how is that going to affect their care?
They will then carry the risk of triplet pregnancies, so for maternal and neonatal risks.
I want to switch topics a little bit and talk about a few things that came up yesterday during the hearing. You mentioned earlier you take care of pregnant people who either have an underlying condition or have some other sort of morbidity that arises during pregnancy. Can you speak to sort of how frequently you are seeing that in your practice?
Every day.
And what are generally the rates among the entire pregnancy population, if you know, of having a severe maternal morbidity?
So severe maternal morbidity is defined by the CDC as an unexpected outcome at the time of labor and delivery with negative consequences on the pregnant woman. And my understanding that happens in about 140 per 10,000 births. So when we think about maternal morbidity and maternal mortality, we think that maternal mortality is like the tip of the iceberg and ideally is a never event, but severe maternal morbidity is much more common. And in efforts to try to reduce that so that to avoid the negative consequences to the pregnant person.
Is there, do different subspecialties of reproductive health pick different denominators? Because we had an expert yesterday where everything was out of 100,000, and some of these lawyers really struggled to turn that into a percentage. You're using 10,000. It's like, that's not even 100,000. It's different. Does maternal fetal medicine, they like 10,000 as the denominator, or
I
what?
use that because that's what the CDC.
That's the
uses for that
CDC.
statistic, so.
Okay, 10,000 it is.
What sort of conditions fall within that severe maternal morbidity category?
So things like a heart attack, renal failure, hysterectomy, need for blood transfusion, ICU admission, mechanical ventilation. There's somewhere between 20 to 25 medical conditions that are categorized as a severe maternal morbidity.
Yesterday, there was also some testimony about viability. What is your understanding of when viability happens in a pregnancy? The point at which viability is possible?
Generally around 22 to 23 weeks gestational age.
And a baby who is born at 22 to 23 weeks gestational age, what are their chances of survival?
So that varies depending on a number of factors, including, are they what we call fetal growth restricted? Are they an appropriate weight? Do they have an underlying birth defect, genetic condition? The circumstances surrounding their delivery. In general, the chance of survival at 22 weeks is very low. There are some babies that can survive, but the vast majority, even with all our advances in neonatal care and aggressive neonatal resuscitation, do not survive.
And what does the care of a baby born at 22 weeks gestational age, what does that look like?
So it involves mechanical ventilation. So placing a breathing tube, generally feeding tubes, IV lines through their umbilical cord, and often transfusions, antibiotics. And in general, babies that are born prematurely have a neonatal intensive care unit admission until they would have been about their due date, although sometimes longer if their course is very complicated.
If a pregnancy is terminated before that viability point of 22 to 23 weeks, is there any way for the fetus to survive?
No.
So I think Judge McBurney yesterday asked the question of, is there a transplant option for a fetus? Is that a possibility?
No, not currently.
Are you familiar with HB 481's exception for medical emergencies?
Yes.
And what is your understanding of what that exception is?
Can I look at it to review?
Absolutely. Could we pull up Plaintiff's Exhibit 1, page 4?
Is this a touch screen? Because it has.
It is, yeah, thank you.
Oh,
Okay.
wow.
Well, you want to stay muted,
Okay.
and then got it.
Okay.
There you go. And it actually, you can draw on it if you need to. We haven't had a witness do that yet. I don't know what Ms. Stone is planning, but
I won't be.
thank you for getting that other stuff off the screen.
Could we blow up the first topic? I think Catherine can do this too for you. The medical emergency, section 3.
So HB 481 defines medical emergency to mean a condition in which an abortion is necessary in order to prevent the death of the pregnant woman or the substantial and irreversible physical impairment of a major bodily function of the pregnant woman.
And as a physician, do you understand how this exception applies?
Myself and my colleagues struggle immensely to understand how to apply this clinically to our patients.
So that phrase major bodily function, is that a term of art you're familiar with, like maternal fetal medicine? It's something that doctors say and everyone knows what it means.
Not generally, no. We also are not clear what necessary means.
I mean, you know what the word means, but you don't know what would qualify as necessary from the perspective of a doctor or a prosecutor who would decide, I don't think that was necessary, so I'm going to bring charges against you, or a crazy judge who might need to decide what's going to happen.
Correct.
Okay.
And what about substantial and irreversible physical impairment? Is that a medical phrase?
That's similarly difficult to apply to the patient in front of you.
So is that a term that you're taught in medical school?
Generally not.
In your experience, are there conditions which there is a consensus obviously apply within this exception?
So in my experience and speaking with my colleagues in maternal fetal medicine, like I said, we struggle to know exactly how to apply this. Most of us agree that there are certain cardiac conditions. So the World Health Organization or the WHO, there are some criteria that take specific cardiac disease and put them into classifications as far as the risk in pregnancy. And there's class 4, which includes things like heart failure with a very low ejection fraction, pulmonary arterial hypertension, in which the recommendation is for pregnancy termination based on the risk of maternal death with pregnancy in those clinical situations. They also have cardiac conditions in class 3 and in class 2, which in class 3, the risk of a cardiac event in pregnancy is 20 to 27%. In class 2, it's 10 to 20%. Is that, appropriate? And can we say that knowing that those numbers exist, that is a substantial risk? Does the woman have to actually have the cardiac complication before we say that she meets this medical exception? Or is the risk of the cardiac event adequate to meet this exception is unclear. And conditions like kidney disease and liver disease don't even have these classifications, along with pregnant persons can have any host of medical conditions for which we then try to manage as best we can in pregnancy.
So you mentioned earlier that pregnant people sometimes develop cancer. How does your understanding of how a cancer diagnosis would fit within there?
This is also a challenge. That depends on the type of cancer, what the indicated treatments would be, the gestational age at the time of the diagnosis. There is a lot of counseling that's involved. Obviously, there's a new cancer diagnosis, there's a pregnancy. It's very complicated. We try to weigh the risks and benefits of treatment, delaying treatment. Will the delay of treatment to prolong pregnancy to a better gestational age result in the increased risk of death of the pregnant person in the long term? Does the exception only apply if it's the death of the pregnant woman during the pregnancy? Again, this sentence is very hard to apply in complex medical situations that we are faced with.
You mentioned class 3 WHO cardiac conditions. Are you aware of the expert affidavit submitted by Dr. Jeffrey Wright on behalf of the state in this case?
Yes.
Have you reviewed it?
Yes.
And do you recall his opinion that a class 3 cardiac activity would qualify as a medical exception?
Yes, in his testimony, he said class 3 would qualify as an exception to this in the ban. However, on speaking to my colleagues, it is not clear, as the guidelines for class 3 do not say that abortion is recommended as it does for class 4. However, we do counsel that that is an option a patient can take to try to avoid the cardiac risks of pregnancy.
Something strange has happened on the screen.
Yeah.
So we can either take that there. Okay.
I think we can take it all down if you want. Additionally, you mentioned renal failure. And are you familiar with Dr. Wright's opinion that a serum creatinine level of 1.4 is a medical emergency under the ban?
I'm familiar that in his testimony, he said that a creatinine of 1.4 would qualify as a medical emergency. However, as a practicing MFM in Georgia, I am not sure that if someone's creatinine was 1.4, that I could assure if I performed an abortion or my colleague did, that they would not be at risk of being arrested and losing their license. And also, is it a creatinine of 1.4 at any time? Is it a creatinine of 1.4 at the time I see them Do we have to wait for it to be 1.4 or develop renal failure before we say, well, now you're sick enough, so you qualify for this exception? It's not clear.
So in your opinion, what does the impact of HB 481's ban have on the treatment of pregnant people who have these serious conditions where you're not sure if it falls within the medical emergency exception?
So the medicine hasn't changed and the counseling and the risks are the same. The difference is that now, as OBs and MFM providers in the state, we have to balance the risk of criminal prosecution if we were to proceed with a abortion versus what we think might be the best medical decision that a patient makes for her body.
Does I haven't plumbed the depths of HB 481. You mentioned arrested. I understand that is a consequence. Then you said lose your license. Is that in the statute that if you are found guilty of this, you lose your license, or that would be a natural consequence from the licensing board or whatever it would be called, that if you get successfully prosecuted for a DUI or a hit and run or performing an illegal abortion, you get your license pulled?
I think if we were charged with a felony for violating a law that's supposed to be related to the practice of medicine, that we would be at high risk of losing our license.
But that would be an administrative consequence. You don't understand the statute to say, oh, and by the way, one penalty is you could be prosecuted, felony, maybe go to prison, but you also lose your license.
I'd have to look at it again to see if
Okay, it's knowable. I just wasn't sure if the sense among the medical community was, it don't really matter what the statute says. If we get prosecuted for it, they'll pull our license over on the administrative side.
That's a concern. And then we can't take care of anyone else.
So how has this lack of clarity around the medical emergency exception, how's it affected your practice?
It makes us feel hand-tied that, normally the patient's interest and her desires for management of her pregnancy align with us providing evidence-based medical care. And in some situations now, we may counsel and say that that is standard of care and that you should have this option. But I'm sorry, it's not clear if we can provide that for you here in Georgia. And it's up to her. She has the resources to go out of state.
You're not removing any options from the list of options. You simply aren't able to provide certain options at the same facility where the counseling is occurring.
Correct.
So overall, in your opinion, what impact is this ban having on the provision of care to pregnant people in Georgia who have maternal morbidities?
So in an outpatient setting where we're counseling, on a medical condition or a fetal diagnosis, I'll say from the patient-physician relationship, it is heartbreaking to tell someone, and if they've come to the conclusion that that's the right thing for their family, that I have to say, well, I wish you the best and good luck. I hope you have the resources and the wherewithal to navigate getting the care that you desire. On an inpatient side, and I think in my testimony, I talk about women whose water breaks prior to viability. They're generally in the hospital. And at that point, it's unclear based on the medical exception when we can intervene and offer pregnancy termination, which is generally considered standard of care to offer that. Do we have to wait until she's infected? Can she just have a tender uterus or a foul smelling odor that we think is infected? Or do we have to actually wait till there's a temperature and an elevated white count and she actually has sepsis before we can intervene? And similarly, if she starts bleeding, how much bleeding? And does she need to require a transfusion before we say, well, that's enough, now we can do it? And those women don't necessarily have the ability to leave a hospital in the state safely.
Do you know that this is switching to the financial side? And if it's outside your scope, just tell me. If a patient has the ability to afford the treatment that she selected after counseling with you, that might be one of the multi-fetal reductions, but she has the ability to afford it because of her insurance in Georgia, how transportable that is, or am I getting outside your knowledge base? In other words, hey, I found a clinic in North Carolina, California, Massachusetts, but insurance won't cover it. And so I could take a bus up there and afford that. I can't afford $10,000 for the procedure.
Yeah. So insurance does not necessarily cross state lines. So I think patients have to figure that out and navigate that on their own also.
And following up on Judge McBurney's question, do you have any understanding of how the costs of having an abortion, are they the same regardless at which point in pregnancy you have an abortion?
No, they are more expensive the further along. And again, I don't see women prior to 6 weeks. So whenever I'm counseling patients, we're talking about a later termination.
Are you familiar with the HB 481's medically futile exception to the ban?
Yes, although could I have that?
Yes, let's pull that up too. It's Plaintiff's Exhibit 1. Page 4, the PDF. And then just the subsection 4, right below where we were before.
Thank you.
So the act defines medically futile means that in reasonable medical judgment, an unborn child has a profound and irremediable congenital or chromosomal anomaly that is incompatible with sustaining life after birth. Do you have a understanding of what incompatible with sustaining life after birth means?
I think I do, but again, a challenge to know exactly how to apply it and ensure that we're following the law.
And what's the challenge?
Is it incompatible with sustaining life after birth immediately, in a week, in a month, in a year? Is it incompatible with sustaining life after birth with no medical intervention, with aggressive medical intervention?
Are there any conditions that there's been a consensus in the medical community in Georgia that qualify as meeting this medically futile exception?
In the conversations I've had, in my experience, anencephaly is one of the only things that we agree upon that we feel certain as we can that it would qualify to this exception.
And what other severe fetal anomalies is there not a consensus around that you see in your practice?
Trisomy 18 and trisomy 13 are two of the conditions that we see in pregnancy, and that is routinely offered as part of prenatal screening for all pregnant people. And the vast majority of pregnant patients choose to undergo that screening along with screening for Down syndrome. Trisomy 18 was previously considered a lethal diagnosis, and without aggressive postnatal care, people with trisomy 18 did not survive. Still with trisomy 18, there's a very high risk of stillbirth with that condition. And with aggressive medical care after delivery, still, 10% of less children survive with that condition. And those who do have severe neurodevelopmental disabilities. But it's not clear, again, if they survive the pregnancy and the delivery, and if we provided neonatal resuscitation, some may survive. So it's unclear if it makes the exception, even though it's a devastating diagnosis.
What is trisomy 18 or trisomy 13?
It's where a fetus or a child gets an extra 18 chromosome. We have 23 pairs of chromosomes. You get one from your mother and one from your father. And trisomy is where you have a third of a chromosome. And then 18, it's 18, 13.
And what does the child born with trisomy 18, what does that condition look like for the child?
So it can vary. It's very severe, and it can have a number of birth defects involving sort of actually all the major organs, the brain, the face, the heart, the intestines, the kidneys. Each person or fetus with trisomy 18, it's not necessarily the same. They're often severely growth restricted or very small.
And you mentioned that it's routinely screened for. At what point in pregnancy does the screening for trisomy 18 and trisomy 13 take place?
So as far as prenatal, you can do prenatal screening or diagnostic testing. Screening is generally like a blood test, and the earliest that you can do that is about 10 weeks. And the diagnostic testing to say that we're certain the fetus isn't affected involves a chorionic villa sampling which is at the end of the first trimester, or an amniocentesis, which is another prenatal ultrasound guided procedure that we generally cannot perform between 15 or 16 weeks to confirm that diagnosis.
So can it be diagnosed before 6 weeks?
No.
In your experience, when you've had a patient who their fetus has been screened or diagnosed with trisomy 18 or 13 or any other sort of fetal anomaly, severe fetal anomaly, and they make the decision to terminate their pregnancy, is that an easy decision for patients to make?
No, the vast majority of patients I see have highly desired pregnancies, and when I deliver fetal diagnoses or abnormal genetic diagnoses to families, they are generally devastated. They do their best to take the information regarding the risks and benefits of continuing the pregnancy to themselves, and then for the potential neonatal outcomes for their child. And when they do choose to terminate, it's a very personal decision that they take very seriously. But once they have made it, they need to move forward with it, and having to travel and go out of state prolongs that suffering.
Is trisomy 18 something that is inherited? In other words, one of the parents had a risk of that, or it's a mutation? It could happen. The two healthiest parents of all time, they've had 6 kids who were born perfectly healthy, but number 7, because of fate, you get trisomy 18.
That's a good question. So most of the time it is just a spontaneous sort of error of the chromosomes. It is more common as women get older, as we're born with all the eggs we will make and they age with us, and the chance that there is an extra chromosome or a trisomy, whether it's trisomy 21, 13, or 18, increases with age. There are rare conditions in which you could carry a balanced translocation of chromosomes or have something called gonadal mosaicism that could result in multiple pregnancies with trisomy 18. But for the most part, it's an unlucky event at the time of fertilization.
So you mentioned the patients who have made the decision now to terminate and delaying their suffering, having to go out of state. What about the patients who can't travel out of state?
So then they have to carry those pregnancies to term and then make decisions about the care of their neonate. And again, I have women that we deliver devastating diagnoses to, and they choose to continue their pregnancy. They feel like any time they have with their child is important and valuable to them, and we wholeheartedly support whatever decision they make with compassion and care. But fundamentally, they warrant the counseling about their options and be able to make the right decision for themselves and their families.
I want to turn to talk about a few other things from Dr. Wright's report. If we could pull that up. Defendant's Exhibit 22. And page 9, paragraph 48. And I'm going to point you to the second to last sentence in this paragraph that says, the Life Act does not interfere with the physician-patient relationship any more than does general tort law providing for medical malpractice liability. Do you see that?
I do. Thank you for highlighting that.
Do you agree with that statement?
I do not.
I didn't highlight it, just to be clear.
Someone highlighted it. Thank you.
Why do you disagree with that?
So as obstetricians and maternal fetal medicine doctors, we are used to taking care of our patients and navigating what the best decisions for them are, understanding that we are at risk for medical malpractice cases. However, in general, as long as we are providing the standard of care and taking care of the patient as best we can with the information in front of us, and that generally aligns with her wishes for herself and her pregnancy. And if we are sued for malpractice, we have to prove that we were not negligent and that we followed standard of care. And in general, we're not at risk of being arrested. Whereas under this House bill, what the patient desires and what we're able to do not necessarily align. And that, if I or another OB doctor in Georgia provides an abortion that subsequently decided that it did not meet the exception appropriately, then we can't care for other patients. So normally we can think of the patient in front of us and what's best for her and her pregnancy. And in these now challenging situations in the back of our minds, we're like, why I can't do anything wrong here, because then how will I take care of my other patients?
Have you and your colleagues discussed the dilemma from the other direction? You described a patient who has an infection, but maybe it's not severe enough yet to qualify for the exception. And so you elect, based out of fear of arrest and losing your license, I'm going to hold off. And the infection moves faster than you thought, and the patient dies. You could be sued for malpractice for not having cared for the patient. But the reason why you didn't care for the patient was, I don't want to get arrested, which seems like that is very different from general tort law.
Absolutely. And actually that highlights the case that happened in Ireland. Ireland used to have very restrictive abortion laws, and that exact situation happened where a pregnant patient was admitted with her ruptured membranes, and the physicians waited and waited because the baby still had fetal cardiac activity, and she ultimately died. And actually then Ireland changed their restrictive abortion laws in relation to that case. And those physicians, I think, were at risk of being malpractice for not taking care of her sooner, but it's a challenge.
The court reporter has asked that when we're done with exhibits, we take them down so that she can see the witness's face. Easier to do takedown. So if we're still on 48, let's stay on it. If we're
One
not,
more paragraph to go to in
Okay.
this one. Could we go to page 11 and paragraph 56? In paragraph 56. Thank you. Dr. Wright here says that I accordingly disagree with plaintiff's expert's conclusion that the Life Act will adversely affect the physician-patient relationship. And he continues that laws regulating the practice of medicine do not unduly interfere with the physician-patient relationship. On the contrary, they protect patients from inappropriate therapies and insulate physicians from unreasonable patient demands. Do you agree that that HB 481 protects patients from inappropriate therapies and insulates physicians from unreasonable patient demands? And then we can take that off. Thank you.
No.
And why not?
I think providing abortion services is an essential part of reproductive health care and is not an inappropriate therapy.
Do you know any physicians who's performed an abortion because of an unreasonable patient demand?
No, physicians do not perform abortions who do not want to. And in our training, as I think was discussed yesterday, learning how to perform abortions is standard care in OBGYN, but any resident physician or attending physician who has an objection to doing that does not perform them.
And in your opinion, and in your experience, is providing abortion care part of the standard of care?
Yes.
I have no further questions.
all right. Pause that.
Your Honor, if I may, I'd like to at least hand for the witness and for the court a copy of her affidavits, just simply for ease of reference, instead of having things pop up and down on the screen while we go through it.
Great. And your last name is
Trent.
standard spelling.
Yes, sir.
Great. Thank you.
Good morning, Dr. Waddell. My name's Ed Trent. I think you indicated in your earlier that you don't perform abortions as part of your practice. Is that correct?
I perform multifetal reduction and selective reductions. I do not do medical abortions or surgical abortions.
Okay. And we'll talk about the difference between what happens during a selective abortion when you talk about medical and surgical in a moment. Well, I guess we'll do that now. For selective reduction, that involves basically, say in triplets, a decision is made that for the benefit of the mother and for the continuing pregnancy, that we're going to reduce the pregnancy from 3 to 2. Is that right?
That's multifetal pregnancy reduction.
Right. Okay. And that involves using, I think you said ultrasound, where then you use a needle with potassium chloride to inject in the one fetus that will not continue on in pregnancy. Is that right?
Correct.
And that fetus dies, but remains in the womb until the other 2 children are born.
Correct.
Now, looking at your CV, you've done obviously significant research on HIV in pregnant women. Is that right?
Yes.
You've also looks like in here in the last couple of years, done significant research on COVID-19 in pregnancy.
Correct.
But you've not written any research papers on access to abortion, have you?
No.
No research papers on the benefits of abortion, correct?
No.
No research papers on the impact of abortion on women, correct?
Correct.
Now, in your affidavit on paragraphs 23 and 27, you indicate that the embryo is neither living nor distinct from the mother. Is that correct?
Can you say the paragraph number again, please?
Paragraphs 23 and 27.
Yes, that they are not living distinct persons.
All right. So then what is the embryo if it's not a living, distinct person from the mother?
It's an embryo.
How is that not living?
It depends on how you define living. When a child is born, they're given a birth certificate and they're counted as a living person.
So in your opinion, when is this baby alive? At birth?
So when life begins is a religious and philosophical question. It's not something we're taught in medical school. I'm here to give my medical expertise.
So you don't have an opinion on when this child becomes alive?
Is her opinion relevant if it is philosophically and religiously based?
Well, that's sort of my question. You're here as a medical doctor. Do you have a medical opinion on when life begins?
There's no solid medical. We're not taught in medical school about when life begins.
Now, isn't it true, though, that this embryo begins developing at the moment of fertilization?
At the moment of fertilization, cells begin dividing to develop into an embryo.
All right. And this is the same process it's going to develop. It develops into an embryo, then to a fetus. It's born into a child and ultimately ends up in a courtroom one day talking about this, correct?
Potentially.
Okay.
If it's lucky.
Yes.
That's how I feel.
Now we know that in the process of development, the cardiovascular system is one of those first organ systems to develop. Is that right?
The embryo is developing lots of organ systems at the same time.
All right. And in the early stages, by the 6th week LMP or 4th week after fertilization, we've got the beginnings of a circulatory system with a small fetal heart that's pumping blood through its body. Is that correct?
The structure that will ultimately develop into the heart is already conducting electrical activity at 6 weeks. Yes.
And
At
it's
6 weeks, is it a 4-chambered heart like a human heart? Is it like a reptile heart with 2 chambers? It's not even a heart. It's just some cells that are sending out electrical activity.
It's not a 4-chamber heart that you would think of as having.
That a baby has when the baby emerges.
Yes, which is also how we would never be able to diagnose a fetal heart condition at 6 weeks. That's it.
But it's still a cardiac muscle, though, that's that's contracting to move blood through the baby's body, correct?
Yes.
Okay. And at the 6-week mark, this tiny fetal heart operates in a steady and repetitive rhythmic contraction within the embryo's body. Is that right?
Usually.
Okay. And this heart that starts beating at this time, that's the same heart that's going to beat in this child to the day it dies, even if that's an old age.
Yes.
Okay. Now, in your role, you care for a number of pregnant women in high-risk pregnancies as a maternal fetal medicine doctor. Is that correct?
Correct.
And you will probably, Your Honor, and I apologize, get a text from the court reporter saying Mr. Trent needs to slow down. So if you see that, please tell me.
Okay, it hasn't happened yet, but that's probably because she's trying to keep up.
Yes. In treating the women, do you want the best outcome for both the mother and your child?
Yes, I've spent my career trying to learn to provide the best evidence-based maternal and fetal care.
All right. And would you agree that abortion is a bad outcome for the child?
The abortion is performed on pregnancy when a woman decides that that's the best decision for her body.
All right. But it's not a good outcome for the child.
Continuing the pregnancy may not be a good outcome for the child either.
All right. When we're talking about non-medical reasons for abortion, we don't have any idea that there's a medical reason that this abortion needs to end or that the pregnancy needs to end, correct?
We may not.
Right. In treating these high-risk, complicated cases, in the 3.5 days you're in one hospital, the half day that you're in Grady Hospital, are you constantly exercising your reasonable medical judgment and providing care to your patients?
I'm constantly trying to apply evidence-based medicine to follow standard of care.
And in doing that, are you exercising your reasonable medical judgment?
That's not a term that we generally use, but
Well, I'm assuming you're not trying to be irrational or unreasonable in recommending care.
correct. I try to follow evidence-based guidelines.
And the evidence-based guidelines, I believe you mentioned, come from the Society of Maternal Fetal Medicine is one place.
Correct.
And the American College of Obstetrics and Gynecology is another place. And have either of these organizations provided guidelines on medical emergencies during pregnancy?
They have not created, and this has come up about, is there a list of conditions that would meet these exceptions? No, it's too difficult to do.
All right. Is it too difficult or they just haven't gotten to it yet?
It's too difficult.
Right. Now they provide lists in a number of other situations though, don't they?
That's a very good question.
I mean, they provide you lists on what the proper standard of care is in any number of situations.
Yes, and within certain medical conditions, like I described, abortion is considered, or to be counseled and offered abortion is considered standard of care. But there's not one reference that you can go to say, you know, it's agreed unanimously and you will be protected under the law if the patient has X, Y, and Z condition.
Now, with more states implementing laws to have greater protections for the unborn child and limiting these elective abortions, wouldn't an update from one of these two organizations on what constitutes a medical emergency during pregnancy be helpful?
So when this ban initially came out, that was our thought was, okay, let's try to get together and see, can we come up with a list so that we can care for our patients and try to determine when these restrictive abortion bans meet exceptions. And it is too challenging. Medicine is too complicated. The complications that pregnant people enter pregnancy with are vast. The complications that occur in pregnancy are vast. And we actually worry by creating a list, if we leave something off, there's something we haven't thought of, we don't know, it's multiple things together that we could actually hurt patients.
So that's why you exercise your best medical judgment in providing care and recommendations to your patients.
That's why we try to follow the standard of care.
Now, in your affidavit, you reference a number of articles dealing with fetal mortality. Can you define fetal mortality for us?
Could you point out where I reference that?
I believe it is in paragraph. Well, you talk about pregnancy-related, paragraph 21 on page 11 of your affidavit.
Sorry, where does it say fetal mortality?
Pregnancy-related death is defined as a death during pregnancy or within 1 year after the end of pregnancy from a health problems related to pregnancy. That's under the pregnancy-related mortality.
You asked about fetal mortality.
Then that understands why everybody's confused, because the question I asked wasn't what I thought. Talking about maternal mortality during pregnancy, when we track those, it's during pregnancy and up to a year afterwards. Is that right?
Yes, and as the judge said, there are different standards as far as exactly how it's defined in the denominator and so forth, but this is one definition that we use.
Now, in your report, in footnote number 2 on page 6, you cite a National Institute of Health. What are maternal and morbidity and mortality? It's Plaintiff's Exhibit 145. Correct, that's one of the studies that you've cited in your report?
Yes.
Now, in here, they reference at the very top of that there are approximately 700 maternal deaths or pregnancy-related deaths in the United States. Do you agree with that number?
Yes.
And do you agree with the National Institute that there are approximately 50% of those deaths would have been preventable?
Yes.
Now, nothing in the article suggests that the lack of access to elective abortion has anything to do with the number of pregnancy-related deaths, does it?
This study was published prior to this data is from prior to restrictive abortion bans. I think I've only practiced in an era where until very recently, Roe v. Wade was intact. And my understanding from talking to senior OBGYN physicians was that when abortion was illegal, that the mortality and morbidity associated with illegal and unsafe abortions was high, but I'm not sure that that's included in this number.
But this article says nothing about, gosh, even with, abortion available pre-viability, if we just had more elective abortion, we'd have a lower maternal mortality rate related to pregnancy.
Could you please say that again?
Sure, nothing, let me just kind of rephrase it. Nothing in the article says that we need more abortion in order to lower the pregnancy-related death rate.
I don't think the article references abortion at all.
All right. Another article that you reference in footnote 16 on page 12, which is plaintiff's 126, article Geographic Healthcare Access, Racial Discrimination, and Socioeconomic Determinants of Maternal Mortality in Georgia, from the International Journal of Maternal and Child Health and AIDS from 2021. Do you recognize that article?
Yes.
Now, on page 279, talks about contributing factors for the mortality rate are things such as age, marital status, educational level, and race of women. 279. Here at the bottom, it says the high MMR in Georgia is due to a number of social determinants of health, including geographic location of obstetric services. That's another part that they also reference. Do you see that on the screen?
Yes.
Is there anything in the article that suggests that lack of access to abortion, particularly elective abortion, was a factor in the maternal mortality rate related to pregnancy?
I would have to review the article in detail again. I'm not sure that it mentions abortion at all.
I can represent to you that it does not.
Okay.
Another article that you reference, which is Plaintiff's 146 in footnote 26 on page 19 of your affidavit, to how implicit bias contributes to racial disparities and maternal morbidity and mortality in the United States, the Journal of Women's Health. Now, here it also references approximately 700 deaths because of pregnancy or delivery complications. Do you agree with that statistic?
Could you say it again? Sorry.
Do you agree that there are approximately 700 women die each year as a result of pregnancy or delivery complications?
Yes.
Okay, so that's all across the United States. And they also represent And they emphasized the majority of these, I believe 3 out of 5, could have been prevented. You see that in there? Can you highlight that section, Josh? I believe it's down in the next paragraph. Or if you want to go to the conclusion, it's also referenced there.
I think, again, these studies are prior to the restrictive abortion ban, and that this is a recent development here in Georgia, and it occurred in Texas and prior to us. And there has been an article published from Texas that showed that the restrictive abortion bans increased maternal morbidity associated with inability to offer abortion. As I mentioned before, I think from speaking to senior obstetricians, that when abortion was illegal, the maternal morbidity and mortality associated with illegal and unsafe abortions is real, and that we may not have the data here, but with time, as women may seek unsafe or illegal abortions or not have access to them, it will take us time to know the downstream consequences of that in the current
Right,
era.
at this point, that's just a pure guess, isn't it?
I said it was based on prior when it was illegal. And then there's now been this report in Texas.
Okay, and I promise you we'll get a chance to talk about the Texas report. But here we've got a recent study that talking about mortality rates related to pregnancy, because you talk in your affidavit that getting pregnant is a really dangerous thing for women to do. But it seems here that we've got a relatively small number, and that we have the ability with our medical care today to drastically decrease the number of these maternal deaths right now without resorting to abortion. Is that not correct?
I think we do our best to reduce them, and they still happen. Are you saying that because we define them as preventable?
Correct. If they're preventable, that means there are more things we can do in medicine to make sure this woman has a better outcome without terminating the pregnancy.
So it doesn't, the preventable does not necessarily mean that. It can also involve things like suicide, which in theory is preventable, although the ban in Georgia actually excludes mental health illness as a medical criteria. Domestic violence is also considered preventable and has nothing to do with advances in medical care. So the preventable is a broad range of
But
things.
domestic violence would be a pregnancy-related death. It's the way it's calculated in this article, is it?
It's a pregnant person that dies during pregnancy, so that's still included.
So they include domestic violence as a death related to the pregnancy.
If a pregnant woman dies, that still can be categorized under a pregnancy mortality.
What about a car accident?
Similarly,
So these numbers then include a pregnant woman who happened to die in a car accident as part of the 700?
so like I said, it depends on exactly how you're defining and what denominator you're using, but the preventable doesn't always mean that with advancements in medical care, we could have prevented it.
Well, it sounds like it's also not advancement so much as expansion of medical care, as in I don't have access because I live in a rural area or I'm poor in an urban area. So it's not we need fancier machines. It's we need to get these women connected with the resources that already exist.
Okay. Now, similarly on plaintiff's exhibit 51, which is from the Georgia Department of Health, referenced in footnote 15 on page 12 of your affidavit, they also note that 87% of pregnancy-related deaths in Georgia were preventable, correct?
Sorry, I'm not sure where you are. This is,
Which footnote on what page?
It's on footnote 15 on page 12. It's where you reference this chart. It's plaintiff's exhibit 51.
yes, but just as the judge pointed out, preventable is a general term that can be related to access to care and not just advancements in medical care.
But abortion has nothing to do with preventing the death, correct?
So it depends on the situation. Again, I described medical conditions in which the risk of death is increased in pregnancy. And that may be considered preventable, and that if she had terminated, she may not have died.
That's when, in the doctor's judgment, that abortion was necessary to prevent the death of the woman, right?
So I think I said it before, and if I didn't, I'd like to say that necessary to prevent a death is that a death that we think is 1% likely, 10% likely, 20%. I'd say in most of medical care, preventing death, even a very small chance of death, we would still do. And it's unclear at what risk of death to the pregnant person would qualify as necessary.
So when using your best medical judgment, would you recommend that a woman consider abortion in order to prevent her death?
So I counsel and would offer that. My concern is that if I was in a court and it was up to a jury or a DA to determine if it was necessary, that it is not clear where that line may be and that I could be at risk of prosecution or one of my colleagues.
Okay. With all due respect, Dr. Vidal, that wasn't my question. My question to you was, when do you counsel a woman that an abortion may be necessary in order to prevent her death? What do you look at in making that judgment to make this counseling recommendation to your patient?
So a number of things, her current condition, what we predict maybe the risk of death will be with continuing pregnancy. We do know that death associated with pregnancy is significantly higher than that with abortion, as I think was discussed yesterday.
So from that, would you say that anytime a woman is pregnant, that abortion, she ought to consider it because something might happen that could lead to her death, more likely with pregnancy than with abortion?
So I think there are risks associated with all pregnancy, which we discuss with patients, and that her desire to be pregnant and to have a child generally outweighs that. And all pregnant women are willing actually to take on a lot of risks during pregnancy. And as long as that is her choice, we're there to support her.
I understand wanting to support the mother's choice. My question to you as a medical doctor, a maternal fetal medicine doctor, with extensive experience, board certified, works in high-risk pregnancies all the time. When is it that in your medical judgment, a woman's life is at risk that you would recommend that she seriously consider aborting that child?
There's a host of medical conditions, and when I may bring that up with her, including also her prior pregnancy complications.
So these are things you do with all of your patients as you evaluate them using your best medical judgment, isn't it?
Yes, like I said, my counseling has not changed. What has changed is whether we as OBGYNs in the state of Georgia feel that we can actually offer abortion services here without breaking the law.
You say your counseling hasn't changed, but if you, and it may not be exactly your role, but if you or a colleague encountered the situation of, it looks like there's an infection there. And if I didn't have HB 481 looking over my shoulder, I might recommend more aggressive treatment than I am. Is it not affecting your counseling? Because you might recommend or not even mention a course of treatment because of concerns that I don't know where necessary falls. It hasn't been defined.
I think in general, the counseling is the same, but you're right. I think prior to this, we could feel more comfortable. And I think I said it in my affidavit that the vast majority of my patients, they're highly desired pregnancies, and that by my discussing and offering termination as a potentially appropriate medical therapy, they're appreciative of having the choice to make the best medical decision. And a lot of times in pregnancy, it's not just that pregnancy, it's what will affect their future pregnancy. If you have sepsis or an intrauterine infection and require hysterectomy, you can't have other children.
And the reproductive system of a woman is one of her major bodily functions. Is that right?
Correct.
Her heart system is a major bodily function.
It's a major bodily organ.
Okay. The circulatory system would be the major bodily function, then I suppose.
Okay.
All right. The kidneys, part of a major bodily function. Is that right?
They're a major bodily organ.
Okay. They facilitate the cleansing of blood, which is a major bodily function of the woman. Is that right? Okay. I'm sorry. Is that yes?
Yep.
Okay. So you know what those are and you treat them all the time. Is that right?
We treat medical conditions in the body and pregnancy, correct?
And are you able to determine, based on the condition of the woman that you are treating, whether or not continuing her pregnancy would put those major bodily functions at risk for severe and irreparable harm?
Could I have the ban up again? Because again, it's the language that's a challenge.
Sure. So exhibit number 1. you wanna
Yes,
highlight
in
there?
order to prevent substantial and irreversible physical impairment of a major bodily function. We used the creatinine level earlier. The creatinine is a measure of kidney function, and this does not describe at which number or what level that would be. Certainly dialysis, which is that the kidneys have failed completely and you're using a machine to perform that function, we would probably all agree. But dialysis is very morbid and has a lot of risks associated with it. So do we wait until we think that this pregnant person will need dialysis before we offer medical care? Again, in other parts of medicine, as doctors, our responsibility is to do no harm and to take care of patients. And we don't wait for significant or substantial and irreversible physical impairment before we offer treatment.
Correct, because the statute says that you can use the abortion to prevent that from happening. Isn't that right?
Well, it says is necessary in order to prevent. And that's the challenge is, can we say anyone with any renal impairment, knowing that the kidneys work harder in pregnancy and are at risk of worsening renal function, that's enough? Again, is it a number? Is it what renal abnormality they have? This is not clear.
That's why the statute puts this in the reasonable medical judgment of the doctor, correct?
Does it say? It says.
When it talks about the prosecution, that the defense to the prosecution is that you exercise your reasonable medical judgment, correct?
Correct. However, that is still at risk of the interpretation of potentially a jury, and medical care is complicated, and the fear of, am I able to explain this in such a way that it would be unanimously agreed upon that it meets this exception is our concern.
Now, when you have these serious conditions, you mentioned earlier that you talk with a group of doctors that you work with.
Could you say that again?
Sure. When you have a particularly difficult case, do you go to your colleagues and say, hey, I've got this difficult case. Can you look at it with me and help me figure out maybe a possible course of action?
Sometimes, yeah.
And if you're worried about, gosh, this person has some kidney disease, their creatinine level is starting to creep up, does it look like they're going to, if this continues, create a problem for their kidneys down the road? Do you talk with doctors about that?
Potentially, yes.
All right. In between, then you and some other really smart nephrologists be able to figure out, gosh, this pregnancy is going to present a substantial and irreversible impact to these women's kidneys. If the pregnancy continues, we need to look at how we're going to solve that, correct?
We certainly would discuss how to take care of the pregnant person to optimize their health. Yeah.
Do you flip a coin as to whether one kidney makes it substantial or meaningful loss of both, or where does substantial get solved?
This is my concern. And also, I think you're getting at, if more than one doctor thinks that it meets this, because we've discussed that also. So we say, well, if one MFM and a nephrologist, or one MFM and a cardiologist, or two MFMs, or the OB and the MFM, if there's two of us, or is it three of us? Is it a committee? Do we have time to put a committee together will that protect us? And again, in medicine, we're not used to having to worry that we're going to be prosecuted for breaking the law when providing medical care.
So are you looking for something that says, if I use my reasonable judgment in making this call based on what I've documented, I'm not going to get prosecuted? Are you looking for that kind of an assurance?
Well, I think we struggle in being able to provide care because we don't have an assurance. I'm not sure that there could be language that was written that would encompass all the complications that can arise.
Sure, that's why you're the medical doctor, and they place this in your reasonable medical judgment. Do you not agree with that?
So I can make recommendations based on my expertise. Again, the concern is, will it be considered legal under this current writing of the law?
Let's take a look at some of the complications that you referenced that may occur and how those are typically treated. I want to draw your attention in particular to Plaintiff's Exhibit 134, which is the CDC's article, Pregnancy Complications, cited in footnote 3 on page 7 of your affidavit. Now, as part of your practice, do you look to the CDC for some guidelines on best practices?
Yes.
Right. And under before pregnancy, the very last sentence of that paragraph says, if health problems are under control and you get good prenatal care, you're likely to have a normal, healthy baby, correct?
Correct for some people, but not everyone.
Well, certainly there are 7 billion people in the world that all kinds of things can happen.
Yep.
But in general, the CDC says if you got your health under control and you've got good prenatal care, you should have no problems having a healthy baby.
So there are patients who are not able to get their health problems under control during their reproductive age and may still seek pregnancy.
But that's not what this sentence said. I mean, this sentence
Yes.
says if mom is healthy and it's a big and you get good prenatal care, then you are likely, not assured, but likely. It doesn't sound like a controversial sentence to me. You agree?
Yes.
You don't have to agree, but if you don't agree, I want to understand.
No, I think this is true, although, you know, a normal healthy baby, 12% of patients deliver prematurely. And so is that defined as a normal healthy baby? And once you start adding up, different risks and a 3% risk of a birth defect. So I think still overall likely, but.
Because if 12% are early, that means that 88% aren't. So you'd be more likely than not to have a normal, healthy baby. If, they're big ifs, your health problems are under control and you get good prenatal care.
Good care, yes.
And under during pregnancy, the very next paragraph at the end, it says many problems are mild and do not progress. And they make the recommendation. However, when they do, they may harm the mother or her baby. And keep in mind, there are ways to manage problems that come up during pregnancy. Always contact your prenatal care provider if you have any concerns during your pregnancy. It's the CDC's recommendation, correct?
Yes.
And they go through a list of different types of complications that may arise. Anemia is listed. They recommend simply taking iron and folic acid supplements, correct?
I can't see that part, but that sounds correct. Okay.
There, next line to the bottom. Is that right?
Yes.
Now, urinary tract infections is a complication sometimes of pregnancy,
Correct.
sometimes outside of pregnancy.
Correct.
Those are treated with antibiotics, is that correct?
Yes.
Doesn't treat that with abortion, right?
A urinary tract infection would not be a medical indication for an abortion.
Okay. So I take it from that there are certain medical indications for abortion.
There are medical conditions in which we would discuss the option of abortion.
Okay. Mental health concerns is the next, and it recommends there that getting treatment is important to both mother and baby. And if you have a history of depression, it's important to discuss this with your healthcare provider early in pregnancy so that a plan for management can be made. Is that correct?
Yes, and this is very important, but I will say in my practice, however, accessing mental health resources in the state of Georgia is very challenging due to access to providers, insurance coverage, expenses. And so, although I agree with this sentence, it's not always accessible or affordable.
There's no reference, though, by the CDC that says, look, if you can't get to a psychologist, then have an abortion.
I didn't say that either.
Okay. Hypertension recommends monitoring your blood pressure, including at home, and having that under control with your doctor. Is that right?
Yeah, so high blood pressure puts patients at risk. And then the most important thing is to try to keep it under control, which is part of what I can help to do.
Right. So most of the time it's controllable.
Generally, mild hypertension we can control in pregnancy.
There are serious situations where you're not able to control it. Preeclampsia is something you mentioned, correct?
Correct.
So then we take a different course of action in that kind of a life-threatening situation, right?
Potentially.
Yep. Same with diabetes here. The CDC recommends managing that. And it can help women have healthy pregnancies and healthy babies, right?
Correct. I spend a lot of time managing diabetes in pregnancy to optimize maternal and neonatal outcomes.
For obesity and weight gain, again, they recommend losing weight before pregnancy in order to increase the likelihood of a healthier pregnancy, right?
Correct. But most people, that's a challenge to do, but correct.
Talks about infections. The easy steps are things like hand washing and avoiding certain foods, right? For HIV and things of that nature, talks about screening and vaccinations.
and treatment with antiretrovirals.
Okay. Nowhere does the CDC say in dealing with these various complications that abortion is medically indicated, medically necessary at all in order to address them.
I don't think that's the scope of this article, but
Now, are these,
we go through some common things we see in pregnancy and how to manage them.
so one of those that you mentioned earlier in your testimony of a serious complication would be something called preeclampsia, correct?
Correct.
Can you describe for us what that is?
Preeclampsia is a hypertensive disorder that's specific to pregnancy, which is generally seen as high blood pressure in the mother with protein in the urine. However, can affect other bodily organs. And it's classified as mild it's classified as with severe features or without.
Okay.
Why is it bad to have protein in the blood? The high blood pressure, I understand, don't want that, but
The protein in the urine is a sign that the kidneys are being affected by preeclampsia.
okay.
Show you what we'll mark as Defense Exhibit 620. Article from the Cleveland Clinic on preeclampsia.
Thank you.
Definition you just provided of preeclampsia is consistent with the Cleveland Clinic's definition. Is that right?
Yes.
Now, they note that preeclampsia typically develops after the 20th week of pregnancy. Do you see that?
Yes.
Is that consistent with your experience?
Yes.
Now, in those early 20th weeks, we may be pre-viability. Is that right?
Yes.
If you turn over on page 5, it talks about how preeclampsia is treated. Do you see that section?
I see it. Yes.
Right? If you're close to full term when this develops, they recommend basically you can deliver early.
Again, it's broken down by preeclampsia that is with severe features or without severe features. Preeclampsia without severe features requires very close surveillance and recommend delivery at 37 weeks. Preeclampsia with severe features, generally those patients require hospitalization and very close monitoring, and we don't prolong pregnancies past 34 weeks.
Right. And in your experience and with your training, you're able to tell the difference between the two.
There are criteria that we use to tell the difference.
Right. And you apply those to your patients, right? To make the diagnosis.
Yes.
And are you able to tell when you have a patient whose preeclampsia with serious conditions is to the point where the pregnancy needs to come to an end? We either need to deliver the baby or we need to terminate it through abortion.
There are criteria that we say we would recommend against what's called expectant management, which is continuing the pregnancy with close surveillance.
Now, another area that you referenced that would be a significant complication would be premature rupture of membranes. Is that right? Or preterm rupture of membranes?
Correct.
PROM, I suppose, is the acronym.
Yeah, they're preterm rupture of membranes is.
Okay. And you referenced an article from Tanya Medina, Plaintiff's Exhibit 141. And I apologize, my note doesn't specifically note where in your affidavit that is referenced, but do you recognize the article once it gets pulled up?
Yes.
Okay. And obviously, it's very important in these situations for appropriate evaluation and management in order to improve the neonatal outcomes, as they reference on 659. Do you agree with that?
Yes.
And the treatment may depend on when this occurs during the pregnancy. Is that right?
Yes.
If it occurs in the pre-viability period, the likelihood of the child surviving is very small.
Generally, yes.
And risk of infection, I believe you said, is extremely high. And this significant risk of infection to the mother puts her life at risk at times, correct?
Yeah.
All right. It could impact her ability to ever have future children.
Correct.
All right. And you're able to tell where we are with these patients in evaluating this.
So we do our best to evaluate, and generally the patients are hospitalized because the clinical condition can change very quickly from the patient being stable to being infected and getting very sick. And so we use our best judgment to monitor them and try to evaluate if we think an infection has developed or is developing.
And the time period of when this occurs also impacts, say, and I believe the article references 24 weeks sort of as the cutoff. For after 24 weeks, to the extent it's safe to do so, we try and continue the pregnancy to 34 weeks. Is that right?
Correct.
We can't do that all the time because of things changing very quickly.
Yes.
And doctors like you get paid to make the decision on, we can't go any farther, right?
Yes, it's my responsibility to make a recommendation regarding delivery in the setting of premature rupture of membranes.
Now, dealing with medically futile situations, obviously incredibly difficult for the family, is that right?
Correct.
In your affidavit in paragraph 38, you reference a type 1 spinal muscular atrophy where the child may only live 2 or 3 years.
Correct.
Do you believe that situation is incompatible with sustaining life after birth?
I think I mentioned earlier that that language is hard to interpret. Sustaining life after birth, again, is it immediately or within a few years of life for things like spinal muscular atrophy or Tay-Sachs disease?
That's why I'm asking, in your medical opinion, would a child that may only live 2 or 3 years, is that child incapable of sustaining life after birth?
Generally, they are able to sustain life.
Okay. Now, in paragraph 39, seems to me that you suggest that abortion is appropriate for any child with a potential disability, because you note that women should have the autonomy to choose abortion, quote, based on the anticipated needs for the child, their values, their family and financial situation, and other highly individualized considerations. Do you see that?
Yes.
Is it your opinion that abortion is appropriate anytime any kind of a fetal anomaly is detected?
I would counsel and discuss the anomaly, and the patient could have the option to continue or terminate the pregnancy.
And one of the anomalies you mentioned earlier was Down syndrome. Do you think that would be a genetic anomaly that's incompatible with sustaining life?
No.
Would you agree with the law that prohibited abortion on the basis of a diagnosis of Down syndrome?
Again, I think it would be the woman and her family's choice to continue a pregnancy that's effective.
So the answer to that then is no, you would not approve of the law that prohibited abortion for Down syndrome.
I do not think that would be in the best interest of pregnant patients. No.
Would it be in the best interest of the children with Down syndrome?
The children with Down syndrome are cared for by their families after birth, and so it's up to that patient, her wishes for that child.
Now, some fetal anomalies are treatable, correct?
Correct.
Some are not treatable, but the child can live and either with or without medical care, loss of a limb, for example.
Correct.
And then some are life limiting to the point that chances of the child either surviving to birth or after birth are extremely small.
Correct.
And those would be like life limiting type conditions.
Correct.
All right. In talking about miscarriage, we heard from Dr. Siwiak yesterday that the procedures used to care for miscarriage medically and surgically are the same as those used in abortion. Does that sound correct?
Yes.
Right. And I believe in your affidavit, you note that there's 15 to 20% miscarriages that occur.
That's a general number, yes.
So there are numerous opportunities for the training of medical students on how to handle miscarriage care.
So a number of those miscarriages happen spontaneously without any medical intervention.
I think you mentioned when we talked some about selective abortions or selective reductions. Let me ask you, first of all, how frequent do triplets occur?
I can't remember that number off the top of my head.
I told you it was approximately 1 in every 10,000 pregnancies. Sorry for the denominator, Your Honor. Would that be about right?
That might be in live births. That may not be in pregnancy.
Okay.
Because there are triplets that self-reduce or that patients reduce.
Okay. How do you select which fetus doesn't get to continue?
So in a multi-fetal pregnancy reduction, which is triplet or higher, it's based on trying to assess the anatomy of the fetuses, if there appears to be something wrong with one of them. Some families choose to undergo prenatal genetic testing, just as they do in singleton pregnancies. And if one was affected, you may select that. Otherwise, it's based on technical feasibility.
Technical feasibility of which child is least likely to make it to birth?
If all things are equal, you choose the fetus that's farthest from the cervix, because then the procedure is less likely to result in loss of the entire fetal pregnancy, we think.
Now, in your rebuttal affidavit, you criticized Dr. Wright for relying on a study by Ji-Yan Lee. It's on paragraphs 19 and 20 of your rebuttal affidavit. Because that study was from South Korea, correct?
It was a single study in Korea, correct?
In 2021 is when this was published, right?
That I'm not sure.
If we can pull up 518.
If you say so.
Okay. Well, the outcomes that the Lee study showed is that expected management, given our current advances in medical abilities, have a good or better outcome in triplets than by using selective reduction to twins or singles. Is that the conclusion of this study?
That's the conclusion of this study, although it's not in line with the Cochrane review of multiple studies and other studies on the procedure.
All right. But the study then, the survey of studies you provided in your rebuttal report is by Yaniv Zipori, Plaintiff's Exhibit 143, which is there on the footnote on that same page of your rebuttal affidavit, correct?
Yes.
All right. In looking at the studies that he looked at, it's on page 3 of the chart at the top, with the years of reduction, the most recent is 2013, done in London. The next two most recent are 2012. One is in Turkey, the other is from Iran. Doesn't really translate to the United States, does it?
When you're giving these years, I see a 2015, several 2014s. What years are you
Looking
talking?
at years of reduction, the ending of when it was evaluated.
Not the date of the study, but whatever years of reduction means.
The years when the reduction was performed in the multifetal pregnancy.
Got it.
So the most recent ones he looked at, the data was most recently collected in 2012 in Iran and Turkey. Not exactly compatible with the United States, is it?
Correct, although this is multiple studies, and again, the Cochrane review, which I think is in my initial plaintiff, which looks at a large number of studies, did show benefit with the procedure. And again, this is this is counseling and information for patients to make their own decisions. And this particular study is using one study, and the gestational ages at which they did it and how they did it is not the same as what we do here in Georgia.
And do we know whether what we do here in Georgia is analogous to any of these studies referenced by Zipori?
So the abdominal approach is, so for the vast majority of these studies,
Including Turkey and Iran?
yes.
Okay. The last thing I want to talk with you about, you mentioned the Texas issue. It's plaintiff's 144. Just going to give you it laid out a little differently because it's how I got it in my paper. So we're not going to talk about the same page.
Thank you.
In the review of the Texas situation, this is the article that you reference in footnote 23 on page 17 of your affidavit. Is that right?
Yes.
So here we had 28 patients that presented at less than 22 weeks gestational age with preterm premature rupture of membranes, preeclampsia with severe features, and or vaginal bleeding. Is that right?
Yes.
All severe morbidities at the time they walked into the hospital.
They had obstetric complications when they walked in.
Which include, and those are the things that they included, right? Is
Those are
what they had.
obstetric complications. Those are different than severe maternal morbidity.
Do you believe that preterm premature rupture of a membrane is a severe morbidity, a severe impact on the mother?
It's a severe obstetric complication.
And one that needs to be treated because if left untreated, she could either die or have a substantial impact on her major bodily functions.
She's at risk for that, correct?
Okay. And I believe you told me earlier it's a substantial risk. I'm sorry, say yes. Okay. And then in preeclampsia with severe features, that's the worst kind.
Correct.
And then vaginal bleeding is also not a good thing during this level of pregnancy.
Correct.
And indeed, 26 of the 28 had the premature rupture of membranes, right? Looking at the
Correct.
chart on the right.
Yes.
Now, it notes in the bottom there of the study design that after 2021, all were expectantly managed through medical intervention when there was an immediate threat to maternal life. Do you see that?
After September 2021, all were expectantly managed with medical intervention where there was immediate threat to maternal life, correct?
So we have all 28 of these folks, according to this study, when they were managed, they had an immediate threat to maternal life, which falls under the Life Act's medical emergency exception, correct?
So they were expectantly managed, meaning that they were not offered or able to have an abortion until there was an immediate threat.
Where does it say they're expectantly managed until
What's
there was
that?
immediate?
They were expectantly managed with intervention when there was an immediate threat. So prior to the immediate threat, they were expectantly managed.
Well, this seems to say they're expectantly managed following the existence of an immediate threat to the maternal life. Because they had an immediate threat to her life, we expectantly managed her when that threat was existing. Is that not how you read it?
That's not how I read it, and how I tried to describe in my earlier is that premature rupture of membranes and preeclampsia with severe features and vaginal bleeding are all obstetric complications of pregnancy that we know can result in maternal morbidity and mortality. These women were expectantly managed, meaning they were not offered medical care to end their pregnancy until the immediate threat to the life. And as practicing obstetricians and MFMs in the state of Georgia, it is uncomfortable to wait until someone has gotten infected or bled enough that we can agree that it's an immediate threat to their life.
I'll tell you, Dr. Bedell, that I think your reading is inconsistent with what's here, but obviously the judge is also capable of reading and draw his own conclusion. But the fact of the matter is, if these women showed up in Georgia and in the exercise of reasonable medical judgment, the doctor says that abortion was necessary at less than 22 weeks in order to prevent the death or serious and irreparable physical impact on a woman's major bodily function, abortion is allowed under the Life Act, correct?
Maybe I'm not being clear. So premature rupture of membranes is an obstetric complication that can occur and places the woman at risk for severe maternal morbidity and mortality. The way the Life Act is written is there has to be immediate threat to that. So again, is premature rupture of membranes alone at the moment, most of us are uncomfortable that that would qualify as a medical exception, and that previously that is standard of care to prevent the severe maternal morbidity. Again, in medicine, we want to do no harm, and the health of our patients is our priority, and waiting until, and it says expectantly managed with medical intervention when there was an immediate threat. So again, bleeding beyond a certain amount, infection, and with this expectant management, the rate of maternal morbidity was over 50%.
It was almost double. I mean, it was 33% in other scenarios, right? I read the article too. I don't know the way you're reading it, but we are reading it differently.
I think the word when means something different than until, but no deaths out of this situation, right? Fortunately, correct?
There was one hysterectomy, which means no future children.
Okay.
And death again is we don't want maternal deaths.
Of course we don't. And the statute says you're able to act to prevent that from occurring. These weren't evaluated under the Georgia standard, correct?
My understanding is that the Texas restrictive abortion law is not too dissimilar to ours.
All right. That's all I have, Your Honor. Thank you.
You're welcome. Let me stop the timer. Ms. Stone, do you have any redirect?
I have two very short questions. Dr. Bedell, Mr. Trent asked you some questions about deaths, pregnancy-associated deaths, when a pregnant person is killed through domestic violence or is died in a car accident, for example. Could you explain the difference between pregnancy-associated deaths and pregnancy-related deaths?
So I think pregnancy-associated death is a pregnancy or a death of a pregnant person, and pregnancy-related is if we think the death was related to pregnancy in itself. And the numbers and the denominators, and during pregnancy, 6 weeks, 1 year, I think there's some variation, and that's not my area of expertise in those definitions.
But a woman who dies as a result of a car accident, but she's pregnant, has nothing to, probably has nothing to do with the pregnancy. It could be because of the nature of the injuries. Had she not been pregnant, she wouldn't have died, but it's not caused by the pregnancy in the same way that you've talked about a ruptured membrane and sepsis, and then the expectant mother dies. That would be pregnancy related, as opposed to I happen to be pregnant when the lightning bolt hit me.
Then could we pull up plaintiff's exhibit 144, please, which is the study you were just looking at? Or you've got it in front of you too, I think. So while we pull it up, Mr. Trent was asking you at the end of that study design language, which I'm not, we have a different PDF, so it might be on the next page. But Mr. Trent was asking you about that language where that said after September 2021, all were expectantly managed with medical intervention when there was an immediate threat to maternal life. Could you just read the next two sentences of that as well?
The primary perinatal outcome was fetal or neonatal demise. The primary maternal outcomes were maternal morbidities in the table, time from presentation to delivery, and indications for delivery.
And what is fetal or neonatal demise?
Fetal demise is when the heartbeat stops, when the fetus is still in the uterus, and neonatal demise is when the neonate dies after birth.
Thank you, Dr. Bedell. I have no further questions.
All right. Any recross, Mr. Trent? All right, I think, may Dr. Bedell step down. Thank you, ma'am, for your time.
Thank you.
Appreciate it. We're going to take our morning break. What is next? I think there is one plaintiff's witness left, but Ms. Naismith is not here now, as forecast. Okay. So, Mr. Scher, tell me what you want to have us do when we get back from our morning break.
We'll call Dr. Scott.
Okay, so Dr. Scott is around. Great. Okay, excellent. But as long as she's back here at 11:15, we'll be good to go. So we'll pause for 10 minutes, come back 11:15 on the clock on the wall, and we'll pick up where we left off. For people's count, hour 55 left for the state, 2:38 left for plaintiffs.
Oh, yeah. Julia. She's not the girl. Hi there. Hi, I'm Julia. And so we're now switching over to the services and then seeing if you have to we'll be going later in the afternoon. She is an cultural. Essentially, summarizing what happened. But basically, heard, but was still down. And then after that, so maybe specifically that means there's no change. To the moving, you know, when you do statewide well, that's a good question too. So it's the judge, if the judge that immediate so it's not generally, if we went to get rid of the family was. Yeah, she doesn't know that. Sorry, we are just. I move them around hard. No, glad you did.
Welcome, nice to you.
It's funny coming in after the break, you can hear all the snack bags crinkling shut. Ms. Stevenson, are you ready to go?
Yes, sir.
Great, thank you. Before we pick up with the state's first witness, a note from the court reporter: when lawyers are drifting from the lectern to hand something to a witness, what you're saying is hard for the court reporter to hear. Typically, it's been, I'm presenting you with exhibit X and not, here's the key to the case. But just know that if you're away from a microphone, it is easy for those of us in the courtroom to hear you, but the court reporter can hear you less well. So you'll want to be mindful of that and maybe announce your purpose before you leave the podium and then resume your questioning only when you're back. All right, with that, who from the state's team? It looks like it's Mr. Field. Good morning, sir.
Good morning, Your Honor. Brian Field on behalf of the state, and the state calls Dr. Ingrid Scott.
Dr. Scott.
the whole truth, and nothing but the truth.
Oh my God.
Go ahead, Mayor. State your spell your name for the record.
My name is Ingrid Skop, INGRIDSKOP.
Good morning, Dr. Scott. Again, my name is Brian Field. I'm one of the attorneys for the state. What is your occupation
I'm an obstetrician gynecologist,
and where do you work?
San Antonio, Texas.
And for what employer?
Currently, I am the senior fellow and the director of medical affairs of Charlotte Lozier Institute. I am also working part-time as an obstetric hospitalist in San Antonio.
Can you spell Lozier?
LOZIER.
Thank you.
And
Prior to that, I worked for 25 years as in a private practice.
also in San Antonio.
Yes, sir.
And in the interest of time, did you attach a CV to your affidavit?
I did.
And does that CV reflect your relevant educational and professional activities?
Yes, it does.
Okay, but I'd like to discuss a few things that aren't reflected there. Do you attend conferences to stay up to date on developments in the areas of obstetrics and gynecology?
Yes, I do.
Do you ever present at such conferences?
Yes, I have.
And have you published papers on matters related to obstetrics and gynecology?
Yes, I've published several peer-reviewed papers.
Okay. And when was the last time you published a peer-reviewed paper on these topics?
June of this year.
And have you studied the various methods of performing abortions, surgical and medication?
Yes, sir, I have.
Have you published papers on those topics?
I have published several papers on those topics.
And you said that you were an OBGYN for 25 years, correct?
Yes, sir.
And how many babies do you think you delivered during that time?
I have the best job. I believe I've delivered over 5,000 babies.
And are you board certified as an OBGYN?
Yes, sir.
And are you a member of any relevant professional organizations?
Yes, sir. I'm a member of ACOG that's been discussed here previously. I'm also a member of the American Association of Pro-Life Obstetricians and Gynecologists.
Have you ever treated women who are experiencing pregnancy complications?
Many times.
And where in the pregnancy process have you treated them? Early, first, second, third trimester?
I've treated all 3 trimesters and postpartum complications.
And have you ever treated women who have experienced miscarriages?
Yes.
Have you ever performed an abortion?
No, I have not performed an elective abortion.
So you added an adjective in front of there. You've not performed an elective abortion. That
yes,
wasn't
sir.
his question. So help me understand the difference between question and answer.
I have never intentionally ended a pregnancy with the purpose of ending the fetal life, which is the legal definition of abortion, induced abortion. I have, as we'll discuss, I think, on occasion needed to perform a medically indicated separation of a woman and her fetus when her pregnancy posed a risk to her life.
But have you received training on how to perform an abortion?
Yes, every method that can be used to perform an abortion can also be used for other obstetric and gynecologic indications, most frequently to remove a deceased fetus or embryo.
And so in your practice, have you performed a dilation and extraction, or a D&E?
Yes, I have.
And have you performed dilation and curettage, or D&C?
Yes, sir.
Okay. And have you observed an abortion being performed?
Yes, I have.
Have you ever worked at Planned Parenthood?
Yes, I have.
And in your practice, have you ever treated a woman whose pregnancy put her life at risk?
Fortunately, it's fairly uncommon, but I have in 25 years on many occasions cared for such women.
And have you ever had a patient who was considering having an abortion?
Yes, sir.
And did all of those patients go through with it?
Not all of them did.
And as part of that care, did you discuss with them the benefits and risks of all procedures that were available?
Absolutely, including support, because for many women, addressing an unintended pregnancy, if they find that they have support, they often will carry their baby.
And have you ever treated a patient who was just experiencing complications from their pregnancy?
Yes, certainly.
And have you ever treated a patient who experienced complications from an abortion?
Yes, on many occasions.
Now, Your Honor, I'd like to tender this witness as an expert in the following topics: obstetrics and gynecology, including fetal development, treatment for pregnant women, and the method and risks of abortion procedures.
All right. All right, Dr. Scott, you are qualified for purposes of this proceeding as an expert in generally the OBGYN field, but with the, I won't call them subspecialties, but the other areas of inquiry that Mr. Field identified. Before we go any further, Ms. Mickelveld, has your name been provided to the court reporter? So we should let her know that you are handling examination on behalf of plaintiffs of Dr. Scott. And I want to make sure that the names of Team SisterSong have been provided to our court reporter.
I believe they have, but I'm happy to say and spell my name. Since
Let's do that.
Rolls off the tongue.
Okay.
It's Tiana, Tiana. Last name Mickelvet, Mykkelt, as in Tom, V as in Victor, E as in Edward, D as in dog, T as in Tom.
Thank you. I paused your clock for that.
I noticed she was taking a little extra time on the spelling.
All right.
Thank you. So you recall submitting 2 affidavits in this case?
Yes,
Is that
sir.
correct? Okay. And do those reports reflect the opinions that you've offered in this case?
They do.
And do you hold all opinions in those reports or affidavits to a reasonable degree of medical certainty?
Yes, I do.
Now, I'd like to begin at the beginning. When does life begin?
Life begins at fertilization. At that time, the embryo becomes a zygote and immediately starts dividing and differentiating and growing, utilizing metabolism or utilizing nutrients and metabolism. And those are all definitions of life.
And is there any general consensus on this point in the medical community?
There was a survey of 5,000 biologists, and irrespective of political persuasion, 96% of them agreed with the statement that life began at fertilization.
But biologists and medical doctors are different. Did you say biologists?
I did say biologist. There is a trend in medicine to redefine the beginning of a pregnancy as the time when it can be detected, which is approximately 1 week after fertilization when it has implanted in the uterus, and when a beta HCG can be detected in the blood. But irrespective, within a week of fertilization, all medical doctors consider that to be a living human being.
All is a big word.
Based on science.
And I believe you also cited some embryology textbooks in your affidavit. Is that correct?
Yes, sir, I did.
But you read Dr. Bedell's expert report, correct?
I did.
And what do you make then of her statement? This was at paragraph 27, that in the last 3 decades, the consensus among the scientific community is that an embryo is neither living nor distinct at 6 weeks LMP.
I'm not sure why she said that, because that's not scientifically correct.
And do you recall whether or not there were any citations of authority at paragraph 27 for this quote consensus?
As I recall, there was no reference to back up that statement.
Okay. But you understand, though, that in this case, we've been talking a lot yesterday and today about the heartbeat. Is that correct?
That is correct.
Okay. So can you describe for the court the process by which the heart develops in an unborn child?
So rapidly, as I mentioned, after fertilization, the cells begin dividing. Within a week or two, they begin differentiating into the organs that they will become. So they become unique. At approximately 23 days of life, there is a muscular tube made of cardiac muscle. And at the same time, the autonomic nervous system has developed to the point where it sends electrical impulses to the muscle. This causes the muscle to contract. And in addition, liquid and blood cells that carry oxygen have developed at the same time. As it contracts, it pushes the blood through the embryo's body.
And just to make sure I understand, what is it that causes that contraction?
It's a portion of the nervous system that is involuntary.
Okay. So do you recall Dr. Bedell stating, and some other witnesses as well, that there's embryonic cardiac activity as early as 6 weeks LMP?
Yes, I recall them stating that. That is a medical description of what's occurring. To the layman, we know that as a heartbeat.
So on that point, is there any difference between what you're saying and what they said other than jargon?
No, there's no difference.
Now, do you also recall yesterday hearing testimony from Dr. Swiak about miscarriages?
Yes, I do.
Okay. And do you recall her testifying that they are common after 6 weeks?
I do recall that.
And is she correct about that?
Miscarriages are common in general. Approximately 15 to 20% of pregnancies are lost, but most losses occur prior to the heartbeat. Once we've seen a heartbeat in an uncomplicated pregnancy, that has about a 97-98% chance that absent an outside intervention, that baby will be born alive. Even in complicated pregnancies, 82%, the vast majority, will be born alive once that heartbeat is detected.
Where does that data come from?
It comes from various studies. They're in my report.
Like the higher article in your
Right.
reports?
I believe one of them was from fertility and sterility. I don't recall where there were a couple other articles.
When you say absent external complications, does the mother developing, for example, preeclampsia, would that be, it's external to the fetus, but it's not external to the mother?
Right. So absent an outside intervention. So the fetus is on his way to becoming live born. Of course, the most common outside intervention is an induced abortion. But as we'll discuss, if a doctor does need to intervene to deliver the baby, many times they're born alive. But if they're not, if they are too early, then that would be another situation where they would not be born alive.
But when you use some very, very high percentages and then said absent any outside intervention, well, we've been hearing about how women encounter obstetric complications and whatnot, and the percentages were higher than 2 or 1%. So I'm wondering if you are categorizing a medical condition that develops for the mother as an external complication.
The vast majority of the medical complications that threaten a woman's life occur in the second half of pregnancy, and almost all the time those babies can be born alive. So they're not counted in that number.
Okay.
And just to make sure the record is clear, that the original question on that point was about miscarriages and the percentage of miscarriages. Your testimony was that after 6 weeks LMP, or when a heartbeat is detectable, the rate goes down significantly.
Exactly. So this is a point at which we can say this human being is likely to enter our society as a living member of our society at birth.
And then if we move forward from 6 weeks LMP, what occurs with that heart's development?
Well, its function never changes. So it's going to continue to distribute oxygenated blood throughout the embryo and later the fetus's body, and then, of course, later the child's body. It does develop in complexity. It sort of twists. It develops 4 chambers instead of the initial 1. Valves develop, and that process is completed by about 17 to 20 weeks. But the function that the embryo needs is fully developed at the time that the heartbeat is detectable.
And starting at that 6-week point, if that heart muscle were to stop beating, would the unborn child be able to continue developing?
No, at that point, he needs that heart to distribute the oxygen. He would die if the heart stopped beating.
And we've heard a bit about chambers, and the reports that plaintiffs experts have introduced talk about the 4-chamber heart. In your experience, are you aware of anyone who's been born without a fully formed 4-chamber heart?
Sometimes it does happen that babies do not develop all 4 chambers.
And in those instances, would that child still be considered by a doctor to be a living person with a heartbeat?
Of course.
And what happened to those children?
Well, in many cases, because our medicine is amazing, in many cases, interventions can be performed so that that child can live and live a good life.
And are you familiar with any authoritative medical literature that defines life as requiring a heart to be fully formed with 4 chambers to define the existence of life?
There is no literature to support that.
So I'd like to talk with you now a bit about the health risks from abortion. And then let's begin with Dr. Swiak's statement yesterday and in her report that abortion is safer than pregnancy. Do you recall hearing that?
I do recall hearing that.
And are you familiar with a study that is quoted as suggesting that abortion is actually 14 times safer than pregnancy?
Yes, I'm familiar with that study.
And I'd like to talk with you about that study from the vantage point of the patient. So you talk in your report about a 2-patient paradigm. Can you explain what that is?
Well, as an obstetrician, I consider myself to have a responsibility to 2 patients, which is a great job to have. I weigh the different outcomes of different interventions based on how it will affect both of my patients. Unfortunately, I think as we have seen in the testimony, there are some doctors who have only a one patient paradigm wherein the mother's needs are paramount. The fetus is only worth considering as a patient if that fetus is desired.
Okay, so let's talk about this report first with respect to the unborn child patient. How would you compare the safety of abortion with pregnancy?
It's important to recognize that the data in the United States is very incomplete, flawed, and compromised. So we cannot rely upon this study. If we look, the best way to determine a death related to pregnancy is called records linkage. And that's where we take all death certificates of a reproductive age woman and we link it back to determine what sort of pregnancy events or interventions have been performed.
And we'll explore that a bit, but with respect to the unborn baby patient.
Oh, I'm sorry. I
How
skipped
would you
ahead.
compare the safety of abortion with pregnancy?
Every successful abortion ends the life of the unborn baby. So it is not safe at all.
And now with respect to the mother, I'd like to discuss the study. And this is the Raymond and Grimes study. If I use that term, is that
Sure.
Something you'll understand?
Yeah, absolutely.
And in that study, according to Dr. Swiak, it says that there were more maternal deaths per 100,000 live births than fatalities per 100,000 legal induced abortions. Does that sound correct to you?
That is what that study claims.
And you take issue with that, right?
I take issue with much of the data in that study.
So what I'd like to do is to talk about the formulas that led to those figures. And let's start with the denominators. If we look at these denominators, on the one side, as I mentioned, we have live births. And on the other side, we have legal induced abortions. So beginning over with the live births, do you have any reason to doubt the accuracy of that figure?
That is the only figure that is accurate because in our country, we mandate a live birth certificate after a pregnancy passes 20 weeks. But I would note that ideally, we would use 100,000 pregnancies so that we could actually compare all of the at-risk women. We do not use 100,000 pregnancies because we do not have any way to determine accurately how many pregnancies occur.
So if I understand correctly, saying that because it measures only starting at 20 weeks.
And live births after 20 weeks, which deaths associated with those account for only 2/3 of our maternal mortality.
Okay. Now let's look at the other denominator, legal induced abortions. Is that number also tracked?
It is not mandatorily recorded. It is voluntarily reported through two pathways. The state health departments report to the CDC. Some choose not to report anything, such as California, that has a tremendous number of abortions. Alternatively, the Guttmacher Institute, which is the research entity affiliated with the abortion industry, consistently reports about 20 to 30% more abortions a year because they get their information directly from the abortion industry. And I would note that even though the Raymond and Grimes study used CDC maternal mortality data, they did not use the CDC abortion numbers. They've switched over and used the Guttmacher numbers. So in this case, they've caused that denominator to be much higher. And as I mentioned earlier, the maternal mortality denominator is much lower than it should be.
Okay. Now let's flip up to the top, to the numerators. And I'd like to discuss the two numerators. You have the live maternal deaths for live births on one side, number of fatalities for abortions on the other side. Do you have confidence in the accuracy of either of those?
No, I do not.
If we begin with the maternal deaths from live births, what's your concern about that data?
Well, it is widely known, and there has been much discussion in the past, I would say 5 or 10 years at least, that the maternal mortality data in the United States is incompletely determined. It's estimated approximately 50% of deaths are not documented as such on a death certificate. To improve that, the CDC requested that the states put a pregnancy checkbox to remind the doctor who's filling out the death certificate to tell him if it was related to a pregnancy, either during the pregnancy or within a year of the ending of the pregnancy. But even in that situation, we've seen that between 13 and 50% of the pregnancy checkboxes were inappropriately checked. That is, the maternal mortality committees could not find a pregnancy when they reviewed records. And some of these were in extremely older ladies, 75, 85. We know clearly there was not a pregnancy. So there's a lot of false positives there.
Has this I mean, has this been an issue for an extended period of time? Has the United States ever had a time when they weren't tracking maternal deaths?
Yes, there was a widely read paper in 2016 by McDormand out of University of Maryland, where she documented that from 2007 to 2016, the United States knew our data was so bad, we did not report a maternal mortality ratio to the world.
Now let's flip over to the other numerator. This is the fatalities from abortion numerator. How accurately, in your opinion, is that tracked?
I think this is very inaccurate. Again, the CDC largely requires a death certificate to tell us that an abortion occurred. And for many reasons, abortions are not documented on death certificates. And, as I mentioned earlier on the records linkage data from Scandinavian countries where they have single payer healthcare, they know every event, they have meticulous record keeping. They documented that of all maternal mortality, only 27% were documented on a death certificate. Specifically regarding abortion-related mortality, only 6% of deaths, only 1 out of 20 deaths was documented on the death certificate. They would have never found it had they not done the records linkage, and we don't do records linkage here.
So of all 4 figures we just discussed, 2 denominators, the 2 numerators, do you have an opinion as to which is the least accurate?
I think undoubtedly the abortion-related mortality data is the most inaccurate.
And in addition to what we just discussed about the various inputs that go into these figures and the comparisons to the Scandinavian studies, do you have any other reason to question these data?
I think that it's very likely that many abortion-related deaths are complications of maternal health complications, suicides, accidents, homicides, even substance abuse and overdose. And again, when we look at the Scandinavian data, in the year following an abortion, a woman is 2 to 4 times as likely to die of any reason. She is 6 times as likely to commit suicide, 4 times as likely to die of an accident, and 10 times as likely to be killed. So over there, they're telling us exactly the opposite of what Raymond and Grimes told us, that abortion is much more likely to result in a woman's death than a term childbirth.
And I'd like to pause here for a moment to discuss ACOG with you, because this is the point in, I believe it was Dr. Swiak's rebuttal report, that she takes issue with the way that you've talked about ACOG. And can you explain to me your reliance on ACOG for some things, and then other times you don't rely on it? Can you explain that?
Yeah, I can see that it's confusing. And it's important for the outside observer to recognize that the ACOG has 2 components. ACOG has never surveyed their membership. I've been a member for 25 years, but I'm told it was prior to Roe the last time they surveyed their members on our feelings about abortion. So the leadership has an ideologic desire to promote widespread abortion for social reasons. And they do this through—
What do you mean social reasons?
Well, not medical reasons. So there's not medical data to document why they feel that these abortions are needed. But in the 1960s and the 1970s, prior to Roe, the leadership of ACOG overlapped with the leadership of the American Eugenics Society for a number of years. So there were reasons outside of medicine that they chose this stance, and they put forward policy statements frequently about things with which they have no medical expertise. For example, there are policy statements on climate change. There are policy statements on housing insecurity, important issues, but not issues in which ACOG necessarily has expertise. So that's when we see the advocacy that comes from their leadership, and actually without any input from the OB-GYNs. It is interesting.
You say that, how do you become a leader of ACOG? Don't the members vote for them? And presumably the leaders from the 1960s who you allege were aligned with the eugenics movement aren't the leaders anymore, or
that's true.
Or they'd be gone.
That is true. And I don't know why they persist in the ideology, but they certainly do. That's very well documented. And I think I put some of this in my report.
But how did you get to be, if I wanted to be the president of ACOG, how would I become the president?
It is an election process.
So the members select.
the members select. And it may be that many members don't have a problem with the abortion advocacy, but I would like to.
Isn't it sort of like a poll? It's not a poll where you get to express views on specific issues like climate control, but the majority has elected a leadership that presumably reflects the perspective of the majority of the professional members of ACOG. Unless like you get 5 votes if you live in California and only 1 vote if you live in Georgia.
I'm afraid it's not as easy as that because most of us in the trenches are very, very busy. We don't have time to run for ACOG leadership. It tends to have a bit more of a progressive leadership out of academic institutions. And believe me, I've tried to have conversations with the leadership about this, but have not really received much response. But the question goes back to, why do I trust ACOG's advice in other circumstances? And that's because the other part of ACOG uses evidence-based medicine. They use peer-reviewed literature searches to create what I feel is very good clinical guidance. So on the one hand, they're telling everybody we represent 60,000 doctors and we promote abortion. But on the other hand, surveys have asked private OB-GYNs, if your patient asks you for an abortion, would you perform it? And only 7 to 14% of the OB-GYNs working, as I have been in the field, will perform an abortion if requested by their patient. So there's a disconnect. There's a leadership promoting it. On the other hand, the people who are doing the work, caring for women and their babies, 90% of us do not perform elective abortions.
Okay, I thought you said they didn't do surveys and you just told me about one, but I'm gonna let you, Mr. Field, take over again.
That was not ACOG. ACOG actually has not asked us for our response, but these were surveys outside of ACOG.
Okay.
So assuming, let's talk about that data point you just mentioned, 7 to 14% of OBGYNs will perform an abortion. But we heard yesterday some testimony from Dr. Swiak that she felt that the Life Act would cause a reduction in training opportunities for OBGYNs in Georgia. Do you recall hearing that?
I recall her saying that, yes.
So considering how few OBGYNs perform abortions, do you agree with that statement?
I don't think that's correct.
And why not?
Because again, most obstetricians do not have any desire to perform abortions. So it's not going to bother them necessarily if they go to a state where that is restricted. Obstetrics is a very competitive specialty. And so there will still be plenty of very good quality medical students willing to come to Emory and to Georgia to do residency training. The complex family planning fellowship, however, its primary purpose as a 2-year training is to train on D&E abortions. So they probably will not be able to continue with that 1 fellow a year.
And now let's discuss briefly some of the risks associated with abortions. I'd like to begin with medical abortions. Could you describe the procedure briefly and then discuss the risks that are associated with those procedures?
Sure. The FDA has approved mifepristone, which blocks progesterone receptors, cutting off the hormonal support and causing embryonic death. This is followed in 24 to 48 hours by misoprostol that induces contractions to expel the pregnancy tissue. This is approved up to 10 weeks in our country.
And what kind of complications have you seen from those abortions?
The most common complication is the inability or the failure to expel all of the pregnancy tissue. And when this happens, women often bleed a lot. They may get infected from the dead tissue, and they generally will require a surgical procedure, an aspiration procedure to remove the tissue. And again, when we look at records linkage studies, we find that occurs between 3 and 8% of the time. Approximately 1 out of 20 women will need surgery to complete her medical abortion.
And you've had to treat those complications in the ER, correct?
I've cared for them many times. Many times they do not go back to the abortionist. They're frightened and they come to the emergency room where I've cared for them.
And now let's talk about surgical abortions. Can you describe the process briefly and the risks associated therewith?
Sure. In the first trimester, it's a dilation and suction aspiration procedure. D&C is the sort of the generic name for it. Beyond about 13 weeks, the fetal bones have hardened. They're calcified. And so he cannot easily be removed with suction. So then it becomes a dilation and evacuation, or a D&E. The layman's term is dismemberment abortion, and that really does accurately describe what happens. The baby is pulled apart limb by limb, and then until all the tissue is removed.
And what risks are present for that procedure?
Well, that's a much more risky procedure. And I think that's part of the reason that complex family planning exists as a fellowship, because doctors need a lot of training in that. You have to dilate a cervix that it was not going to dilate. This is a healthy cervix. You can cause damage to the cervix. You can cause false passages in the cervix. It's a blind procedure with large instruments, and reaching in blindly to pull out parts can result in perforation of the uterus, which can damage surrounding organs. And also tissue can be left behind, which can lead to future infertility or other problems.
And
when you say it's a blind procedure, it's very graphic. I mean, the imagery is clear,
Yeah.
But there's not, I think of all the devices that doctors use to say, hey, you've got a tumor right here, or this bone is broken.
Mm-hmm.
There's not equipment used during the course of a surgical procedure that gives the medical professional visibility into the uterus, other than physical, which you
No,
couldn't see.
that's a good question. It can be used with ultrasound, and I believe in training, and many doctors will use it to determine that they're not going through the uterus, or that they've removed all the tissue, but it's not always used that way.
Okay. For this topic, based on your understanding of the data and your experience, is an abortion safer or riskier than pregnancy?
I believe, based on my analysis of the data, that an abortion is more risky to a woman than carrying a child to term. And I also, it's frequently used as an excuse, maternal mortality. We need abortion to lower our maternal mortality rate. And I would say that's analogous to saying we need to take away everyone's cars to lower deaths from auto accidents. That's not how it works. We can lower maternal mortality in many different ways by addressing the direct causes, not by promoting more abortions.
Let's talk about miscarriage care specifically a bit. What is your understanding of how the Life Act addresses care that an OBGYN may provide for miscarriage?
The Life Act specifically says that there's an exemption to remove a dead unborn child. So very briefly, abortion is a generic, or is a general medical term describing a pregnancy that is lost in the first half of pregnancy. A spontaneous abortion is when the fetus has died. We've talked about induced abortion, of course. I think the plaintiffs mentioned a couple other scenarios. We can have what's called a threatened abortion, and that's where a woman presents with symptoms as if she could be experiencing a miscarriage, such as bleeding or cramping. In those cases, if the baby still has a heartbeat, we don't know that she's going to lose it. Many times in my experience, you put them to bed rest, you give some time, and the bleeding resolves, the pregnancy continues, and many live children are born after that event. So it would be inappropriate to offer an abortion at that point. Remember, most of these women want their babies until we know for sure which direction things are going. There is another situation that's called an inevitable abortion. And I believe this is part of the plaintiff's concerns, that sometimes we can tell the loss is going to occur. That's the situation with the premature, preterm rupture of membranes. Essentially, the labor is already starting. That's why the water bag has broken. Another scenario might be the placenta is separating, what we call a placental abruption. Sometimes women come in preterm labor and there's fetal parts delivering. Those are all scenarios where we know that baby is not going to make it, even if he is still currently alive. But we also know that if we do not intervene, that the risk to the woman is quite high. Infection leading to sepsis, hemorrhage, things like that. And it is clear to me that the Life Act allows intervention in that scenario. One thing I want to clear up from what was stated earlier, the word immediate is not in the Life Act. So a doctor can use his reasonable medical judgment and know this lady has a preterm rupture of membranes at 18 weeks. This baby cannot make it to 22 weeks to live. The baby's going to die. If I wait, the mother may have a serious complication, possibly leading to death. We can't know for sure if she will or won't die, but we do have the ability to make the intervention at that time. The ACOG guidance that I put in my report does tell us that it is appropriate to offer an abortion or an induction at that point. And this can be done. So we don't have to wait till a woman is getting ready to die before we intervene. We know, because we're doctors and we're clinically skilled, we know what situations are likely to lead to serious problems.
And I'd like to talk about that just very briefly. The reasonable medical judgment, I believe, was the term you used, right?
Mhm.
Which is, I believe, also in the Life Act. Can you discuss very briefly, just as a general matter, when you treat patients, how you apply your medical judgment?
Yeah, I mean, obstetrics is a field where there is always risk for the obstetrician. I mean, it is this field with the highest medical malpractice liability. So it is part of our job to recognize we may make a decision and someone may second guess that decision. So that has always been the case. I understand the word felony is scary. I get that. But there is nothing that this law is telling doctors to do or not do that we haven't always done. We've always intervened when we needed to save a woman's life. And we document that. We make that decision. We look at ACOG's guidance. We talk to our peers and get, sort of a curbside consult from them. Hey, what would you do here? We have clinical, we train a 4-year residency. And then in addition, I've had 25 additional years. So we have experience to know when things are going to go bad. And so we can intervene in those situations.
And even before, you practice in Texas, right?
Yes.
So even before the current Texas law, before the current Georgia law, the Life Act, has there been anything at the federal level, for instance, that has, had OBGYNs making these types of determinations?
Yeah, actually, it's interesting. The Hyde Amendment, which a lot of people are probably familiar with, that prohibits federal funding for abortion, does allow and will pay for the medical care for a woman who needs an abortion to save her life. That's always been part of that law since 1970s. So the reality is we've been following that standard since the 70s.
No other questions, Your Honor.
Oh, sure. Thank you. Okay.
It's thick.
We're gonna go page by page. Okay. So I guess we're into, almost good afternoon territory.
Good afternoon.
Dr. Scopp, I'm Tiana Mickelvet. I'm a lawyer at the firm of Bondurant, Nixon, and Elmore here in Atlanta. You told us this morning that you've been an OBGYN for about 25 years. Is that correct?
Yes, ma'am.
But you're not licensed to practice medicine in Georgia.
That's correct.
And you've never been licensed in Georgia, correct?
No, I have never.
And I didn't miss it on your CV. You're not a lawyer here in Georgia.
That is correct.
But you're here today to offer your expert testimony about how Georgia women are affected by a Georgia law that is applied to Georgia doctors, correct?
That is correct. It's a very, very similar law to what we have in Texas.
And you've already admitted that you've never performed an abortion, correct?
That is correct, as have 90% of OB-GYNs.
And did I hear you say earlier that you had performed all of the procedures, abortion procedures in all 3 trimesters?
No, that might have been a misinterpretation. I have performed every procedure that can be done. I suppose if you're asking, because a 3rd trimester abortion is generally done by labor induction. And of course, I've done many of those. So yes, I guess in retrospect, that's correct.
So if we took a look at a deposition that you gave in Utah in 2020, Ms. Anderson, can we see page 51 at lines 7 through 9? And the question you were asked in that deposition was, what about D&Es after 18 weeks of pregnancy? Have you ever performed one of those? And your answer was, I have never performed one that late. Did I read that correctly?
Yes, I think you asked me, have I performed the procedures? And the answer is, of course, yes. I didn't say that I performed every procedure at every gestational age.
Thank you for that clarification. And so it would be correct that you have not performed a D&E after 18 weeks of pregnancy.
That is correct.
And so it would be incorrect to say that you had done every procedure in every trimester, correct?
Yes, I didn't mean to acknowledge that I had done that.
And I believe you testified you'd done them many times,
I'm
done
sorry.
the D&E procedure many times.
I've done many D&Es, not as many as an abortionist, of course, but
And you testified that you performed D&Es about one per year over your 25 career, or about 25 times. Do you recall that in your Utah deposition?
that sounds about right.
Okay. Do you recall testifying in a case in Florida earlier this year?
Yes, I do.
Okay. And in Florida, you were asked how many D&Es you performed. And Ms. Anderson, if we can take a look at the Florida deposition, it's Scott 1 at page 60. Those are my words for Ms. Anderson. And it's page 57 of the deposition transcript, lines 3 through 12. And in that testimony, you said you performed about 5 D&E procedures. Is that correct?
That looks like that's what I said, yeah.
And so, Dr. Scopp, is it fair to say you've performed so few of these procedures, it's really hard for you to remember how many you performed?
Well, clearly I did give a range there. So yeah, I mean, the answer is infrequent. It's not that often that you lose a pregnancy in the second trimester and need to do a D&E.
And although you've only performed 5 or 25, we're not sure, of these procedures, you consider yourself an expert in abortion safety, right?
I am certainly capable of reading the literature, and I have enough knowledge of a woman's anatomy and just of pregnancy that I do have a great deal of respect for the D&E procedure, because I think it is very dangerous, and I think that is well documented.
And you just mentioned you have the ability to read the literature, correct? But you're not an epidemiologist, correct?
That wouldn't be applicable here, I don't think. They wouldn't
The
really,
study of public health.
they wouldn't understand the procedure, having not done it, I don't think.
But your expertise is based on your experience, but you're not and you just told me you read the literature, so you've studied.
That's correct.
Okay. But you're not an epidemiologist, someone who would study public health and the effect.
That's true.
Okay. And you've said previously that you're not anywhere close to an epidemiologist, correct?
That's correct.
And you haven't held any academic university or faculty positions, is that correct?
No, but I went to an amazing medical school, Washington University, that is very, very academic. And I learned at that time how to critically read the literature, and I've been doing it for 30 years now.
And isn't it true, Dr. Scopp, in your Utah deposition, you even previously admitted with regard to your own research, you're just not a good researcher?
I don't know if I said that or not, but
okay, well, let's take a look. It's Scott 2 at 32.
You're in good company if you said that. I'm not a good researcher either. It's not a crime, but
you know,
it may be relevant here.
I bet I said it in relationship to my footnotes, and I definitely could use a legal assistant.
And it's the deposition page 121 at 25 through 122 at 7. It's the deposition page 121, 25. And we'll start with this page in the bottom right corner, Ms. Anderson. There we go. We can, all right, so that bottom right corner of 121. All right, this is a mini. Could you add that question too, please? And your testimony was the question, I'm just trying to understand your process of drafting the report, Dr. Scott. So you're not familiar, you said, with who compiles the numbers on a website you cited, Abort 73, is that correct? And you said, correct. And then on the next page, oh, sorry, it was further up.
It's at the top of 121.
Correct. Sorry about that. It's 3 through 7. So when you didn't find a source, the question was, did you look for it? And you said, yes, but I'm not a really good researcher. So it is possible that it was easy to find and I just didn't find it. Did I read that correctly?
That is what I said. And I would point out that currently I'm working on research full time. So I think I'm a little better now.
Got it.
I was practicing full-time OB-GYN at that time, which is about.
I understand the ball juggling game. You're not an expert on mental health, are you, Dr. Scott?
I am not certified in mental health. I'm actually married to a psychiatrist, and I have, in 30 years of caring for patients, I've cared for many, many women who've had mental health concerns and complications.
And in your Utah deposition, would it be fair to say that when asked if you were an expert in mental health, you agreed, I wouldn't say I'm an expert, but I'm married to a psychiatrist.
I guess I still have the same answer.
And you're not an expert in neonatology, is that correct?
Of course not. That's a pediatrician.
In your affidavit in this case and in your testimony today, you've testified that abortion is far more dangerous for women than pregnancy, correct?
Based on very reliable records linkage studies.
That's the Scandinavian.
Yeah.
We'll get to those.
Okay.
And that's because your argument is that anyone who says that abortion is safer than pregnancy is relying on conjecture by researchers associated with the abortion industry. Is that correct?
I was referring specifically to the Raymond and Grimes study when I said that, which, by the way, even though the Scandinavian data was available in 2012 when he wrote that study, he did not reference it at all. So he totally ignored it.
And that's because you have described Dr. Grimes as a vocal abortion advocate because he was chief of the CDC abortion surveillance branch. Is that correct?
Well, what I was saying is that because he was chief, he should have known how poor the data was. The director of the CDC at that time did release a statement saying that these two numbers were conceptually different and were used by the CDC for different public health purposes. So he should have known that this really was an apples to oranges comparison with incomplete data. The vocal abortion advocacy, I think if anybody Googles him, they can discover that that is the case.
And that was based on your internet research. I was going to ask you that.
I'm getting better.
All right. And the truth is, Dr. Scott, you believe anyone is biased when it comes to abortion research. Is that correct?
No, I wouldn't say that. But I think what happens in the United States when a study is, and of course it makes sense that it's primarily abortionists who are doing the research because they're involved, but almost uniformly, they ignore the fact that the data is flawed because we do not have mandatory complication reporting. So when they report complications and put out studies that say that there's few complications, like for example, with medical abortion, they report 1% to 2% complications. They can do that because they're only reporting the complications they know of who came back to their clinic. They don't know about the lady who came to me in the emergency room.
I understand.
And they don't acknowledge that when they.
So I'm clear on my question, Dr. Scott. Was that a yes? Researchers are biased or no?
When they don't acknowledge the flaws in the data, I think that demonstrates their bias.
And you believe that those researchers are intentionally trying to make abortion seem safer than it is. Is that fair to say?
By ignoring the flaws in the data and painting a rosier picture than is actually true, I think that they are.
And that includes researchers from the Centers for Disease Control and Prevention, headquartered here in Atlanta. Isn't that right?
The CDC analyzes the abortion complication and maternal mortality data that comes to their attention. I'm not sure that they as vigorously search for it as they should. I'm not going to say what their motives are for that.
And so you have testified, I believe, in your affidavit and here today that the CDC data is incomplete because it relies on death certificate information. Is that correct?
I believe I did say that, yes.
And Dr. Scott, isn't it true that the CDC data is not based only on death certificates, but it includes a number of other sources of information?
They do say that they do nexus searches, look at media. They do list a few other ways that they say they look for data. Conspicuously absent, I think, in that is that they don't look at medical malpractice data.
Well, let's take a look at that. We've got Defendants Exhibit 508, which I believe you cited. On the second page, it is the sentence beginning additional methods at the end of the first paragraph, if we could take a look at that. In fact, you've acknowledged that additional methods used to identify other potential abortion-related deaths include media reports, such as computerized searches of LexisNexis and reports by public health agencies, state-based maternal mortality review committees, professional organizations, healthcare providers, and individuals. Did I read that correctly?
You did.
And I believe I just heard you say that you believe medical malpractice information is missing. Is that correct?
I think there's other ways they could look for this data if they really wanted to find it.
Dr. Scott, are you aware that LexisNexis is a research database that includes things such as medical malpractice actions and other lawsuits?
No, I was not aware of that.
And your other complaint about the CDC data is that it's not reliable. And are you aware that CDC epidemiologists conduct extensive research and review of the records they receive to determine if abortion is a cause of death?
Right. I'm very aware that they take the death certificates and they determine if they are pregnancy related as due to the outcome of the pregnancy versus pregnancy associated. But my argument is they're only taking the ones that they've identified, and it has been well documented, even within the United States, by independent researchers that they do not identify all the deaths.
And you have previously testified, Dr. Scott, you're saying they don't identify anything. Let's take a look at your Florida deposition at page 196, line 23 through 197, line 4. That's page 199 of the PDF. And the question you're asked is, do you think the CDC epidemiologists are suppressing any of the data that would show a higher rate of abortion-related mortality? And your answer is no. Is that correct, Dr. Scott?
That's right. It does say, I think everybody can read it, that what I said is I don't think they suppress the data that comes to their attention, but I still stand by my statement that I don't think they work very hard to find additional deaths, primarily mental health deaths.
And a few weeks after your Florida deposition, you drafted and submitted your expert affidavit in this case, where you've made the exact same criticism of the CDC data, but you omitted any mention of the language we just reviewed. Isn't that correct?
I'm sorry, what language are you discussing?
The language from the report that shows that the information is gathered by additional means, and the information shows that 2 CDC trained epidemiologists examined the linkage between any abortion and any related death. Is that correct?
I guess if it's in my report, I don't recall specifically, but if it's modified, then I think that's probably true.
I think my point is it wasn't in your report, correct?
I guess that's the case.
And Dr. Scott, would you agree that doctors should not spread medical misinformation?
Absolutely.
Of course you do.
the American board is threatening doctors with removal of their board certification for misinformation, but they've somehow defined that as anything outside of the standard ACOG recommendations about abortion.
And it's been suggested that you have been engaged in medical misinformation. Is that correct?
Well, certainly people can throw sticks and stones, but I think everything I've done is well researched, and I will stand by my statements.
And do you recall testifying before the House Committee on Oversight and Reform on the need to protect and expand abortion rights and access?
Yes, I do recall that.
And you testified that the U.S. has poor data on poor data on deaths related to abortion. I think we just looked at it, and you made the same criticism of the CDC data that you did here today. And let's take a look at that transcript at PDF page 34, if we can, please. And there are no line numbers, so we are going to be at the kind of bottom right where it says, but the CDC, that part of the paragraph, please, Ms. Anderson. And you're making essentially the same argument that you've made to this court and in your affidavits here. Is that fair?
Yes, I think my statements have been consistent.
And if we look at the next page, it's page, actually, it says PDF page 34.
I'm curious before we move on, what I thought I understood, and I understand this very weakly, but you're helping. You were impressed, Dr. Scott, with the Scandinavian study because it was record related. They looked to death certificates.
They look to death certificates. They know every abortion because they pay for abortions there. They have single payer healthcare, so they know every complication. Because here most of them are paid privately, right? So we don't have any way to find out. And so they were able to consistently know of all the deaths, which ones had a preceding abortion and what complications occurred in the middle. So they're able to cast a much wider net to document deaths than we do by merely analyzing the ones that happen to come to our attention when and the differences are quite astounding. Of course, we have Raymond and Grimes saying 14 times safer here. Over there, we have 2 to 4 times more dangerous. So there must be, I mean,
I understood that part, but I thought one of the things you were praising the Scandinavian work for was that it was linked to death certificates.
That's what makes it thorough. Yeah.
So isn't your testimony, though, in response to Congressman Heiss's question, that the CDC actually uses death certificates? So I'm wondering what's
very good question. So the Scandinavian countries look at all reproductive age women. So they are looking at, so again, the CDC has the deaths that say there was an abortion.
Okay.
Which is less than what
it's going to be underreported.
Over here, they're looking at every woman who could have possibly been pregnant, pulling those death certificates, and then going back to find out if there was a pregnancy, which is a much more reliable way to determine pregnancy associated deaths.
Thank you.
And I'll just return your attention, Dr. Scott, to the hearing. And at that hearing, another doctor, Dr. Moyetti, raised the question about your discussion of that data as potential medical misinformation. Isn't that correct?
Yes, this is a very good example of how politicized this issue is. At that time, ABOG had said misinformation about COVID, but this was an abortion provider from Dallas who was, and also this was a Congressman, Connolly, that were trying to intimidate me by threatening me at the U.S. House Oversight Committee with removal of my board certification for voicing an opinion outside of the mainstream, which of course is how.
Dr. Scott, you're not here to give your opinion, are you?
So hold on one second. I sort of let it slide. Ms. Mikkelveld, you need to make sure that Dr. Scott has finished her answer, and then you're free to dissect it in any way you want. But she was here mid-sentence. You guys have talked over each other a little bit, but finish your answer, and then there may be some follow-up.
My expert opinion. based on my clinical practice of almost 30 years and my review of the literature.
Right. So you're here to provide your opinion based on your experience and your research, and not to give your political opinion about the issues. Is that
Absolutely,
correct?
not like this doctor did in the hearing.
I see. And I want to go back to the Finnish data. I rarely have an opportunity.
Finnish as in Finland.
Finland, to
Okay.
talk about Finland, yes. You're not suggesting that Finland's healthcare system is anything like or directly comparable to the healthcare system here in Georgia, are you?
That might be a political opinion. No, I'm not suggesting that. I'm just saying they have a better ability to detect complications is the only point I'm making.
And you understand that as compared to the CDC data that we've talked about, the CDC gathers information on all deaths within a year of a pregnancy or abortion, but then it does a second step and it analyzes whether the death was actually caused by the pregnancy or abortion.
That is correct.
And we just looked at that language
Mhm.
in the report. But you understand that the Finnish studies simply measure all the deaths 1 year after a pregnancy or abortion without conducting any analysis whatsoever to determine whether there was a causal relationship between the abortion or pregnancy and the death, correct?
That is correct. They're detecting pregnancy associated, and what the CDC finally determines after review of the records is pregnancy related. But my argument is cast a broad net, investigate, and you're going to cut some of them out, but you're going to find out what the true number is. Whereas if you don't cast a broad net and have incomplete data to analyze, you're not going to find everything. And particularly regarding mental health, it's not clear to me that the MMRCs, the maternal mortality review committees, have a real standard way that they determine, like you mentioned, Judge, an auto accident occurs. Could it have been, because she blacked out from anemia from her childbirth? We don't know. And until we get serious about really looking at mental health, because of course we're all concerned about mental health, we have a crisis in our country, we are not, until we know how great the problem is, we're not going to know what steps to take to resolve it.
And I think you said this in your example, in the Finnish study, if a woman had an abortion, a few weeks later, gets in a car wreck, that would count as an abortion-associated death. And there would be no analysis to determine whether it led to or her death, the abortion led to.
That is correct. But I think what's very important in light of the mental health discussion we had yesterday afternoon, if 6 times as many women die of suicide after abortion, that's a signal that we should take seriously. We don't know yet whether they were related, but we certainly can't say there was no relationship until we've investigated them.
Well, the CDC does investigate, correct?
When it comes to their attention.
And you acknowledge this distinction between the CDC data and the Finnish study in your deposition in 2020, is that correct?
That's true.
Okay. And in your Florida deposition earlier this year in June, you agreed that the Finnish studies are intentionally over-inclusive, correct?
Yes.
And again, you submitted 2 affidavits in this court where you relied on those data and those studies, and you omitted any clarification of that point.
I assume, I don't recall specifically intending to do that, but if you've reviewed it and if you say I did, I don't know what the reason was. I probably just to shorten the report. Honestly, it got long.
Your Honor, we're going to keep asking for a report. I just asked if she be provided a report.
It's the first one.
Okay.
Sure.
Record where your questions are.
Also going back to the death certificates that the CDC has, if a woman is distressed by an abortion and has and commits suicide 6 months later, there is almost no way that information is going to make it to the death certificate. Right. So those are going to be the ones that we're not going to detect.
Okay, I feel like I understand pretty well some of the disagreement between the two sides on how the Finns were doing it and how CDC has done it.
Okay.
And I guess my question for you, Dr. Scopp, is when you're aware of these distinctions, why did you omit any discussion of them in your subsequent affidavits?
I don't recall it being intentional. I think it might have just been in the interest of shortening the report.
Dr. Scott, you don't make any bones about being a pro-life advocate, correct?
No, but it doesn't, I consider the fetus, I know the fetus is a living human being. That is scientific. I consider him to be my second patient, so I do advocate for him. But again, everything that I've said in these reports, I've got documentation for. So this is a scientific report.
And in fact, you don't believe there are ever any compelling medical reasons that women need abortions. Isn't that correct?
I'm glad you asked that, because there has been a lot of confusion here today about some of these life-threatening situations that are a little bit unclear. And I will say that there are times that women need separation from their baby, and they're due to life-threatening conditions that we've discussed. And in those times, again, the Life Act in Georgia leaves it up to the doctor to make that decision. So if the doctor wants to do a D&E, they can do it. If they want to induce the labor, they can do it. Many times, depending on the gestational age, we know regrettably the infant will die. So depending on definitions, for me, I don't consider that an induced abortion, because the legal definition is with the intent of ending fetal life. In that scenario, I know based on my clinical experience, his life will end, but my intent was to save his mother. My intent was not to end his life, even though it happened. So we can split hairs. I mean, you could call that an abortion, and I think that's fine. And in that situation, I would say that abortions are sometimes necessary to end or to protect a mother's life.
Before you go on, can we take down, since we're not using the exhibit anymore? And Mr. Field, if you're going to object, you need to make sure the microphone, currently the microphone is pointed away. And if I respect the need to have confidential communications, you can always turn that light from green to red. But the court reporter didn't get your objection, so she knows from the record you were objecting. Didn't really end up, what you wanted to make sure that the witness had the document about which she was being questioned in front of her. Very reasonable request. Turns out she did have it, just wasn't brought to her attention. But bringing to everyone's attention, talking to the microphone if you want the court reporter to get it. All right, back to you.
Dr. Scott, you're currently employed by the Charlotte Lozier Institute, correct?
That is correct.
And the Charlotte Lozier Institute is a pro-life organization, correct?
They are a research institute, but they are affiliated with Susan B. Anthony Pro-Life America.
Are you being compensated for your testimony here today?
I am not being paid anything by the state of Georgia.
And is that because it's part of your job at the Charlotte Lozier Institute to provide this kind of pro-life expert testimony in legal matters, correct?
Our mission is accurate science and statistics surrounding abortion. And within that context, I'm here as representing my job.
It is literally your job to provide pro-life testimony wherever your employer dispatches you. Is that correct?
No, I mean, I accept where I want to go. But this is within the mission of my job.
You had described, I think you call it the Guttmacher Institute as a pro-abortion. Would the Lozier Institute be the pro-life counterpart to Guttmacher? Or how would they line up in terms of their focus and the work they do?
I think you can make that analogy. The Guttmacher Institute was initially started by Planned Parenthood. They're independent now, but they are quite clear on their website that their purpose is to promote widespread abortion access.
If I went to, and I won't, but if I went to the Lozier Institute's website, would its purpose be similarly clear, but maybe trending in a different direction?
I think that might be the case.
Okay.
And I believe you said you could choose where you go, but so far your work has taken you to Florida. Is that correct?
That's correct.
And Ohio.
I did some written reports for Ohio.
And to Kentucky.
That was a Zoom presentation, or
Texas,
yes,
South Carolina,
written.
Montana,
Yes.
Utah,
Mhm.
Georgia, obviously, Vermont.
Written, yeah.
And is it fair to say all of those were in favor of all of your testimony, written, oral, Zoom, was all in favor of abortion restrictions, correct?
My research has led me to believe, and my clinical experience has led me to believe, that abortion restrictions are in the best interest of women. And that's why I do the work I do.
And you're also a member of the American Association of Pro-Life Obstetricians and Gynecologists, correct?
That is correct.
Is that APLOG or APLOG?
APLOG, yeah.
Okay. Also a pro-life advocacy organization, correct?
That is correct.
Okay. And you've agreed that that APLOG is biased on the issue of abortion, correct?
Well, they also consider the fetus to be their second patient. And they also do review the peer-reviewed literature to put out statements. But yes, they generally do come down on a pro-life perspective.
Dr. Scott, can you think of any organization that isn't pro-life whose data you believe is reliable?
I mean, there's many journals that I refer to. But if you're asking, because I think we all recognize that this issue is so politicized that I don't know of an organization that weighs in on the question that does not have a bias. I don't think that exists.
Because you believe the CDC data is biased?
As we discussed, I think the CDC data is incomplete. And I think that many times when, as in the Raymond and Grimes, when a paper is published using that data, I would have liked to have seen the CDC object, knowing that that data was incomplete, but they didn't. But I don't really have a perspective on how the leadership of the CDC feels about this.
And you believe that the American College of Obstetrics and Gynecologists, or ACOG, the largest professional organization of OBGYNs in the country, at least as to abortion, you believe that their data research analysis is biased, correct?
No, I believe that ACOG, when it's not related to abortion and when they have experts in the field review the peer-reviewed literature, I believe they make very good recommendations. I think it's only, again, these issues that are so politicized, as I mentioned a couple of examples earlier, in which ACOG has a bias, but that is purely driven by the leadership because they do not ask us how we feel about their advocacy. But I have remained a member of ACOG for 25 years because I think that their committee opinions, their practice bulletins are useful.
And you also reject data and information from the American Medical Association, which you have also described as an abortion advocacy organization, correct?
Well, I think if we review what's happened in light of Dobbs, the AMA has joined several amicus briefs promoting abortion. But I do want to make the point that dissent and disagreement in medicine and science are healthy. So I am not the only person that has the views that I do. And I mean, we think back, to the time of Copernicus and Galileo. I mean, science stagnates if there aren't people asking questions. Dr. Semmelweis was an early obstetrician who discovered that hand washing was important. Seems so common sense. But at the time, he was ostracized from his community and in fact died impoverished and rejected. So I'm not making the analogy that, I'm a Dr. Semmelweis, but I'm just saying that just because a medical organization takes a viewpoint, and I think if we look at all of those websites, we will not only see statements in favor of abortion, but we will see statements in favor of abortion as a social good. Like, again, areas in which they don't have the expertise to tell us what's good socially, and yet they will still make the statements because of that predetermined viewpoint. But it doesn't, because I disagree with them on some areas, does not automatically make them right because they're bigger and me wrong because I'm smaller. And like I say, I am a member of ACOG and they've never asked me. And so they don't represent many of their doctors.
You have also testified that the American Psychological Association and the National Academies of Sciences, Engineering, and Medicine are biased abortion advocacy organizations, haven't you?
I have made that statement. I would remind you, the APA at one point embraced eugenics. They used to embrace phrenology, where they would measure people's heads and look at their race to determine what their IQ would be. So they were wrong then. These organizations do get it wrong. The AMA for 20 or 30 years allowed cigarette advertising in its journal. So they were wrong then as well. So again, research can tell us that maybe we should change our ways. If more research comes out and it doesn't back me up, well, we've solidified the idea. But if it does back me up and we change the way we do things, then that will be for the benefit of patients. I know we're going to discuss mental health, and I'm certainly not an expert there, but you've already heard how the mental health literature is very, very, very difficult to interpret. So if we cared about women, our response would be more studies, better studies, not we can make a determination based on the flawed studies we have.
And you understand that ACOG issued a statement on behalf of 75 healthcare organizations, all opposing legislative interference into medical decisions like HB 41. And are all of those organizations, because they oppose abortion restrictions, also abortion advocacy organizations in your view?
Well, I don't know. I can't speak for all of those organizations. I am familiar with that statement, but I will tell you that, I don't know.
Let's take a look at Plaintiff's Exhibit 16, please. Are you aware that the Medical Association of Georgia opposes HB 41?
I wasn't aware till just now, but it doesn't surprise me because, again, mainstream medicine seems to have embraced abortion on demand.
And if we look at the last paragraph, it says, considering the above policy positions, MAG opposes HB 41. Specifically, MAG opposes this bill because it would criminalize physicians practicing within their standard of care, creates a new civil cause of action against physicians, could undermine efforts to recruit and retain OBGYN in Georgia, and could further restrict access to healthcare in rural Georgia. And did I understand your testimony correctly, Dr. Scott, that you believe that this is an example of mainstream medicine requiring abortion on demand?
No, I hadn't had a chance to read this yet, but actually what I would tell you that I think they're saying here is they have misinterpreted the law. And I do have good news for people who are concerned about women in Georgia. Texas, of course, we've had our law similar to yours in place since September of 2021. And what has happened, doctors were initially confused, but then they don't want to be alone. They don't want to be facing a felony without anybody supporting them. So what's happening is that the hospital systems have come alongside and they've provided the doctors guidance. Many times it's a checklist, like if you need to end a pregnancy, here's the steps you should take. They're not telling the doctors specifically what events to intervene on. That's up to ACOG. And ACOG, you'll see in my report, has given a lot of good advice on when these separations need to occur. But what the doctors need is they need to know that somebody has their back. And now as these hospital systems are telling the doctors, we have your back, here's what you need to do. And many times it does involve a second opinion. If it's a cardiac problem, a renal problem, let's get a nephrologist, let's get a cardiologist. And as that has happened, the doctors have become comfortable. They're providing better care in Texas. And I have no doubt that this will happen in Georgia as well. So, it's good news for the Medical Association of Georgia that their concerns are not going to be realized because doctors know how to practice medicine. We have the guidance, we have the skills. And once we just have the comfort that somebody has our back and that we're not going to be left alone facing some sort of litigation, I think the doctors are going to provide good care in Georgia.
Dr. Scott, Isn't it true that following your testimony before a Florida court in an abortion case, that judge found your testimony to be lacking in credibility?
Yes, that is true, because he said that I disagreed with the mainstream medical organizations. But as I've explained today, disagreement does not necessarily a priori make my testimony invalid or incorrect.
And let's take a look at that.
What are we looking at?
The Florida court order.
Is it an exhibit number?
It is not yet an exhibit number. I believe it's attached to our reply, but Ms. Anderson can pull it up. Would you like the whole order is in front of you if you'd like to look at it.
Scott
Yes.
4.
And I believe it's page 34. Let's look at paragraph 68. And Dr. Scott, isn't it true that the judge did not just note that you were out of line with mainstream medical organizations? He also noted your lack of experience in performing abortions, your admissions that testimony on risks of certain complications was inaccurate, overstated, or based on data from decades ago, and that you provided no credible scientific basis for your disagreement with recognized high-level medical organizations in the United States. Is that correct?
That is what he wrote, yes.
And your testimony and the affidavits in this case suffer from the same deficiencies, do they not?
Well, as I mentioned earlier, 90% of OBGYNs do not perform elective abortions. So if we're only going to let doctors who do abortions testify on this issue, we will have severely limited the pool of physicians talking about it. And in addition, that will be all one side. So I believe that the testimony that I put forward, and I've added some new references for you guys, and I can talk about them if you want, but I know we're on a time crunch regarding complications of D&Es, because I did take that, realize that some of the studies that I had put were a little bit older. But again, if we're going to say that only abortionists can talk about abortion, that's like saying only women can talk about it. I mean, good knowledge can come, only female judges can rule on it. I mean, that's not the case. We can get good knowledge even from people who don't necessarily perform that procedure. Like I say, I've seen it. I've cared for the complications. I've done every one of the procedures that can be used for an abortion many times in my career. I've kept D&E fewer times, but I am very familiar as an obstetrician of 30 years with how this is done and the complications that can arise. And I think that I have expertise that is valuable for this court today.
And I do see that you did add some information on your supplemental affidavit. And believe that is in toward the end at paragraph. Ms. Anderson, I have page 29 as the PDF page. At paragraph 102 of your affidavit, you note that your opinion is not solitary or monolithic, as you just said, and you identified several additional organizations in support of that position. Is that fair?
Yes, ma'am.
And that includes the American Association of Physicians and Surgeons, correct?
That's correct.
And are you aware that very official sounding name, but that this is the organization that in 2008 published an article accusing President Barack Obama of hypnotizing listeners with his speeches?
So I'm not aware, and I don't have a
Let's look at Scott 9 on the first page, please.
Judge,
Yes.
the witness keeps leaning back, and so the mic is not picking her up.
Okay. I wasn't sure if you were referring to the lawyer or the witness in your comment, but thank you. And I'll emphasize that. I want folks to be comfortable, but I also want folks to be near the microphone. So if you lean back, don't talk while you're doing it.
Okay, thank you.
You're welcome.
And my question, Dr. Scott, was this is the organization you cited as some of the non-mainstream organizations who share your view, correct?
They share my view on abortion. I don't necessarily have a reason to feel that I share their view or they share my view on everything.
Like conversational hypnosis?
That's all I have, Your Honor.
Okay. Don't go anywhere. Mr. Field, do you have any redirect?
I don't, Your Honor.
All right, you may go somewhere. Dr. Scott, thank you so much for your time and your testimony. So, Mr. Chair, my request, it's going to make it a little choppy and I apologize, but that we start with your next witness and we'll go for about 20 minutes, a little less. We need to stop just before 1. We'll get on this call.
Okay.
And we'll take our 30-minute break then. I don't like interrupting a direct or a cross if we can avoid it, but do what you can for about 15 minutes, then we'll pause and then you'll be able to pick right back up. Who is this next witness?
Yes, the state calls Dr. Priscilla Coleman.
Dr. Coleman. Yes, sir. Sure.
Judge, could we state the names of the attorneys that will be doing the cross and direct on this one?
I sure will. So we've got Mr. Scher, whose name I spelled for you at the outset. He'll be doing the direct, and it looks like Ms. Kay, K-A-Y-E, will be doing the cross. You won't hear from her unless there's an objection from her until after lunch, but Ms. Kay and Mr. Scher.
Thank you.
You're welcome. Mr. Scher, when you are ready. Oh, whoop, let's swear her in first, please.
I do.
Can you state your name and spell it for the record?
Priscilla Carrie Coleman, Priscilla Kari, Coleman, Coleman.
Thank you.
Thank you, Dr. Coleman. Let me begin by showing you Exhibit DX16. And do you recognize this document?
Yes, this is my.
And what
CV.
is it?
It is my CV.
Okay. And what's your most recent place of employment?
Bowling Green State University,
And how long were you employed there?
20 years.
What responsibilities did you have there?
Well, I was a full-time faculty member, so that involved teaching on average 3 courses per semester. I also had responsibility to conduct research and a variety of committee responsibilities at all levels of the university.
And what courses did you teach?
I taught child development, I taught lifespan development, parenting processes, research methods. I taught a grad course in research methods, so it was both undergraduate and graduate. Taught a course a long time ago in family theories, so.
And we're talking in the past tense, so I assume that you're no longer at Bowling Green,
No, I retired this past summer. It's almost 20 years to the day.
and that was enough.
Yeah, yes. I have other things I'd like to do.
Yeah. And tell me, what was your terminal degree? Your CV lists other degrees, but what was your terminal professional degree?
It was a PhD in developmental psychology, lifespan developmental psychology from West Virginia University.
Okay. And did you specialize in any subfields?
Well, because it was a lifespan program, we had some core coursework, obviously, but then we were able to specialize in a point in the lifespan. So I primarily studied early social and emotional development and the transition to parenting. I really hadn't looked too much at the outcome of abortion at that point.
Okay. And so you mentioned that one of your subfields was, I think you said developmental psychology.
That's my primary.
Okay. And what is that? And what training do you have in that specific subfield of psychology?
Well, the PhD is in developmental psychology, and the sort of the overarching theme of that area of training is studying normative development, typical development from conception to death.
Okay. And are you a clinical psychologist?
No, I'm not.
So you don't see patients?
No.
And so is it fair to say you're more of a research scientist than a clinical scientist?
Yes, definitely. My program was research focused.
Okay. And what role, if any, do clinical data play in your research?
Well, my research, most of my research, approximately 2/3 of my publication, or at least, have focused on the psychology of abortion. So I've been interested in abortion decision-making, outcomes associated with abortion, and risk factors for more serious negative reactions. So I use clinical data that's been generated in various large data sets to analyze.
Okay. And how many scientific or technical articles or studies have you published?
I believe it's 63. I always count wrong. I know that over 60. And if you count book chapters and encyclopedia entries that are also peer reviewed, it's probably closer to 70.
And is it fair to say that a high percentage of those are on the topic, are on the psychology of abortion and pregnancy?
Yeah, over 2/3, I would say.
And how long have you been publishing in the field of abortion and mental health outcomes?
I believe my first publication was 95.
Okay.
I'd have to look exactly. Early 90s. I mean, we could look, but
So over 30 years.
close to 30 years,
Okay.
27, I think.
Okay.
I'm not going to start doing math here.
My
since it seems to
math
be
is
the
obviously
sentiment
not very
that
good
We
today
don't want
either.
to do that.
Has your work been peer reviewed?
Yes.
What percentage of the articles that you've published have been peer reviewed?
Well, virtually all of them.
Okay.
I mean, I've written other types of documents, but when I talk about having over 60 articles, I'm talking about peer-reviewed
Okay.
journal articles.
And how is a scholar's influence typically measured or assessed in your field?
Well, there are different ways. You can look at the quality of the journals that an individual is publishing in, and there's an indicator for that. It's called an impact factor. And most of my studies, a significant proportion, are at or above the average impact factor for psychology and for medicine. And then there's also a way to evaluate an individual scholar's productivity, and there's an index referred to as the Hirsch index or H index. Mine is currently 34, according to Google Scholar. And in a study I cited in my report by Barner, I believe the average score at about 20 years for a highly productive scholar at research intensive universities is under 16. So my current H index is at twice that of other scholars.
And the H index reflects citations to your work?
It reflects two indicators, the number of publications and then the number of citations to your work. Both are incorporated.
If you just, I'm not saying you do this, but if you were to stake out controversial positions, might that not raise your H score? Because people are citing it saying, well, no one but McBurney says this, and I get cited all the time. They'd say general research, but see McBurney as the outlier, or how do they control for you are?
I don't know of a way that they control for that, but I've personally scanned a lot of those citations, and by far the primary reason I'm cited is because there's trust in the
They like your information.
Well, they believe it's
Sure.
valid.
It's reliable.
Correct.
And have you personally peer reviewed the work of others?
Yes, many times.
And have you participated in any professional associations?
Over the years, I've been a member of the American Psychological Association, the American Psychological Society, and the Society for Research in Child Development.
And aside from your articles, approximately how many presentations on abortion and mental health or abortion decision-making have you given?
Dozens, I'm not sure the exact number. A lot of them recently are invited presentations. So I haven't been doing as much at professional conferences, but anytime I'm invited, I typically will go if able.
And are any of those presentations particularly memorable?
Yes, it's been great to be invited all over the world. So I've traveled to some really nice places. And it's probably in terms of which of those presentations had the most impact or are most memorable. I've spoken in Parliament houses in Great Britain, Northern Ireland, and in Australia and Queensland and New South Wales, connected with a longtime friend I hadn't seen in years who happened to live in Sydney. So that was a highlight.
But never in Ireland proper.
Well, I've spoken in Ireland. I've
Okay.
spoken at a hospital in Dublin, Mater Hospital, but not in the Parliament House.
Okay. And how many times have you been qualified as an expert at a trial?
I believe it's 5 times.
Okay. And did you prepare a report in this case?
Yes.
Could we have exhibit DX15, please? And is this the report that you prepared?
Yes.
And I think you have a copy of it in front of you, right?
Right.
And what topic were you retained to address?
Well, I was asked to examine the verified complaint and to look at the content of HB 481 and to provide scholarship and opinions that are relevant to the issues within this law.
Okay. And please describe generally the materials that you reviewed in creating your report.
Well, my focus in writing an expert report is always predominantly on the published peer-reviewed literature and the studies that, from my perspective and from my years of training, are the highest quality evidence. So peer-reviewed sources that are both my work and the work of others. I believe that within this report, I have 250 citations, but more than that has informed my opinions over the years. I try to keep on top of everything that's published in this domain.
Okay.
And then also my training, my education, and so forth.
And in preparing your report, did you apply the standard scientific principles and methods in your field?
Yes, of course.
And do you believe that you're an expert in the application of those principles and methods as they relate to abortion and pregnancy?
Yes.
Do you believe your testimony will be helpful in assisting the court to understand the facts and the issues in this case?
Yeah, so I certainly hope so.
Okay. Your Honor,
Me too.
Your Honor, I tender this witness as an expert on the psychology of abortion and pregnancy.
No objection, Your Honor.
All right. With no objection, Dr. Coleman, I certify you, if that's the right verb, as an expert in the field of psychology of
Abortion and pregnancy.
okay, abortion and pregnancy. Nope. How would you describe it? We don't want to over or under qualify you.
I would say psychology of abortion. Obviously pregnancy is involved. I think either way is fine.
Okay, we're going to go with Mr. Scher. So you tendered and have been accepted as an expert in the field of the psychology of abortion and pregnancy for purposes of this trial.
Thank you, Your Honor. With that, do you want to stop now or should we keep going for a couple more minutes?
We can stop now. I think that's a natural break point. That way, Dr. Coleman can hit the ground running after lunch. You've cleared the hurdles you need to have her offer the expert opinions you want her to offer. So we'll hear about those after lunch before people start shuffling their papers too much, just to talk about logistics a bit. You have just shy of an hour 10 left on the agreed upon numbers, and you all should talk about how that will play out since you have more witnesses to call. The plaintiffs have about an hour 50 left. I don't know what people envisioned if you have more witnesses to call and you're out of time and the plaintiffs have more time, it seems like we shouldn't just stop if we have more time in the day. So talk with your colleagues on the other side about that. I've been keeping track only at your request. And
Thank you
your
for
clock
that.
stopped a while ago. This is my clock right now, and I'm just eating up those last couple minutes before 1 o'clock. So do talk amongst yourselves about that. But for your planning purposes, that's what the countdown timers tell us. Dr. Coleman, during the break, don't talk about your testimony with anyone. Just enjoy a brief lunch. Mr. Scher, your team will be able to be back at 1:30 if I cut my thing off at 1:30.
Yes, Your Honor.
Ms. Kay, that'll work for your team. You've got plenty of water to get through lunch, but I don't know about food.
Yes, absolutely, Your Honor.
Okay, then let's be back at 1:30. We'll get through Dr. Coleman's testimony and then we'll take stock of what else we can fit in today. And just a reminder, if we need to find part of another day to get through the witnesses that both sides feel are necessary to present what they need to present, we'll always build in that time if we need to.
Thank you, Your Honor. I think I think we're all planning to finish up today. So.
Okay, great. If that can happen, I was told that about 100 times during the Judge Coomer matter last week, and we didn't finish after 5 days. So anything else procedurally from your side?
No, Your Honor.
Ms. Kay?
Nothing.
All right, 1:30, everyone. Thank you.
Thank you, Your Honor.
And I will again mute things in here so people can speak freely and it won't be broadcast into the metaverse.
Thank you, Your Honor.
All right, we are unmuted. Ms. Stevenson, can you hear us now?
Yes, did I miss anything?
Well, the only thing you missed, I knew it was on mute. I was explaining that you had not received information from one side, and both sides are confused because they claim they've sent the information. So who did you received the list that has Ms. K and Ms. Stone, et cetera, on it?
No, that's the list I need.
Okay. So you actually have the defendants list. You have Mr. Scher, Mr. Field, et cetera. You've got that. All right.
Apologies, Ms. Stevenson. We will get that over to you right now.
All right. Let's go, plaintiffs. They'll send that your way. Apologies. I don't apologize. I told them to do it and they didn't do it, but we'll deal with a contempt hearing later. So they will get it your way. Without that, though, we're going to pick back up. Mr. Scher is at the podium. Dr. Coleman already back in place. She remains under oath from the oath that was administered before lunch. And Mr. Scher, when you are ready, take it away.
Thank you, Your Honor. Dr. Coleman, in one sentence, how do the mental health risks of abortion compare to pregnancy to term?
Well, overwhelmingly, the research, if you look at it, the peer-reviewed studies worldwide, overwhelmingly, there's a systematic effect indicating that abortion is associated with more serious mental health problems compared to pregnancy carried to term.
And in greater percentages?
Higher percentages, it's more significant effects.
And roughly how many studies have there been done that have a bearing on this issue?
Hundreds.
Okay. And many of those studies have been done since you did your meta-analysis in 2011.
That's correct.
Right. And do you have a chart that summarizes 9 of those studies?
Yes, I do. It's in my report.
And let's have Defense Exhibit 611, which we introduced yesterday. And do you recognize this chart?
Yes, I do.
And does that also appear in your report?
Yes, it's more pages than this, but.
Yeah, this is a 2-page chart.
Right.
Okay, good. Now, in your report, you discussed one of the studies that's listed in this exhibit, a 2018 study by Dr. Luo that examined the relationship between suicidal ideation and abortion. Do you recall talking about that study?
Yes.
And how many women participated in that study?
5,115 unmarried females.
And what did Dr. Luo find about the relationship between abortion and suicidal ideation?
Well, abortion was associated with nearly double the odds of suicidal ideation. But what was particularly interesting, I thought, in this study was the fact that the women who did not have prior anxiety or depression, there was a stronger effect. They had a more increased risk.
Okay. Now, you also discussed 2 2019 studies by Dr. Jacob that I think are also on this chart. Do you recall that?
Yes.
And how were those studies conducted?
Well, they both were large-scale investigations, slightly different in terms of the numbers, but basically they were case control studies, and they looked at the association between abortion and elevated risk for psychiatric disorders.
Okay, and
compared to women who had a birth. And you can see in the second one that they were matched controls. That means that the 17,581 women in each group were very similar in terms of demographic factors.
Okay, and in one sentence, what did those studies show?
An increased risk with abortion compared to birth for various psychiatric problems.
Okay, and what are some of the ways that adverse psychological effects of abortion are manifest in patients?
Well, I think the most robust predictors that or outcomes that we see throughout, the many studies that exist worldwide are anxiety of various forms, depression, suicidal ideation and behaviors, and substance abuse indicators of various forms.
Okay.
That last point, meaning the research shows that women who did not used to abuse marijuana, whatever it might be, did begin to do so after the abortion?
Well, sometimes, but not always. The better studies from my perspective are those that control for prior substance use, because then you can tease out that independent effect.
Whether it just continued on through, or this is a new manifestation in this woman's life.
Correct.
And just so we're clear, the studies reveal both of those phenomena, right?
Right. Well, you have to look at every single study individually to see if did they actually control. But many of these newer studies have very vigilantly controlled for prior psych history, or if they're more focused on substance abuse, depending on what the outcome is, ideally they have controlled for prior experiences with that problem. And so
now in 2011, we've talked about this before. Am I correct that you conducted a meta-analysis of research that had been published over the prior decade and a half, Russell?
correct.
And what did you do to ensure the soundness of your meta-analysis?
Okay, well, I was motivated to conduct this meta-analysis after serving as a reviewer for the APA task force report, where they didn't identify any methodological selection criteria. So I was motivated to find the best studies and that in terms of objective indicators. So I only included studies that had at least 100 participants. They all had to have a control group. They all had to have control variables. And published in English. And so that resulted in 22 studies and 36 different effects.
And a total of how many participants?
Well, close to 900,000. I believe it was 167,000 that women who had an abortion.
Okay. And
that number it was in the 160s. I'm not sure the exact number there, sorry.
Okay. And again, just in a sentence, what were the results of that meta-analysis, sort of summarizing the results of all those studies?
Well, using pooled odds ratios, I entered it into a meta-analysis program using a random effects model, and the bottom line result was women who had an abortion compared to women who did not had an 81% increased risk of experiencing mental health problems of various forms.
Okay. And just so I understand the two categories, I understand a woman who had an abortion, went through that process, a woman who didn't, but was never pregnant, or a woman who didn't and then carried to term?
Well, that's a good question, because within the context of the meta-analysis, there were different control groups. So in some of them, it was women who had a pregnancy delivered where it wasn't identified as intended or not intended. And then there were several studies where they looked at unintended pregnancy. And then the control group for some of the studies was simply women who had not had an abortion.
But they could never have been pregnant either?
It's possible, yeah.
Okay.
Yeah, but when the control group was women who delivered after an unintended pregnancy, what was the differential there?
There was still a 55% increased risk for mental health problems.
Okay. And has your meta-analysis undergone review by other researchers since that time?
Oh, yes, quite a bit.
Remember, she's got the high H value.
That's
Everyone's reviewed it.
That's right.
It created a lot of controversy when it was published, because at that point, there hadn't been a whole lot published on this topic or highlighted in the media or elsewhere, indicating that abortion might be risky in terms of women's mental health. It also went against the conclusion of the APA that had come out a couple of years prior. So there were a lot of letters that were written to the editor. Several were cited, the negative ones were cited in Dr. Meltzer Brody's paper, but she did not include the positive articles. There were affirming type responses as well.
And we talked about those with her yesterday.
Yeah, and then the editor gave me the opportunity to provide a rebuttal in November of that year. So I thought it was great, because there was a lot of discussion on this issue.
Yeah.
And then you don't see that enough on this topic.
And since 2011, without necessarily commenting on your meta-analysis, have there been subsequent studies that supported or or even undermine the conclusions from your meta-analysis?
Well, the best, in my opinion, the best studies, and that I by best studies, I mean studies that are comprehensive in terms of numbers, sample size, control variables. They're prospective in design rather than retrospective, so that longitudinal following women over the course of time. So if you look at the very best studies, yes, there have been a lot of studies. This is by no means exhaustive. My table just gave.
And when you say this, you're referring to the exhibit that we have on the screen right now, right?
Yeah, so I included a number of studies, but I could have included a lot more. So I'm very motivated to do another meta-analysis now with all this new data, because I'm sure the effects are going to be even stronger.
But all these studies, including the 9 in the chart before you, they all support the ultimate conclusions of your meta-analysis, right?
Yes.
Okay, so at this point, given all that's come since, your conclusions, is it fair to say that your conclusions don't really depend anymore on your meta-analysis?
No, they don't depend on it, but this recent research over the last 10, 12 years is consistent with the meta-analysis.
Right. Okay. So you mentioned earlier that multiple studies found a significant increased risk of mental issues or mental health issues associated with abortion, correct?
Correct.
And in your opinion, what are the implications of those conclusions for the likely effects of Georgia's 6-week ban on abortions?
Well, I think with the ban in place, fewer women will end up having abortions. And so if you look at what we know about the trajectory following abortion versus the trajectory relative to mental health after childbirth, my belief is that with this law in place, there'll be positive results for women. Fewer will suffer psychologically.
I'm sorry, I didn't mean to interrupt. Have there been studies of the mental health impact on women who sought an abortion but couldn't get one for whatever reason, financially, legally? The family said no and the woman complied?
Well, I'm sure that you've read in, I believe, Dr. Rice's affidavit. She describes the Turnaway study, and that the whole focus there is on women who, it was discussed yesterday, but women who from various centers around the country who missed the gestational age cutoff at a clinic. So they were like, they had just missed it. They were turned away, and then there are the near limits group who just barely had time to get the abortion. So, and that data collection effort has resulted in about 60 studies, which sadly are proliferated. The literature, they're talked about in the media everywhere, and methodologically, it's very unsound. I use it in my research methods class as an example of poorly done research, and the second-year college students can identify those flaws very easily. And so I just find it reprehensible that it's had this kind of impact.
Yeah.
And so there hasn't been enough time yet to have studies done that would meet the standards you would expect of a study of a turnaway effect.
Right. I don't know of any studies that have actually done that other than, I mean, it was a good idea. It's too bad that it was so poor in many ways. I mean,
well, it's probably still a good idea if it was then. And you're saying that no one, it just surprises me if the methodological shortcomings, as you've described it, of the studies that flowed from this Turnaway data have been highlighted. Since that time, no one has said, all right, I'll follow the steps that Dr. Coleman says we should follow. Look, these are the results.
no, well, that's what I'm not saying they followed me, but the researchers, it's a variety of research groups that are represented in that table of studies who have, they sought, the plan was to design studies that produce reliable, valid information. They didn't happen to have the same group that the Turnaway. I mean, that makes sense as a group. No, so nobody has attempted what they have attempted in terms of the group designation. That just has not happened. It's not an easy way to collect data. Finding women who just happen to miss it or got turned away.
And let me, if I could interject a question that I think may go in part to the question Judge McBurney is asking, and that is, are the data from the Turnaway study openly available?
I haven't personally tried to secure their data, but I believe others have, and they have not released their data for confidentiality. They use reasons of confidentiality, and there's a lot of lack of.
And so what that means, perhaps, is that those studies are not replicable. Is that fair?
It's not replicable based on the information in their operating manual. They don't provide sufficient data. Another big topic in research methods, your methodology has to be stated in enough detail for replication, and they have not done that.
Right. And we'll come back to some of those issues in just a minute, but let me, the judge raised a question that I think also raises the issue of, is there a difference between women who choose late-term abortions and people who get abortions earlier in their pregnancy? In your opinion, based on the analysis that you've done of the data, what will be the likely impact on Georgia women who might otherwise choose later term abortions from Georgia's Life Act?
Well, there have been some studies that have indicated that women who undergo later term procedures are at greater risk for mental health problems than women who secure earlier abortions. And so I did published one in 2010, Soderberg in 1998. There have been others. And the reason that women are more at risk further along gestationally is because the data indicates that they may be younger. Adolescents tend to hide the fact that they're pregnant, and so they delay. Adolescents are a high-risk group. Women who are ambivalent are another high-risk group. So if you can't quite decide, you may end up pregnant longer. And so later term procedures are associated with factors that have been empirically found to be associated with more significant adverse effects.
Okay, thank you. You reviewed Dr. Bedell's and Dr. Meltzer Brody's affidavits, and you watched them testify here, right?
Correct.
And are you familiar with their opinions about the Life Act's medical exception and in their view that it's unfair and unreasonable to treat mental health differently from physical health?
I disagree with their opinions, and I'm perplexed at how they arrived at those opinions, given that they didn't state research that directly compared outcomes that are serious, like severe depression.
So did they cite any data in support of their opinions?
I believe Dr. Meltzer Brody alluded to the APA and the Royal College,
but no underlying data.
Dr. Rice alluded to the Turnaway study. And then in her rebuttal affidavit, Dr. Meltzer Brody identified 2 studies by Steinberg, one by Munk-Olson, all 3 with some serious methodological flaws. So
but just focus. I'm sorry, we have so little time.
Well,
let's just focus. Let me just focus you on the Life Act's medical exception. Okay. Does the scientific literature support, in your views, does it support or refute the opinions that Dr. Bedell and Dr. Meltzer Brody have offered with respect to that particular portion of the Life Act?
The psychological piece.
Yeah, the treating mental health differently from physical health.
Well, my view is not consistent with their view.
And why is that?
Because there isn't any literature to support, there isn't any solid empirical evidence to support their view, but there is a wealth of data that counters their view.
And what's the counter? I think the point we're at here is if you have a serious physical health condition, and there are more words attached to it, but a physical health condition, that can be an exception. And if it's necessary, the procedure can go forward.
Right.
But if it's a mental health condition, too bad. You're going to have to figure out how to navigate that. Hopefully you have a good psychiatrist or a psychologist.
Well,
I'm putting a spin on it, but that's what it says, that the mental health condition does not justify or trigger the medical exception. What kind of data would say that's a good plan?
well, there's data that compares women who choose abortion with, and there's data this comparison data shows that the choice to abort is associated with more mental health problems and decline. So why would you want somebody who's suffering from serious depression to undergo a procedure where all the best data available would indicate her problems would not be resolved, but would be exacerbated?
That might be an instance when you don't do that, but you have a client who makes it very clear she's about to take her own life if she can't end this pregnancy. How do you manage that?
I would, if I'm not a clinician, but
Neither am I.
I would recommend that the psychiatrist counselor explain to her that, your likelihood that you will, feel better and suffer less psychologically, your prospects are healthier if you decide to carry to term. You're likely to feel even worse if you abort. It's not going to fix your problem.
But if the medical professional, a psychiatrist, a medical professional determined, hey, this is someone who will not feel better if she carries to term, and it's my diagnosis that she's likely going to kill herself if she is not able to end the pregnancy, how is that a better outcome to say that's not a medical exception? I'm just trying to understand the data that would support that outcome.
Well, that's an individual case, like an anecdotal situation. So I think when laws are made, they should be made to address what's best for most individuals in the state.
Okay. And so in your view, does your analysis support the reasonableness of the Georgia legislatures making that choice to treat mental health differently from physical health?
Yes.
Okay. Are there discrete classes of women who you believe are particularly vulnerable to psychological harm from abortion?
Yes, and I described a number of them in my report. Adolescents are more vulnerable. Women who live in poverty are more vulnerable. Women who are victims of sexual abuse or trafficking. So there are a number of.
And you mentioned adolescents earlier.
Right, and women who are coerced. That's not uncommon among adolescents, but other women, particularly in the sex trafficking industry, there's coercion with abortion that takes place repeatedly.
And women experiencing a fetal anomaly, is that another vulnerable group?
Yes,
okay.
That literature is pretty clear that when women make the decision to carry a child with a significant fetal anomaly, they're far more likely to end up with the psychological problems that arise. I mean, anyone who's carrying a pregnancy, and usually they're wanted pregnancies in these situations, and they're told their baby may not make it or will have a significant disability. That's a shock. That's a trauma to everybody. Right. But then,
and in your opinion, sorry to cut you off, but we just have such limited time. In your opinion, without going into each individual category, in your opinion, what impact is the Georgia Life Act likely to have on the women in those particularly vulnerable groups?
It's likely to be protective and likely to enhance. Fewer women will likely have abortions, and they're going to, in my view, the law is protective of their mental health.
Okay. Dr. Coleman, do you hold each of the opinions that you've expressed today to a reasonable degree of scientific certainty?
Yes, I do.
Thank you. I have no further questions, Your
Good afternoon, Dr. Coleman. My name is Julia Kay. I'm with the ACLU representing the plaintiffs.
It's nice to meet you. I've seen your name many times on reports. So.
Well, that leads directly into my first question. Dr. Coleman, you've testified in more than a dozen cases relating to abortion, correct?
Yes.
You always testify for the side seeking to uphold the abortion restriction, right?
Yes, those are the only sides those are the only cases where I've been asked to testify.
Right. It's your personal belief that abortion is never the right decision for a woman unless her life is in imminent danger, correct?
Correct.
And it's also your personal opinion that abortion should be illegal even in cases of rape.
I prefer not to give legal opinions. I'm a psychologist. I'm not a lawyer. I'm not a politician. We just stated my personal beliefs. The cases I have been on have been related to restrictions, but
just your personal belief. Your personal belief is that abortion should be illegal even in cases of rape.
I honestly, I don't think about my personal opinion very often, but
let's pull up Exhibit 1, please, Ms. Anderson. Dr. Coleman, you were deposed on January 20th of this year in connection with a challenge to an abortion law in Florida, right?
Right.
And you were under oath then?
Right.
So let's go to page 135, line 3. But is your personal opinion that you don't believe abortion should be legal in cases of rape or incest? My opinion is that I don't think there should be an exclusion for rape. Did I read that right?
Yes.
Thank you. Dr. Coleman, you have no training in medicine, correct?
Correct. May I ask, I don't know, if you look at that page a little bit further, you'll
Sure.
see that my opinion was consistent with what I just said.
Sure, we can take zoom out so everyone can see the full page.
Down in line 18, my opinions are really not about the legality. My opinions are about the data.
Got it. So earlier we were just asking about your personal opinion, but I understand that you're giving your professional opinion today.
Right.
So you have no training in medicine, and correct?
No.
And you testified earlier that you also have no training in clinical psychology, right?
Right.
You have no experience providing psychological care to patients.
Correct.
And you've certainly never conducted a psychiatric evaluation of a pregnant patient.
Correct.
You testified in your affidavit that HB 481's police report requirement is essential to ensure that rape survivors get the resources they need, right?
My opinion is that it will increase the probability that will occur.
Understood. Providing resources to rape survivors isn't part of your work, Dr. Coleman, right?
Correct.
You've never counseled a rape survivor seeking health care.
No, I haven't.
You've never counseled any patient seeking any kind of health care at all, right?
Right.
In your affidavit, which actually I have a copy here.
I have one too, but my printer wasn't so great, so I'll go with yours.
In your affidavit, you cited to LeMague and colleagues' 2017 piece about child sex abuse to support your argument that the police reporting requirement is valuable, right?
Which page are we on?
This is paragraph 133 of your affidavit.
I want to double check. It's not that I don't trust you. 131, did you say?
At paragraph 133, you're citing LeMague
Okay.
and colleagues.
Yeah.
Do you see that?
Yes.
Now, Ms. Anderson, let's please pull up Exhibit 18 at page 10. So this is the LeMague piece that you cite. And so here, the highlighted language, here the authors are explaining that barriers to the reporting of child sex abuse include fear of consequences for the self and for others, including fear of negative consequences for the suspected offender, such as imprisonment, and fear that their family might break up. Is that right?
That's correct. But may I know the purpose of citing this article?
I think it's clear from your affidavit what the purpose was. And of course, your counsel will have an opportunity for redirect. I just wanted to make sure that I read that right.
Okay.
Thank you. Dr.
Okay,
Coleman.
I want to make sure we're having this flow the right way. Dr. Coleman, you're always free to explain your answers. So I wasn't sure if you were asking Ms. K, why are you asking me about this? Or if you wanted to explain why you did something.
I would like to briefly explain.
I would like you to explain.
Okay, well, also in that paragraph, it says specifically the data indicated that the optimal condition for disclosure is to have an individual directly ask the child about their experiences, with the individual providing active listening and support, minimizing the child's feelings of guilt and shame, and reducing fears of negative consequences. So the whole point here is that healthcare providers need to be proactive in terms of the questioning, creating that comfort level so that victims are willing to disclose.
Thank you. That is distinct from a police reporting requirement before healthcare can be accessed, correct? Two different things. Healthcare providers asking the question on the one hand, mandatory police reporting on the other. Two distinct things?
Well, not necessarily. I would imagine that if there's this sensitive care and questioning and counseling at a healthcare facility, and if a ethical healthcare provider hears that a person is a victim of rape or some other form of abuse, they're going to recommend going to the police, I would imagine, and I would hope.
Dr. Coleman, does HB 481 require healthcare providers to inquire about rape in the way that you have described? Is that what the law requires?
It doesn't require, but in the affidavit by Dr. Kuyak, I'm like struggling with that. She indicated that they do extensive, counseling
and you've testified you don't believe that is always true with abortion providers.
Correct.
Okay, let's move on. You have described yourself previously as a methodologist, right?
Right.
And you've said that being a methodologist means that you can evaluate studies in any field, regardless of whether you have subject matter expertise in that area.
I don't believe I said any field. I said many fields, virtually any. It obviously depends on my understanding of the content, but when the methods that are used are comparable to the research design methods, the statistical analyses are comparable to my training in psych, which is true across many social science fields, and it's true in medicine. An exclusion might be my son has a PhD in biology. They use different types of techniques that I'm not familiar with.
Right.
So,
but you have never, to this point, run into a study in a field that would be difficult for you. Correct?
I only analyze studies in fields that are relevant to the work that I do. So it's been possible.
You don't have a degree in methodology, right?
I have a degree in a research-focused PhD program where we had extensive training in methodology.
You've previously testified that within the field of psychology, the equivalent of a degree in methodology would be a degree in quantitative psychology, right?
No, I mean, excuse me.
Can we pull up Exhibit 1, please, Ms. Anderson?
I believe I said that's like if you wanted your PhD training to be exclusively on quantitative methods, there is a route that way, but there are all kinds of areas of psychology that are highly research focused. I was trained to be a researcher with the content in developmental psych. But
got it. I'm just asking if you have a degree in methodology or in the equivalent field within the area of psychology, which you said here, if we're looking at page 63, line 15, that the equivalent would be called in the field of psychology a degree in quantitative psychology. And you don't have that, right?
I have a degree that I believe is better. I'm trained in content and methods. If it were just quantitative, I wouldn't get the content expertise. So,
Dr. Coleman, we can take that down. Thanks. Dr. Coleman, you would always read a study before citing it, right?
Of course. I have skimmed studies. I mean, I when I'm looking at hundreds of articles, sometimes I'll skim. But before citing, I typically read the entire article, yes. There's a lot of literature out there. It's only so many hours in the day.
But you included 250 references in the expert report here.
Correct, but I've been writing expert reports now for about 15 years. So
right, and so you either read the studies or you skim them before citing them.
Or I read it 8 years ago, and and may have skimmed it to refamiliarize myself with it.
And You've spoken about how you have thousands of citations to your work and you believe most of them are favorable citations, right?
I haven't done a systematic analysis of what percentage are favorable, what percentage are not, but my last look into Google Scholar, there are over 7,000 citations to my work.
Right. And so I believe you testified earlier that you believe most of them are favorable citations because you personally scanned many of those citations.
Well, I'm just, the question, I was responding to the judge's question that about in a controversial field, isn't it likely that you up the number of citations because people are having issues with your work? And I just said that in a non-systematic analysis, I didn't look at every publication. I don't have the time for that, but I have scanned some of them and I haven't really seen a lot of negative.
Got it. You mentioned in your affidavit that you, excuse me, recently published a critique of the Turnaway study that we've been discussing in Frontiers of Psychology, right?
Correct.
Was that Frontiers publication peer-reviewed?
Yes.
Who selected the peer reviewers?
The editor. That's who selects the reviewers.
Let's pull up Exhibit 16, please. Is this your study, Dr. Coleman?
Yes.
And I see here it lists the editor and reviewers in the left-hand column where it's highlighted, right?
Correct.
Okay, so let's start. The editor is Stephen Samet from Franciscan University of Steubenville. Franciscan University's motto is academically excellent, passionately Catholic, right?
I don't know. I spoke there once, but
let's pull up the Franciscan exhibit, please. So this is their homepage. That's the motto, correct?
That's what it says, correct.
Okay, let's return to Exhibit 16, please. So the first reviewer listed on your study, Dr. Coleman, is Robin Perucci, right?
Yeah.
And Robin is affiliated with the Charlotte Lozier Institute?
It looks like it. This is the first time I've really looked at the reviewers. I do know John Thorpe, so I did know it. I remember seeing that.
This is the first time you've looked at the reviewers on your own study that was just published?
Okay, stop. You guys cannot talk over each other or I'll get a nasty gram for the court reporter, okay?
I glanced at them, but if you had asked me what are the names, I would not have been able to tell you other than John Thorpe, because I really didn't pay that much attention.
Okay, let's pull up exhibit. Ms. Anderson, maybe you can read my mind here, what the exhibit is for Ms. Perucci. I think it is 15. So just confirming that Robin Perucci, the first reviewer on your piece, is affiliated with the Charlotte Lozier Institute, just like Dr. Scott, correct?
But it looked like if we went back, I believe she had an academic, she's a faculty member somewhere, it looks like.
I think that was listed too.
Yeah, we all have affiliations with various organizations.
Right, and the Charlotte Lozier Institute, as we've discussed, is a pro-life organization.
Correct. I do know some people there, but I'm not affiliate. I don't know.
Got it.
I don't know everybody who is.
So let's return to Exhibit 16, please. The second reviewer here is from the American Association of Pro-Life OBGYNs, right? That's the only affiliation that's listed, correct?
That's what it says, yes.
And the third reviewer, the only affiliation listed is the Charlotte Lozier Institute, right?
Right. And I honestly don't know if scholars affiliated with the Charlotte Lozier Institute have had prior careers in academia or medicine. I'm sure that's not the only thing they've done in their lives.
Right, but that's what they're listing on as their current affiliation. And the final reviewer, I believe you said you're familiar with John Thorpe. Are you aware that Dr. Thorpe has repeatedly testified in court about the purported dangers of abortion?
Yes, I do know that he's done that.
Are you aware that his testimony on that topic was rejected by federal courts in both Alabama and Wisconsin?
I really didn't follow that.
Got it.
So Dr. Coleman, the part that's confusing me about this exchange, I'm following a lot of that exchange. I appreciate the point Ms. Kay is making. You write an article that's published in a journal. I know you've written many. You're telling me that you paid no attention to who the reviewers were?
I looked at them, honestly looked, and I thought, oh, John Thorpe reviewed my article, but I saw the Lozier Institute affiliations, and I had the thought, that might not look too great. I just thought, but I had no, I
know you don't pick the reviewers. I'm just curious if your goal is neutral facts down the middle, and you've got a review panel from a doctor, I don't know what his title is. His only association is, well, I assume he's an OBGYN. Maybe he's not. Maybe he's just a lobbyist.
Well,
Mr. Bratz, Ms. Lee, their academic credentials aren't even listed there. What's listed there is something that is overtly political. That doesn't seem like.
Well, it's a little bit troubling, honestly. I wish that that reviewers were chosen who had more neutral kinds of affiliations, but that's just not in my control at all. And the Stephen Bratz, I don't know him, but if he's associated with the American Association of Pro-Life OBGYNs, he must be an OBGYN. I don't think they have. I don't know for sure.
I don't know either.
I was just happy to see John Thorpe. I really respect him. He wrote my letters for promotion, for tenure and promotion at BGSU, and he's an extremely prolific scholar and has secured millions in grants. He's in maternal fetal medicine, highly esteemed.
Okay, thank you.
Dr. Coleman, you've testified in your affidavit that the Turnaway study's attrition rate significantly undermines its scientific rigor, right?
The attrition rate, along with other major sampling issues.
Understood. And you cited in your report, this is in paragraph 85, you cited a study by Amico from 2009 for the point that having an attrition rate greater than 30 to 40% is a fatal flaw in any study, effectively negating the results. Am I accurately describing paragraph 85 of your affidavit?
Yes, and within that same section, I cited to Fowler and I cited to Drugalis. And my purpose in citing Amico was he was not to say that that's definitive. That article was about the use of attrition as an exclusive criterion. And I think his position was it should be broader than that. You consider other factors. And so, but that was the position of the CDC, and that's why he mentioned it. So
let's look at paragraph 85 of your affidavit. This is Defendant Exhibit 15. So you have the final sentence of this paragraph.
Excuse me, Ms. K, Dr. Kerr.
Ms. K.
Ms. K, I have to get to the paragraph.
Yes, of course. I will wait.
Was that 85?
Yes, 85.
It's also going to be up on your screen. You can either do the hard copy or what's on the screen.
That's easier. Okay.
So this final sentence says, Amico noted that loss of potential participants or of those who initially consent to participate and subsequently leave the study of greater than 30% or 40% is indicative of a fatal design flaw, in effect negating results.
And in that sentence, he was referring to CDC, the convention amongst CDC scholars.
Now let's pull up Exhibit 17, please. This is the Amico study. And let's go to page 6 of the PDF. So what we can see here is that Amico is actually arguing the exact opposite of your fatal flaw spin. He's saying here that the most basic and pressing recommendation.
Stop for 1 second.
Oh, now we can see it.
Great.
Couldn't see it.
Sure. That the most basic and pressing recommendation is movement away from using percent attrition as an indicator of scientific rigor.
He says that, but if you read the full article, what he's advocating for is a broader examination of measures of quality of a study. His position is there's been too much of a narrow focus on attrition. And with the Turnaway study, attrition's a problem, but that's just one. There's so many others I would love to share with you if you're interested.
I understand. I just want to focus on your descriptor of Amico as saying that percent attrition is a fatal flaw. But I read this to say that, in fact, attrition certainly should not be considered standing alone a fatal flaw. It seems like the exact opposite point.
Well, he was just, as I have already said, he was describing the CDC convention on attrition. His overall thesis is not throw away attrition. His overall thesis is that is one indicator of study quality, and there are other indicators, and it matters more in some types of work than in others. I bet you could call this guy and he would not say attrition does not matter at all. He's making a point. This is a theoretical piece. He's citing to different authorities, and he wants to broaden our understanding and our use of indicators of study quality.
Right. And he's saying we should move away from using attrition as even an indicator of scientific rigor.
Well,
that's the language here, right?
He is wrong, and I don't agree with everything he said.
Let's turn now to some of your own research on abortion. We can take this down. Thank you, Ms. Anderson. You discussed earlier your 2011 meta-analysis, which concluded that abortion causes adverse mental health outcomes, right?
Right, that's what I concluded. The study didn't conclude it, but I did conclude it.
11 of the 22 articles you included in that meta-analysis were studies that you yourself either authored or co-authored, right?
Right, because they met those criteria that I used.
And you've previously testified that the most important criterion for inclusion in your meta-analysis was a study's use of controls, right?
I didn't rank my criteria.
Can we please pull up Coleman Exhibit 1, your Florida deposition? Let's go to page 109.
Is this the same Florida proceeding at which Dr. Scott testified, or a different?
Different.
This is the
This was from January of this year, and Dr. Scott testified in June of this year. Two different cases. Okay, so let's look lines 9 to 10. You're initially referring to a different criterion. You say that wasn't the most important criterion. The most important criterion was the use of controls, in my view. Did I read that correctly?
Yeah, I mean, they were all important, but I guess whatever preceded this, I must have been highlighting controls. I mean, controls are very important, but sample size matters. You don't want to sample a very small sample. So I only included studies with 100 or more. Comparison groups are very important. That factors in to the control process.
So because use of controls is important, you were rigorous about ensuring potentially confounding variables were controlled for in your meta-analysis.
Right.
But you've acknowledged in prior testimony that 10 out of the 22 studies you included in that meta-analysis did not control for a prior history of mental health, or in other words, didn't control for mental health issues predating the abortion, right?
Right, which was more studies than the Royal College included in their analysis, that they eliminated all kinds of studies with prior controls for prior psych history for the simple reason that those assessments didn't occur within 90 days. So I compared to these esteemed professional reviews that we heard about yesterday very briefly from Dr. Meltzer-Brody, my meta-analysis concluded a larger proportion of studies with prior controls for psych history.
Would you also agree that in comparing the mental health of women after an abortion with the mental health of women after childbirth, it would be important to control for whether the underlying pregnancy was intended or not, right?
Correct. And several of the studies in the meta-analysis did do that. And I published a study in 2005 where it was predominant, if you'll indulge me, it was predominantly poor women, not well educated, 79% were Black. And I looked at the wantedness the wantedness variable was unrelated to substance abuse, but the abortion variable was related. So of course, the wantedness of a pregnancy or the intention of the pregnancy, which is actually pretty difficult to measure, and it depends on whether you measure it immediately or down the road. It's a variable that we know fluctuates. So it's not like, I mean, it's important. It's obviously if you're aborting an unintended pregnancy, that may be less traumatic than a wanted pregnancy, and not, half of us sitting here were not the result of an intended pregnancy. Half of us are unintendedly here, and so it's a common experience. And I in doing a study, I'd prefer to have that variable to control, but it's certainly not a fatal flaw to not have it controlled for intendedness. And there are other ways to equate groups.
Let's briefly pull up Exhibit 1 again, the same Florida deposition, page 213, line 25.
That was a long deposition, 11 hours.
Okay, so here you're saying that's why it is important to control for, and then if we can move on to the next page to finish the thought, please.
I'm still on the same.
Yes.
Okay.
The intendedness of the pregnancy.
We see the question.
Sure. Here, you know what? You can have these. I have a copy for you. I will give everyone a copy. Ms. Stevenson, I am now passing copies of this deposition to the witness, opposing counsel on the court.
Is it that big too?
You can, I'm good with the screen. You.
Strike that from the record, Ms. Stevenson.
I went into it thinking it was going to be 7, but it wasn't federal court. They said 11. I thought, oh, dear God.
And so your language here is that it's important to control for the intendedness of the pregnancy because, if you want to understand, is it the fact they ended up pregnant and they didn't want to be? Or is it the actual abortion that's causing subsequent mental health issues, right?
It does help to tease out that effect along with a lot of other variables.
Right, but many of the studies that you rely on, both in your meta-analysis and in your expert affidavit here, don't control for pregnancy intention, correct?
Many do.
I'd like to look at just a few examples of studies you're citing in this report. Let's pull up Exhibit 12. This is the 2010 MOTA piece. And let's go, well, we can actually start on this first page here. Limitations include, where it's highlighted, limitations include we could not identify the gestation at which the abortion occurred and whether the pregnancy was wanted or unwanted, right? So that's one of the limitations identified. And now let's please go to page 6 of the PDF. So this is one of the studies you're relying on to support your conclusions in this case, right? And let's look at some of the limitations. We were unable to distinguish whether mental disorder preceded or followed abortion if both events occurred in the same year. Recall of when the abortion happened or when mental illness came on may have been unreliable, particularly if they occurred in the distant past, because this was retrospective. And the authors note that unintended pregnancy itself may be a stressful event that can be a confounding factor in the relation between abortion and mental illness, but we couldn't examine those associations, right? Those are some of the limitations of this study you rely on?
Right. There were strengths of the study too.
Okay.
If I may, this is also the data set that Julia Steinberg used, one of those studies that was cited by Dr. Meltzer Brody, and the NCS does have a very low, a very high concealment rate. It's estimated that 44% only 44% are revealed. So that's a 56% concealment rate. So a lot of these older studies have the similar flaws. So just as I cited Tomoda, she cited to Steinberg, using the same data set. I mean, so that there's only so many data sets out there, and they do have some limitations.
Let's look at some of the more recent
Okay.
pieces post-dating your meta-analysis.
Okay.
Why don't we look at the 2013 Bellieni review of 30 studies that you cite in paragraph 24 of your expert affidavit for the conclusion that abortion is a risk factor for mental illness when compared to childbirth.
Okay.
This is exhibit 20, and let's go to page 8, please.
Excuse me, in my report, what can you read?
Yes, paragraph 24 of your affidavit.
Okay, I don't want to look at this anymore.
Bad memories.
No, not really, but.
If we can pull up the highlighted language, thank you.
And it's paragraph or page 24?
Paragraph 24. Okay. So here in the Bellieni study, which is defendant's exhibit 42, the authors explain some limitations that most of the 30 studies they analyzed used data taken from big databases, which meant that confounding factors could not be eliminated.
Well, many of the studies with the large databases, that's actually an advantage of a large database, assuming the correct useful variables are within. So databases do vary widely in terms of the number of demographic factors, the reproductive history variables. And so most of them have plenty of variables that you can work with. But
right, but the authors of this study that you cite, which in turn reviewed 30 different studies, say in this paragraph, we need more research because only a few of the studies we looked at were able to rule out confounding elements in data analysis, right? That's their conclusion.
Right, but I also looked at the studies that they cite to, and I know that many of those studies are strong. So an author's particular assessment, I don't necessarily agree with their commentary that relates to the data cited. I agreed with the articles that he looked at.
I see. So sometimes you think a study can be very strong even if it doesn't have any controls for confounding factors.
No, that's not what I'm saying. I'm saying that his assessment may not be accurate. Another example of this type of a situation with the Gilchrist article, the author, I believe it was Gilchrist 96, the author had commentary within his article wherein he stated that there was an association between abortion history and suicide. And he had commentary in there that said it's unlikely that the abortion caused the increased risk of suicide. It was likely due to unmeasured variables. I didn't agree with that because we didn't have any data. There wasn't any data in his report on unmeasured variables, but there was a clear, strong, significant increase in suicides following abortion. And it was almost 6 times greater than it was with pregnancy delivered. So I agreed with the data and what he discussed, but his view on the data I didn't necessarily agree with.
I see. So the court, in reviewing the studies that you rely on in your affidavit, should take with a grain of salt the limitations that the authors themselves identify in their studies, because you may disagree with those limitations.
No. That's definitely an overstatement. I'm saying sometimes the commentary that's provided might not line up with my view on the data, but when the data is decent, then it's useful in terms of informing the court.
Let's turn to the Luo study that you were discussing with Mr. Scher on direct. This is defendant's exhibit 177, please. And this is another more recent study that you highlighted as a strong support for your conclusions, right?
Correct.
Luo was a study of female migrant workers in China, right?
Right.
Okay, let's go to page 10 of the PDF, please. Okay, so Ms. Anderson, Can you first highlight the beginning of the paragraph that says our results should be interpreted considering, and the above all sentence? So the first point that the authors make is we cannot draw causal conclusions from this data set due to the cross-sectional design, right?
Well, and in fact, we can never draw causal conclusions with this type of research. You can't randomly assign women to have an abortion or a birth. Causal conclusions are always precluded. And that Dr. Rice attempted to explain that yesterday, but we can only draw causal conclusions when we have random assignment to groups. And what we're looking for is that the three basic conditions are: the cause needs to precede the effect. You need to be able to show covariation of the independent variable with the dependent variable, and you have to rule out confounding factors. So you just can never definitively do that in any given study as long as you're comparing women who choose abortion versus childbirth. It's just not possible. But we can build a case for causality over time with strong studies. It's suggestive of a causal association. But of course, I mean, that's every author of every paper on this topic, they should say that. It should be, clear. I mean, it appears to be causal, but it's not definitively causal. So we speak in terms of increased risk. And that's what I think women need to know, that if they decide to have an abortion, they're at a greater risk of having a mental health problem. Doesn't mean they're going to have one, than if they choose birth. So it's all about increased risk. It's never about, for sure, you go have that abortion, you're going to commit suicide. I mean, it's causal. It's never that. It's not straightforward. It's just the nature of the data.
Thank you. I want to highlight just one more point about Luo before we move away. Again, this is a study that you've identified as strong and recent support for your conclusions here. Let's highlight, please, where it says fifth in the right-hand column, third line from the bottom. So those 3 lines, and then we'll move on to the next page. We compared suicidal ideation between women with induced abortion and those without such experience, most of whom we assumed to be never pregnant. On to the next page, but not ideally, 2 groups of pregnant women, with one experiencing induced abortion and the other delivering the baby. Did I read that right?
Right.
Okay, we can close this out now. Thank you. Your meta-analysis was designed to include only the strongest studies, right?
Based on the criteria specified.
And you mentioned that one inclusion criteria you chose was that the study had to have more than 100 participants. And I believe you actually testified a few moments ago that this is really important. You don't want to have a very small sample size.
Want to increase the statistical power, and you're going to have if you're dealing with quantitative studies, then you want to have higher statistical power, which you need numbers for. However, if it's a qualitative study, the purpose is different. You're interested more in the substantive experiences of people, not just Likert type items, survey items, but you want to get at kind of the breadth and depth of women's experiences. So qualitative research often far smaller samples, but the information derived is different, and it's not necessarily less useful, but it's different.
Right, but if you want to quantify a phenomenon, you need a decent sample size, preferably more than 100, right?
Right, but it's still not that cut and dried. It depends on how many variables you have.
Okay.
So if you have fewer variables, you can get away with a smaller sample size. So 100, I believe 100 was used in Thorpe's review in 2003. And that was a very well done review of the literature. He chose 100 as a sample size cutoff. And so, that was part of my motivation.
Right, so for purposes of your meta-analysis, you felt that studies below quantitative studies with fewer than 100 participants were less reliable and should be excluded. right?
No, that's, well, I excluded them from my meta-analysis, but it's not, but whenever we look at this whole body of literature, there are strengths and weaknesses. And so you're not going to get me to say here that any small study is not reliable.
Got it. Let's look at the approach that you took to your expert affidavit for the court. Let's pull up defendant's exhibit 15, which is your affidavit. And let's go to paragraph 36, please. Okay, so let's please highlight the first two sentences of paragraph 36. And here you say, Allenson and Asbury in 1996 reported some startling statistics conveying women's emotional conflict prior to having a first trimester abortion. Did I read that right?
Yes.
Now let's please pull up exhibit 13.
The sample size was small. I can spare you that.
And let's go to if you can flip through, there's some highlighted language in here. Okay, here, so at the bottom here, 20 women attending the fertility control clinic in Melbourne. The startling statistics came from a sample of 20 women in Australia.
Startling statistics relate to the fact that these are women all fully intending to abort, who aborted, who experienced these maternal feelings of, I patted my tummy affectionately, 30%. I thought or daydreamed about it. This shows that the point of including this data for the report or for understanding the whole phenomenon of decision-making and maternal attachment to the fetus and so forth. This shows that women who are undergoing some women undergoing a first trimester abortion are feeling some maternal type emotions. And so this is an example of a qualitative study that I just alluded to, indicating that it offers a different type of information.
Is one supposed to draw statistics from a qualitative study?
A lot of times I did the same thing in a qualitative study. We had over 900 participants. It was qualitative. But yeah, it's easy. You can come, you're not a lot. It's not like this is all qualitative. You can't use numbers, but the focus is more on the substantive information derived. And with a quantitative study, you're performing typically inferential statistical tests. You're not going to do that. These are just descriptive numbers. These are just percentages.
Let's go back, please, to defendant's exhibit 15, your affidavit.
Where are we going?
Back to the same paragraph that we were just in about Allenson and Asbury.
Okay.
Because you didn't give the court any context for describing Allenson and Asbury as revealing startling statistics. You didn't reveal in your affidavit that this is a study based on 20 women in Australia, right?
I didn't say the number of participants in every single study. I stick to the information that's relevant to the points I'm trying to make.
So the court would have to review all 250 references in your affidavit to understand whether something you refer to as a startling statistic might in fact be drawn from a pool of 20 people, right?
I suppose they would.
Let's go to paragraph 42 in the affidavit, please. Okay, so this is talking about a study, previous page, please. Right, exactly. So bottom of page 12, paragraph 42. Here you're talking about a study that you published in 1998, where you found that 38.7% of female college students voiced regret in the first few years following an abortion.
Correct.
That study included just 31 female college students, right?
Yeah, I think that we looked at men as well. So I think it was 60 total.
and 31 female college
I
students.
believe, but you're talking 24 years ago.
We can pull it up.
Okay.
It's Exhibit 14.
Was published. in
Page 5,
a-
please.
was published in a prestigious journal, the Journal of Social and Clinical Psychology.
So here, this sample is 32 men and 31 women
Oh, wait a
in
minute.
college were the participants, right?
From the larger we had a larger sample. In order to derive, if you look, you need to highlight further up. The sample consisted of 1,387 students, of whom 34.5% were male, 65.5 were female. But then we had to pool that many students to get then the 30 or 32, 31 men and women who admitted to an abortion.
I see. Okay, let's move to Defendant's Exhibit 102, which is Ferguson's 2008 study on abortion mental health.
Okay.
You're familiar with that study, right?
Yes.
And in fact, you've testified that you're very familiar with that study.
It's one of many that I've reviewed.
And you've testified that it's one of the strongest studies documenting that abortion causes adverse mental health effects.
No, I would not have used the word cause. That word comes out of people's other experts' mouths and in their writing. Julia Steinberg uses causal all the time. I do not. So that is not, I would not have said that. I would have said he provides excellent data to indicate that abortion increases risk for mental health problems of various forms, because as you can see in the title, he has a 30-year longitudinal study and he has high retention rates. It's far better than many of the studies out there.
So let's look at the 2008 study. This is Defendant's Exhibit 102. And let's go to page 6 of the PDF, please.
This chair doesn't move forward.
It does. You just have to be a weightlifter to get it forward. It doesn't have wheels. It used to have wheels and people kept rolling off, and that was
Okay, so let's
even worse.
Let's look under the header evidence of causality.
Okay.
And that first sentence there is, these findings are consistent with the view that exposure to abortion has a small causal effect on the mental health of women.
They're consistent with the view, but the data doesn't indicate a causal association. He goes on in that section to explain what we need. Those are the Bradford and Hill criteria for causality. So he explains how the data within his study are consistent. Like if you take a look at the consistency of the associations, the resilience to control for confounding, the temporal sequencing. So his study had those elements, but still, Ferguson, nobody can determine causality with this type of data. But so he's suggesting that because the study allowed for several of the conditions of causality to be met, that it gives us some confidence that might be a causal connection. He doesn't say, he said it's consistent with the view. He doesn't say my study showed a causal association.
Thank you. Now let's pull up Exhibit 21, please. This is a 2013 piece by the same author entitled, "Does Abortion Reduce the Mental Health Risks of Unwanted or Unintended Pregnancy? A Reappraisal of the Evidence," correct?
Correct.
Are you familiar with this 2013 study, Dr. Coleman?
Yes.
And in this 2013 paper, among other things, Dr. Ferguson reanalyzed the data set from his 2008 paper, right?
I believe so. Yeah.
So you can actually look, if we go to page 2 of the PDF, bottom right, the Ferguson et al. 2008 data were reanalyzed to produce estimates of the AORs for the direct comparison between the unwanted pregnancy and abortion groups.
Right, can we get that all highlight that, the whole paragraph?
Sure.
Blown up so I can see it better?
So this 2013 piece by Ferguson reanalyzed the data set in the 2008 piece from Ferguson that you rely on.
Right.
You didn't cite this 2013 piece in your affidavit, correct?
No, I didn't, but it is in this. I cited Ferguson 2006 and 2008, and I guess I felt like that was enough on Ferguson. There wasn't any purposeful reason for omitting this.
Let's go to page 8 in this PDF, please. So after doing this reanalysis, Ferguson concludes here that it would be premature to conclude emphatically that this evidence is sufficient grounds for believing that abortion has adverse effects on mental health. So it seems like Dr. Ferguson is retracting his conclusion in the 2008 piece that the evidence shows a causal connection between abortion and adverse mental health.
Well, I promise you, Dr. Ferguson never voiced an opinion that abortion causes mental health problems. He was a far too prolific researcher to make that kind of an error, published over 500. And I think before I agree to that, I want to look this study over more carefully, because I believe within there, he says conflicting statements. So would you like me to take the time?
Sure.
Okay. So is there a hard copy of this, or how?
Oh, to read the whole study?
Well,
No,
this-
I don't think we have time for that, but we can zoom out. You can read the whole paragraph.
Well, the paragraph's not sufficient. I would want to look at what he said earlier, because I'm certain that there's statements in here that are, that are not. He says it would be premature, but there's data in here that supports that. I believe.
Sure, but my question for you, Dr. Coleman, is why you didn't think the court might be interested in Dr. Ferguson's 2013 reanalysis of the 2008 piece that you cited, in which he walked back the conclusion that the evidence supports a causal connection between abortion and adverse mental health.
He's not walking back on his conclusion. He's saying right here, it would be premature to conclude emphatically that the evidence is sufficient grounds for believing that abortion has adverse. But he's not, nowhere in this study, I guarantee, did he say, we were in error in 2006 or 2008, and this better analysis shows, forget those papers, this is the reality. He does not do that. There's consistency across his work with this 25-year longitudinal study.
So you made the choice that the court didn't need this context for Ferguson's 2008 piece.
I wrote this report in a week, and I didn't think about every possible article that could be included. I really wouldn't have reservation with including it. Wouldn't have added much, because it's this. He's basically, it's similar to his previous work. I mean, there was no motivation to not include this. I guarantee.
It was just an error.
It wasn't an error. There are hundreds and hundreds of studies on this topic. Do you think in a week's time I could re-examine hundreds of studies and then put them into piles? This one's most important. I went with the evidence that I remembered was was strongest, most effective in terms of making the points I wanted to make.
But if the points you wanted to make are driven by data and the first Ferguson study you included, is that correct?
I included 2.
Okay, but there was a subsequent Ferguson study that said tap the brakes. Doesn't it make an outside observer looking in saying, well, why would Dr. Coleman not want someone who needs to be educated on this to know that Dr. Ferguson, Mr. Ferguson said maybe it is less clear than the studies you chose that Ferguson wrote?
Well, with all due respect, that one sentence that you pulled out is not indicative of his article. I mean,
what is indicative of his article?
I think I'd like to look back over it because I haven't looked at it recently, and I have read it, and so I knew his position. We together wrote a petition letter to the APA about how poor their analysis was, and so I know what his position has been. He was an outside reviewer for my promotion and tenure. We saw the literature similarly. So if I look at that, even though he's very outspokenly pro-choice, rational atheist, he's not committed by any stretch, or wasn't committed to showing that there are adverse consequences or there's an association. So if I am given 5 or 10 minutes to look at this article, I'm sure there's something, this is a cherry-picked comment.
Okay, it may well be. I'm confident that the article is somewhere in all the reading I get to do as well. So I will look at that. I appreciate you explaining that.
Thanks. Dr. Coleman, you're aware that your conclusion that abortion is associated with increased risk of mental health harms has been rejected by virtually all of the leading professional associations, including the American Psychological Association, American Psychiatric Association, National Academies of Sciences, Engineering and Medicine, and the UK's Royal College of Psychiatrists, correct?
I'm aware that Wikipedia says that and some other sources say that, but when you say rejected, show me some evidence.
Okay, let's give an example. Are you aware that the Royal College of Psychiatrists stated that, quote, a number of methodological problems with meta-analysis conducted in the Coleman Review have been identified, which brings into question both the results and the conclusions?
That's what they said in the Royal College.
Yeah, we can pull that up.
Can we talk about all the other errors they made in their?
I don't think we have time for that.
Well,
but we can pull that if you'd like to see that quote. We can.
And don't stop and don't interrupt each other. You're free to answer the questions. You don't get to ask questions back. What about that one? But you can highlight, as you have been doing very effectively, that this is an area that is rich with debate and that there are conflicting perspectives. And frankly, people look at the same data set and maybe see it a little bit differently.
Okay, I just one brief response.
Sure.
The British Journal of Psychiatry that published my meta-analysis is the journal for the Royal College. It's their in-house journal. And that's why I was invited to speak in British Parliament, because the findings that were published by Peter Tyra, the editor at the time, were in absolute conflict with their 180-page review. And so,
setting aside abortion, Dr. Coleman, you would generally trust the medical conclusions of these professional associations?
I'm not a medical doctor, so as Dr. Scott indicated, she trusts a lot of it, but when it comes to a highly politicized issue like this, you have to look at the data.
And it's your view that scores of scientists have suspended personal and professional ethics in order to advance abortion rights?
I believe that's true.
And you've described these professional medical associations in the United States and beyond as arrogantly seeking to distort the scientific literature in service of a pro-abortion agenda?
That might have been my words on a bad day. I'm not sure.
We can pull up Coleman 19.
But that's basically my view.
Then we don't need to pull up. Thank you. Dr. Coleman, are you aware that in 2017, the District Court for the Southern District of Indiana described your research on abortion and mental health as having been almost uniformly rejected by other experts in the field?
Again, based on what? I am really getting tired of hearing that my research has been debunked, discredited, and nobody shows me where. I mean, in that court case, I wasn't an expert, and they were looking at my Danish population-based study, one of the best ones. And the other one was the Medical data, where we had huge population of women. We had controls. And so I was not the expert. I couldn't defend my own research. But it's really frustrating to be just dismissed like that without looking in detail at the work that I've done. Just because my results don't align with what's politically correct or what the agenda of these various organizations happens to be, the APA in 1969 made a statement endorsing abortion as a civil right. That was a position statement. And I don't, I mean, for a scientific organization to take a political position, in my view, is inappropriate.
Are you aware, Dr. Coleman, that the Seventh Circuit Court of Appeals described your research as being much maligned?
Well, I don't know about that one. Which case was that related to?
We can pull it up. It's Coleman Exhibit 7. At page 826. Oh, that's not the PDF citations.
Do Seventh Circuit opinions count in that H factor you were talking about?
I don't know. The Eighth Circuit liked me. So can we back?
Well, that's a higher number, so that may be better. Soon you may get the 11th Circuit to weigh in.
Just scroll down a little further till we get to 826.
I'll do extra credit.
Okay, here. Have you seen this language before, Dr. Coleman?
I'm not sure. May I please read it?
Of course.
Could we see it in context as well?
Sure. You know what? I have a copy of this for you.
What state is this they're referring to?
This is the Court of Appeals. This is the U.S. Court of Appeals that governs over district courts in Indiana, among other states.
Okay,
And
so
this
when
was
it
appeal out of Indiana.
well, when it says finally the state, referring to Indiana, correct?
Yes.
Okay. Which of the one? Oh. So in this opinion, they're saying that my meta-analysis has been much maligned.
I'm good. Thank you.
Well, it has been much praised as well. So
I have no further questions. Thank you.
thank you.
Mr. Scher, any redirect?
No redirect.
All right. Dr. Coleman, I appreciate your time. I hope you do not feel much maligned here. Maybe by one side, but I
appreciate your fairness.
I appreciate you trying to shed some light, in particular on methodology.
Thank you.
You're very welcome.
Thank you.
Okay.
Oh, yes.
So perhaps symbolically, the two sides are now in equipoise. Both sides have about 45 minutes left. And we've got more time than that left in the day. So you guys will need to let me know how you want that to play out. This won't make a loud noise when it gets to 0. I'll let you know it gets to 0, but we'll figure it out.
Yeah, Your Honor, what we were going to request is dividing the remaining time between both sides.
Sure.
Think
Hour 15 each.
Yeah,
We've got to have a little break at some point.
Yeah, yeah.
So Ms. Stevenson's okay.
Precisely. So I was going to ask Your Honor how much time he felt that the court thought would be left, and we would divide that so that we don't get to the end with one witness and realize we have a bunch of extra time just to keep talking.
Right.
That one witness.
We've got about, it will take a break, not quite yet, because we started at 1:30. So we'll get maybe partway through the next direct, depending on how long that is. And we'll take a little break, but we'll go till about 5:30. So we have 2.5 hours minus 10. So that's what I was saying. It's about an hour 10 per side, remaining 70 minutes. And I can reset the timers. I can not do timers because you guys have worked it out. I'm neutral on that.
If we're now at the same point, I think we can just start it over with an hour 15 for each side.
Hour 10 for each side. All right.
Thank you, Your Honor.
Nice try though, Ms. Kay. All right. Before we start all that up, who is the next witness?
Dr. Farr Curlin,
All right.
and the state calls Dr. Farr Curlin.
All right, Dr. Curlin, come on up.
And for the court reporter's benefit, this is Christopher Bartolomucci for the state.
And who will be handling, we've got a new occupant of the driver's seat on the plaintiff side.
Corey Isaacson. CORYISAACSON.
and the truth, the whole truth, and nothing but the truth, so help you?
I do.
Do it, man. State, stand and bear true.
My name is Far Curlin, Farrcurlin.
Good afternoon, Dr. Curlin. Could you tell us where you received your undergraduate degree and your medical degree?
I completed both at the University of North Carolina, my undergraduate degree in biology, and then my medical degree at the School of Medicine.
And where do you currently work?
I work at Duke University.
What titles do you hold at Duke?
I'm the Josiah Trent Professor of Medical Humanities in the Trent Center for Bioethics, Humanities, and History of Medicine in the medical school. I also am Professor of Medicine in the Department of Medicine and its section on palliative care. And then I also am a professor in the Divinity School.
Now, can you tell us what the Trent Center for Bioethics is?
The Trent Center for Bioethics is Duke University's center focused on bioethics and other questions that are not reducible to science that have to do with the practices of medicine.
Can you tell us what the field of bioethics is?
So bioethics is the field of inquiry regarding how we ought to act and how we ought to live or carry ourselves with respect to all manner of living things. So bioethics is a rather broad term, which would include medical ethics, certainly, but also things like environmental ethics, ethics of different types of research into living things. And my area of focus within that is medical ethics or clinical ethics.
Well, then, can you tell us what the field of medical ethics is?
So medical ethics is the field of inquiry regarding how we ought to act and how we ought to carry ourselves or practice with respect to medicine or healthcare.
Are you also a fellow at Duke?
I am. I'm a senior fellow in the Keenan Institute for Ethics.
Now, before you came to Duke, I believe you taught at the University of Chicago. Could you please tell us about that?
Sure. I went to the University of Chicago after medical school to complete a residency in internal medicine. I then completed fellowships in health services research, and after joining the faculty, a fellowship in clinical medical ethics. And then I served on the faculty in the Department of Medicine, as well as the McLean Center for Clinical Medical Ethics, until I moved to Duke University in 2014.
And as a physician, are you board certified?
I am. I'm board certified in internal medicine and hospice and palliative medicine.
Dr. Curlin, do you have a clinical practice?
I do. I've always maintained a clinical practice. My clinical practice for the past several years has been focused in hospice and palliative medicine.
Now, your CV is in the record at Defense Exhibit 18, and I won't go through all of it, but have you authored works published in peer-reviewed journals on the topics of medical ethics and bioethics?
I have, yes, a number.
Can you give us a rough sense for the number?
I've published more than 130 peer-reviewed articles and then a peer-reviewed book on medical ethics. Not all of those articles are specifically on medical ethics. I'd say probably half of them deal with clinical ethics or medical ethics topics.
And have you ever previously testified as an expert on medical ethics in a court case involving a challenge to a restriction on abortion?
I have several times.
And do you recall whether the courts qualified you as an expert in some or all of those cases?
They did in all of the cases.
Now, yesterday you were in England, you came all the way here to testify today. Can you tell us what you're doing in England?
I'm on sabbatical at the Oxford University and getting some rest as well as doing some research.
Well, Your Honor, I would ask the court to qualify Dr. Curlin as an expert in the fields of medical ethics and bioethics.
No objection, Your Honor, from our side.
Dr. Curlin, for purposes of this trial, you are being qualified as an expert in medical ethics and bioethics, so larger universe and subset.
Couple of preliminary questions, Doctor. Are your expert opinions in this case offered to a reasonable degree of scientific certainty?
Yes.
And as a general matter, what are your expert opinions in this case based upon?
They're based upon my training and research and study of the literature and teaching and speaking in academic venues and interacting with colleagues, mentoring junior researchers, all in the domains of medicine and medical ethics.
What does it mean? I'm sorry to interrupt. What does it mean to say that an opinion about the ethics of something is backed up by scientific certainty?
Well, that's a good question. There's also the concept of reasonable degree of medical certainty. My understanding is those terms are legal terms of art, meaning that it's more likely than not the case, reasonably understood. But in my case, I think all ethical arguments stand or fall on the merits of the argument, which includes how well they accord with what we know through scientific means of knowing. But it's not limited to that.
Now, Doctor, we've heard testimony today on the question whether a fetus is a distinct living human being. What is your answer to that question?
I think the fetus is unequivocally and indisputably and uncontroversially a discrete human organism, a human being.
And so if we're dealing with certainty, how do you use the adverb uncontroversially? We wouldn't be here if it was uncontroversial.
This I would say, is an area of complete certainty. Insofar as biologists know anything about living beings, they know that the human fetus is a living being.
Okay.
Just to elaborate it further, although I know that there was the one statement by one of the plaintiff's experts that there's a consensus that the fetus is neither living nor distinct. There was no basis given for that. And I've been doing this a long time. I've never seen a single biologist or embryologist ever in their official context doubt or suggest otherwise than that human beings begin, like all other mammals, which reproduce sexually at a zygote stage. That's how they begin.
From a biological, scientific perspective, maybe not medical or legal.
Well, we'll get into the medical or legal status of those beings, but they are. The word being means exist, and humans exist as organisms, and the fetus is an organism. These are areas. These are not controversial topics. I genuinely don't think these are disputed by either side.
Now, is there a debate about whether a fetus is a person? And could you please tell us what the concept of personhood means?
There's the debate.
Okay. So person as opposed to human. I understand better now.
Yes. And of course, the debate arises because there is throughout history, there's been a fundamental sense, a recognition across cultures that you should not kill the innocent. And so then the question becomes, in the case of abortion, which obviously kills a human being, the human being is obviously innocent if it's a human being. Well, how can we justify that? And the argument has been made by many that, well, granted the fetus is a human being, but it's not yet a human person, or where the language of personhood is used to indicate that the fetus has not yet gained what ethicists call moral status. Moral status being that which gives us a claim against being treated illy or killed. So yes, that's where the dispute lies. That's where the claim where the arguments cash out.
And where do you come down in this debate?
So in my view, in my expert opinion, which of course, as I've said already, is not one that everyone agrees with, but many do, the language of personhood is being used in a way that ultimately is arbitrary and unjust. It involves, and here's why. You would think that you use the language of personhood as if we all know what a person is, and then we look at a fetus and say, is a fetus a person? We know what a person is. Is a fetus a person? As if we might look at people in this courtroom and say, well, we know we have some human beings here, but are they persons? Because if they're not, we can do to them what we want. That's not the way people generally think. Generally, ethically, we think if we find a human being, we find someone to whom we owe moral regard. So the language of personhood, and ethicists have acknowledged this, including ethicists who support abortion. The language of personhood has been used within the ethics literature to indicate those whom we are choosing to not treat with moral regard, to choose the category that we've decided we can treat them differently than we treat other human beings. And in this case, this is the case, the category of human beings, namely fetuses, about which the language of personhood has been most often used and most often advanced.
Or I guess you could say those folks who advance that perspective don't view a 6-week-old fetus that looks a little bit like a lizard and doesn't have arms and legs and whatnot as not a human being. You are saying the label human being applies at life, and biologists agree with that. So a scientific perspective, but why is that what you think ought to be, from an ethical perspective, why is that what is controlling as opposed to maybe society's conception that, and this is personhood versus the term human being, but in some ways those terms are interchangeable, that human being aspect doesn't occur until some point in birth, viability. I mean, there are these lines that different professions have drawn that, well, before then maybe not a human being. And I don't want us to get hung up on the terms, because I'm not disagreeing with you from the biological scientific perspective, but that isn't necessarily what controls in lots of well-meaning, well-intentioned non-biologists' thinking.
Well, Your Honor, good ethics as with good law depends on good facts. And so the question would be, if that's not a human being, what is it? And I'm saying that scientifically speaking, the term human means of the human species, right? That's what it refers to, of Homo sapiens. Is that a Homo sapien? Well, it's the offspring of a Homo sapien. So it's that. Being, does it exist? It does exist. So that's why the language of personhood has been used, because people realize to say that that's not a human being is to speak nonsense. It may be the kind of nonsense people find appealing, but it doesn't make sense because it requires us to ignore things that we know.
But we know until viability, it doesn't exist independent of its physical, biological attachment to the mother.
That
exactly distinguishes
right.
it from, I guess, the rest of human beings who are no longer physically attached to their mother.
That's exactly right. And so that is one of the primary criterions that people have advanced for distinguishing a non-person human being from a person human being.
But again, it's personhood as opposed to human being.
Yes, exactly. And as in the in the example you gave, in my judgment, none of those criteria, and a number have been advanced. People have said, well, maybe it's sentience when something can experience pain, or maybe in the case of this law, as it's using a cutoff of when you can see that this has a heartbeat, which we take to be a sign of a living being. Or someone says, well, maybe it's higher order cognitive function. Some ethicists have argued we should be able to kill infants before they can really think. I mean, they don't know we're killing them, so how are we really harming them? They've argued.
That's a little bit more of a fringe view than viability.
It is a fringe view. So then the question is, where can we draw a reasonable distinction? And in my view, no one has put forward a distinction that's reasonable.
After conception.
Anytime we have a human being, it seems to me, we have someone that we owe the basic regard that we owe to all human beings.
Now, Doctor, the Georgia Life Act draws a line at a point about 6 weeks into pregnancy when a heartbeat can be detected. Do you have an opinion about where Georgia has drawn that line?
Yes. My opinion is that it's not the case that prior to 6 weeks, this is not a human being, but the heartbeat is a kind of universal marker of that an animal, and particularly a human, is alive. I practice hospice medicine. To this day, I and my colleagues, the way we assess whether someone has died, whether they're still living, whether they still exist or do not, and we just have their remains, is by checking their heartbeat. I'm not an OBGYN, but my brother's an OBGYN. My dad's a retired OBGYN. I have lots of OBGYNs who are friends. And I know that one of the ways OBGYNs, ready ways they check to see if a fetus is still alive, particularly if a mother is concerned, is by checking to see if there's a heartbeat. So that is a marker that I think makes even the layperson recognize that we have a living being.
In your expert report, you opined that abortion entails what you called unjust discrimination. Could you explain what you meant by that?
Sure. So again, personhood is not a term that we used to include people we're going to show moral regard. Notice that. No one goes out and says, well, of course, here's a bunch of human beings, but that doesn't matter. We have to decide which ones are persons so we can treat them well. No, the language is only advanced, as it is in the case of abortion, to set aside those that we're going to be willing to harm, willing to do things to them that we would not do to others. So when that happens, it seems to me that the onus is on those who would set these aside to give a justification for why they don't deserve the respect that we characteristically regard ourselves as owing to all other human beings. And then these answers have been put forward, like viability. Like the plaintiffs have emphasized that the fetus is radically dependent on the mother's womb. It's true. It's also true that a newborn baby is radically dependent on care. And that,
but not necessarily the care of
that's right,
the woman in whom the prior fetus had been growing.
That's
the
absolutely
state can
true.
step in and we're going to fund adoption, foster care, et cetera, in a way that they can't pre-viability.
That's right. I mean, so it is the case that a fetus prior to viability cannot survive outside the mother's womb. Now, generally in ethics, we don't consider vulnerability or dependence an indication that we should lessen our regard. We actually the opposite, right? I mean, when you find a kid who's lost in the woods, you don't think, well, that kid's lost, I don't need to help them. You think, no, they look like they're in special need. We have special obligations. It seems to me that the reasons to justify killing fetuses are reasons that are arbitrary. They're not reasons that give a sound basis for setting aside these for a treatment that we would not permit for any other human beings.
Well, doctor, can abortion be ethically justified on the view that abortion is safer than carrying a pregnancy to term?
In my opinion, no, and here's why. First, I mean, is it Bedell? Who testified? Bedell, sorry. Dr. Bedell pointed out, and this is common knowledge, a woman may not be able to get pregnant. And so what happens when a woman can't get pregnant? Doctors see her and they very naturally say, that's a problem. That's a sign of a deficit in health. And so they do things to try to help her recover the dimensions of health that allow her to become pregnant. Pregnancy is a sign of health. It is true that pregnancy brings certain health risks, as other signs of health do. The fact that someone can run is a sign of health, but running puts you at risk of certain injuries that you're not going to suffer if you don't run. Here's the thing, OBGYNs, and I observe them and I talk to them, they do not treat, nor should they, the condition of pregnancy as a condition in which someone has a risk that would lead them to do something like kill their fetus, unless the woman has already decided, I want the fetus to be aborted. It's not the case that a person shows up pregnant and you say, well, and with a smile and says, I'm excited, I'm pregnant. And the OBGYN say, well, we need to refer you to someone who can provide an abortion because it's dangerous being pregnant. No, there are real, but small risks of complications with pregnancy. And our characteristic approach to that in medicine is to attend to the health of the woman while preserving the health of the fetus. There is no proportionality between the risks of pregnancy in the usual case when someone's not having serious illness and intentionally killing another human being.
Now, you also said in your report that abortion involves unjust discrimination against those with disabilities. Can you tell us a little bit about that?
Yes. I'm not suggesting that women are setting out, or the abortion providers themselves are setting out to discriminate against certain categories of people. But the reality is abortion does discriminate. I mean, we learned from the plaintiffs that it discriminates against Black fetuses at more than a 2-to-1 ratio. It discriminates against, the practice of abortion discriminates against those who have disabilities. So in the US, the data suggests that more than 2 out of 3, or roughly 2 out of 3 fetuses that are diagnosed with Down syndrome are aborted prior to birth. The disabilities community has been really critical in many figures of abortion because they are arguing that we have a kind of eugenic impulse going on here to escape the difficulty of caring for people with disabilities. We're killing them prior to their birth, which creates a world that's less patient with and hospitable toward those who are themselves dependent and will always be dependent in ways that that require care.
Doctor, is an example children with Down syndrome?
Yes. So as I was saying, about roughly 2 out of 3 from the last study I looked at of Down syndrome babies in the U.S. are estimated to be aborted. In some countries like Iceland, it's virtually all. But that's one of the more common congenital anomalies, and it's one that leads to a lot of abortions.
But Down syndrome is not a lethal condition. It's not considered a lethal condition. Is it?
No, it's not. In fact, up until the early 70s, people, neonatologists would often set aside babies with Down syndrome who had certain other congenital anomalies like heart defects in a way that now is no longer permitted. You must, even if parents refuse them, doctors will take custody in the name of the state of those children and do what's necessary to preserve their health, which I think displays the way we characteristically care for those who are vulnerable.
Let's put up on the screen Defense Exhibit 306. This is an excerpt of a book, Dr. Kurland cited in your expert report. The book is Maurice Levine, Psychiatry and Ethics, 1972. And if we could, do you know what page we need to be on, Josh? Here we go, yes. If you could highlight the bottom paragraph on 304.
Right, and then the paragraph on the top of the right side, I think, is what you want. Oh, no, here it is, yes. So this is Margaret Mead thinking about the Hippocratic Oath and the Hippocratic movement in ancient Greece. This is 4th century BC. And she says, for the first time in our tradition, there was a complete separation between killing and curing. Throughout the primitive world, the doctor and the sorcerer tended to be the same person. He with power to kill had power to cure, including especially the undoing of his own killing activities. He who had power to cure would necessarily also be able to kill. With the Greeks, this distinction was, maybe you can remove those, I can read it here. The distinction was made clear. One profession, the followers of Asclepius, were to be dedicated completely to life under all circumstances, regardless. And she goes on to list a bunch of criteria. So this is something quite fundamental that the profession achieved. Mead is saying it was an achievement of Western culture that we have a profession that people can trust are only going to heal and not going to kill. That idea was sustained from Hippocrates through the ancient world, through the Christian era, in the Islamic world, and into modern times up through the middle of the 20th century, which included the World Medical Association's Declaration of Geneva, in which physicians profess that they will maintain utmost respect for human life from conception, even against threats. And so this is a pretty central idea that it seems to me abortion has started, the rise of abortion in the second half of the 20th century and into the 21st has started to undermine.
Dr. Curley.
When you say, just so I'm following that, you say the rise of abortion, having been pulled into this issue by this case,
Sure.
There were laws and discussions and debates about abortion back in the 1800s. And there's a line of argument that actually abortion was fairly accessible. I don't know how safe it was to women way back then until doctors didn't like other people practicing that trade. And so then they wanted to regulate it so only they could do it. And my point isn't the accuracy of that recollection, but you highlighted the rise of abortion in just the last, we'll call it 20, 30 years. What do you mean by that as opposed to abortion 150 years ago, which wouldn't involve, I can tell that this fetus has Down syndrome, so we'll terminate it because of that. But I have no idea the prevalence or the frequency other than that it happened 150 years ago as well.
So abortion has been practiced throughout human history, including 150 years ago, including, at each point. There are a couple differences. One, at least in the Western world, and certainly in the English-speaking world, abortion was illegal. It was illegal in the common law. It was illegal in Georgia. It was illegal in North Carolina, where I live. It was illegal across virtually every state. And the other thing I was emphasizing is that the medical profession and all of its major associations, including the American Medical Association, were clear, insofar as they ever talked about abortion and its ethics, were clear, this does not belong in medicine. there's no major medical association in history until after Roe v. Wade. I'm not sure exactly when ACOG changed its position, but around that era, that changed that position regarding abortion.
So that's the shift in the 70s that you're referring to.
And then just the numbers are, the numbers, I actually can't quote chapter and verse here, but the numbers of abortions that have been conducted in the last 60 years is staggering relative to historical estimates.
Estimates.
I mean, partly this is world population is much larger, but.
So as a percentage basis, we don't know.
I think we do know, but we don't know with certainty what the difference was.
Okay.
Last question, Doctor. As an expert in medical ethics and bioethics, do you believe that the Georgia Life Act is an appropriate regulation of the medical profession and the practice of abortion?
I do.
Thank you. No further questions.
And I guess technically may be the wrong word, but strictly according to what you've helped me understand, it really doesn't go far enough, because between week 0 or day 0 and week 6, we still have a human being, maybe not with a detectable heartbeat. And I appreciate the example you gave of being able to take your patient's pulse or not find it in hospice. But from conception onward, if we treat the fetus differently, if we're saying personhood begins at heartbeat, we're still segregating a segment of humanity into a category most vulnerable of all, where we're not treating them in the same way.
In my opinion, yes, it's never reasonable, even for those younger than 6 weeks, to intentionally kill them. That being said, practical reason always has to be considered from the vantage of the one who is acting. And if you're acting as a legislator, you have to take into consideration other factors that the practitioner is not, like, can this be tolerated by this society? How will it be workable? What will be the side effects? And so relative to the status quo, this law protects more human beings from being unjustly killed, but it doesn't protect them all.
Okay, thank you.
Good afternoon, Dr. Curlin. I'm Corey Isaacson from the ACLU of Georgia on behalf of the plaintiffs. Dr. Curlin, you testified that part of your academic appointment is in the Divinity School. And in the Divinity School, you're co-director of the Theology, Medicine, and Culture Initiative. Did I get that right?
Yes, that's correct.
Okay. And that initiative teaches students, and I'm taking this from the initiative's website, to bring traditions of Christian thought and practice to bear on contemporary medicine. Is that right?
That's right.
Okay. And as you testified, you're also a practicing physician in the field of hospice and palliative care.
Yes, I am.
You don't practice medicine in the field of obstetrics or gynecology, correct?
I do not.
And you never have?
I never have.
Okay. And you've testified now in a number of abortion restriction cases in recent years, is that right?
Yes.
Okay. And you've always testified in favor of upholding whatever abortion restriction is at issue.
In every case I've been asked by the state defending its restriction on abortion, I've been called by them as an expert, yes.
Okay. Now let's turn, if we can, to your role as an ethicist. I believe when defendant's counsel was asking you about something to the effect of what you base your opinions on as a medical ethicist, you testified that you base your opinions on your training, your research, conversations with colleagues. I think there were some others in that list, but that's what I captured. Is that right?
That's some of the list, yes.
Okay. In that list, you did not include in that list that part of what you base your opinions on, your medical ethical opinions on, is also your religious faith, correct?
That's correct.
You did not include that in the list.
I did not.
Would you say that your Christian faith helps to inform your views on medical ethics?
Well, it depends on what you mean. So Christians have taught you should not kill the innocent. It's actually, we adopted from our Jewish brothers and sisters the 10 Commandments. So in that respect, I think that fundamental ethical idea, do not kill the innocent, is something supported and buttressed by Christianity.
Okay. Dr. Curlin, if I could stop you, I just want to make sure we can pull up an exhibit. It's Curlin 5. The PDF number is page 5 at the bottom of page 5 and the top of page 6.
Okay, in the future, have the exhibit up before or after rather than mid answer to important, complicated question.
My apologies, Dr.
That's
Curlin.
okay.
I'm sorry to interrupt you.
So you should continue answering the question as best you remember where you were.
Yes.
And don't worry about what's on the screen yet. If Ms. Isaacson's going to confront you with something, she can, but only after you get to finish answering your question.
I'm sorry, Dr. Curlin. I think I had thought that you had finished up, and I'm sorry if I
He was in the middle of his.
my fault completely. I'm so sorry.
What I was going to say was, there's no, you can't take medical ethics, for example, and strip from it all of the influences of Christian history and tradition, which has contributed to that, nor could you with Islam or Judaism or other traditions. But to my knowledge, there is nothing that I am arguing that is specific to Christian tradition.
Okay. And I don't mean to imply that there's no place for religious ethics and medical ethics, but I wanted to confirm that you did not include your religious faith in the list of things that you rely on to base your medical ethical opinions on.
You're just concerned to confirm that?
That's what my question was.
Yes.
Okay. And if we can now pull up what I've marked as Curlin 5 for Ms. Anderson, PDF page 5, at the bottom of page 5 and the top of page 6. Okay, and this is from testimony in a Kentucky case that you gave. Do you see where we're looking? So it says, and you also, the question is, and you also agreed, Dr. Curlin, that you try hard to carry your religious beliefs over into all of your other dealings in life, right?
That's right.
And you answered, that's right. Okay.
Can I see this in context? Is that all right?
I have the entire
or you can just shrink it
testimony
down.
if
Can
you
we
want.
just scroll up? I mean, it's,
Just
or take away the
take
call
away
out
the
box.
Yeah, sure.
Great.
Yeah.
And if you like the entire testimony, I have it, but I don't think
So
we have
yeah,
time
so
to
you
go through it.
asked me in the context, you're pointing to a survey I'd done where one of the questions was, we asked people, do you agree or disagree with the statement? I try hard to carry my religious beliefs over.
Don't read too fast the court
I
report.
try hard to carry my religious beliefs over into all my other dealings in life. And you said, would I agree with that statement? I said, if I was taking the survey, I would say yes.
Great, thanks for confirming. Okay, and we can take this down now. Dr. Curlin, so some of your professional work has focused on applying Christian ethics and principles to the practice of medicine. Is that right?
Yes.
Okay, and I'm just going to pull a couple of examples from your CV. So for instance, you've given a presentation entitled Being Present, Why Healthcare Needs Theology in the Church. Does that sound accurate?
I don't remember that talk, but I may have.
It's listed on your CV.
Yeah, okay. I've given a lot
Okay.
of talks, but I didn't remember that one, but that's fine.
And there's also a piece on your CV entitled Solidarity, Trust, and Christian Faith in the Doctor-Patient Relationship.
Yes.
Does
I
that sound
remember
familiar?
Mhm.
Okay. Catherine, if we could pull up Curlin 9, PDF page 11 at the top of the page. Curlin 9. It's okay. Thank you. Page 11. Okay, and we're looking at the top of the page. So in this piece, you argue, and I quote, that the Christian physician must see herself as ultimately called, not by either the good of health in the abstract, nor even the good of health in this particular person, but called by God to minister to this particular person's health in service to a relationship of friendship with God. Did I read that accurately?
Yes, you did.
Okay, thank you, Dr. Curlin. We can take that down. And there was another piece that I didn't see on your CV, but does it sound familiar that you co-authored a piece called Faith Matters, But How, in a publication by Gordon College?
I don't have any memory of that, but.
Okay, I can pass it out to you. Here you are, sir.
Thank you.
Oh, this is not my publication. This is about me.
It's about you. If you look on the second page of it, Catherine, if we could pull up,
Picture of you.
if we could
Right,
pull
so-
up Curlin too,
So maybe,
PDF.
oh, you know what? I guess it is. I don't have any memory of this. but,
Catherine, could you
It's been
pull up-
15 years.
Yeah, it's from 2008, I believe. Curlin
Maybe during your
two.
sabbatical, you can review your CV.
PDF.
I do remember Ryan
Catherine,
Lawrence, with whom I wrote a number of papers. So he must have taken the lead on this one. Go ahead.
Okay, so we're at PDF page 18. Actually, it might be at the 18 in the publication. I might have the PDF page wrong.
It's
Sorry about that.
18 and 19 in the publication here.
Okay, thank you, Dr. Curlin. So let's get to that on the PDF. That was my mistake. Okay, so while we're pulling that up, so in this piece, you and, as you acknowledged, a co-author address some of the challenges of being a religious Christian in the professional space. Does that sound vaguely familiar? I know I've asked you to recollect something from a while ago.
Right. I sincerely don't have any memory of this piece, but go ahead.
Okay, and let's actually go to the next page if we can, Catherine, thank you. And you advise in this piece possible ways that physicians can reconcile competing religious and professional expectations. Does that sound familiar?
I don't know. Can you point me to what specifically you're talking about?
Sure, let's look at, let's start with this. So this second paragraph on the page, another option. So you're giving options for what a religious Christian can do in the professional space when there are competing expectations. And so one option you give, and I quote, is to stay in the profession, but ignore those professional guidelines that encroach on religious teachings. Did I read that accurately?
Yes.
Okay, and if we look down, I think at the next paragraph, where it says a parallel option. So in that paragraph, another option you give is, and again, I quote, to stay in the profession, but promote Christian teaching discreetly so as not to cause friction with supervisors who would disapprove if they knew.
That's not what's up on that.
Oh, do we have the wrong one? A parallel option where.
Okay.
There we go. Does it look like I read that accurately, Dr. Curlin?
You know, it does. I will just say, this is really dumbfounding. I don't remember this piece. I'm not saying I wasn't involved in writing it, but I don't remember it. And I have written extensively about these topics, and this does not sound like it's not the way I would put things. The way I put things is quite clear. I've written a whole book about it. It's not hidden. Number of pieces. To my knowledge, Christianity is one of the greatest contributors to the profession of medicine. It was the things we take for granted, like being cared for when you're sick, not with respecting your other characteristics, was an innovation in the Christian community in 4th century Cappadocia that we've inherited to the present time. I don't think that Christianity conflicts with the practice of medicine in any respect. Medicine properly understood. Christianity does conflict with some practices that have been historically condemned by the medical profession, but more recently are being accepted, including elective abortion and including assisted suicide and euthanasia.
Okay.
But in my judgment, those are not medicine. Those are uses of medical capacities and medical intervention, medical technologies to achieve goals that actually contradict medicine's purpose, medicine's healing purpose.
Yes, I understand that's your opinion. Thank you, Dr. Curlin. Okay, I think we can take this exhibit down. Oh, actually, speaking of exhibits, I would like to actually enter this into evidence because it is not currently part of either party's exhibit list. I don't know what exhibit number we're up to for plaintiffs. Do you know, Ms. Anderson? We're not in the 600s. I can tell you that.
You'll get there.
There's not enough time to get there. Sorry.
149. Okay, I would like to enter this into evidence as plaintiff's exhibit 149. If I
All right,
can.
the surprise article co-authored by Dr. Carl.
Putatively co-authored, and maybe
Yeah,
so.
Dr. Carl.
Has that been admitted? May I continue?
Oh, it is,
Okay,
yes.
Great, great. I missed that. Okay. Now, Dr. Curlin, if we can, let's turn to some of the issues specific to this case. So you say in your affidavit, and as you were discussing with the judge before, you rendered an opinion in this case that the human heartbeat, let me just get the language correctly, is a universal marker that a living human being is present.
Yes.
Correct. But as you've alluded to before, you believe that human life actually begins at conception, not at the point of cardiac activity, correct?
Yes, it does, in fact.
Okay. And you believe that a fertilized egg is a human being?
From the point of a zygote, from fertilization, that's a human being, yes.
Okay. And that's your expert opinion as a medical ethicist?
That's my expert opinion as a medical ethicist and a physician and a biology major and a person who understands the science.
Okay. And it's also your religious belief?
It's not a religious belief at all.
You don't have a religious belief that human life begins at conception?
No, is there a religious belief that human life begins at conception?
Is your religious belief that human life begins?
It's not a religious belief at all.
Okay.
I mean, it doesn't contradict a religious belief, but
Mhm.
it's not a religious belief. It just is a fact.
But the question is, do you have, in addition to your scientific fact perspective, a religious perspective that life begins at conception?
I don't know what that means, honestly, Your Honor. It is true that I
guess the science teaches you X, your faith teaches you Y. Are X and Y the same thing?
What my faith teaches me is that every human being is to be treated with regard as made in God's image. All right, that's a religious account, a religious way of describing what makes human beings persons, deserving of moral regard, something we can't treat like we would treat other animals.
So your religious belief is that a fertilized egg has the moral status of a person. Is that a religious belief?
It is deserving of that basic moral regard that we owe to all human beings. Yes.
Okay. Let's move on then. Thank you. So your belief that a fertilized egg is a human being informs your belief that terminating a pregnancy is unethical from the moment of conception. Is that correct? Unless necessary, as you say, to prevent grave injury or death to the pregnant person.
Yes, I think it's never fully reasonable to intentionally kill an innocent human being.
Okay. And so you believe it's actually unethical to permit abortion up until detectable cardiac activity, as the state's ban does here.
Yes, we were talking about that earlier.
Okay. And now the state's ban also allows for an abortion in the case of rape or incest, only if a police report is filed. Is that your understanding of the law?
Yeah, and seriously, you're now speaking so fast that I can't follow your questions.
I'm so sorry. And I'm sure the court reporter feels the same way then. So let me repeat. So the state's law allows for an abortion in the case of rape or incest if a police report is filed.
That is my understanding,
Okay.
yes.
The expert affidavit that you submitted in this case is silent on the topic of rape or incest. Is that right?
I think that's right, yes.
And you don't believe an exception for rape or incest is ethical. Is that right?
It's not that I don't think, no, this goes back to the brief dialogue with the judge. I don't think from the vantage of the one considering whether to seek an abortion or to perform an abortion, it's reasonable, fully reasonable to perform an abortion, because if your reason for doing so, since abortion is killing an innocent human being, if your reason is doing so is that this human being came about as the result of a horrible crime against this woman, that's not sufficient reason to kill the fetus, it seems to me. From the vantage of a legislator, I think that kind of a carve out could be sensible, all things considered, because recognizing that those who have suffered sexual violence are in a terrible situation and that it's just, that's going to be one area where we're not going to draw the line. So I think those are can be both true.
Well, Dr. Curlin, I'm not asking your opinion about what's politically feasible for a legislator to pass or not pass. I'm asking your ethical opinion. So I just want to be clear.
Well, no, let me be clear. That is an ethical opinion. It's an opinion about the ethics of the law. Is the law ethical? I'm saying I don't think it's fully reasonable or ethical to seek an abortion or to perform an abortion in that case.
Mhm.
But I do think the law is ethically justifiable, recognizing that whether you're going to pass that law and what carve-outs you're going to allow is something you have to consider with taking into account all the considerations that a legislator has to consider that a clinician or a patient does not.
Okay.
So would a law that instead of at 6 weeks heartbeat, it's viability for lots of important policy reasons, whatnot, would that also be legally ethical if what the legislature was thinking about was all sorts of things that they think about, but drawing that line at viability instead of at the heartbeat?
In my view, that would be less ethically defensible for two reasons. One, your hostility toward, and by hostility I mean this technically, because the abortion in those cases, their intention is to secure a dead fetus. The hostility is because of a condition of the fetus that's just vulnerability. It's need for care. It's inability to survive on one's own. In this other case, a woman has suffered a sexual violence and has in a very real sense been violated and is in a posture understandably of defense against all that entails. So I think they're different.
They're not mutually exclusive either. There could be instead of 6 weeks, it's viability, and there is the exception for rape and incest. I wasn't contrasting the two. I had shifted gears, and that wasn't necessarily fair. I didn't broadcast that.
Yeah.
But you were talking about a different form of ethically acceptable. And this is the first time I heard it from you, that legally, ethically acceptable to have a law like Georgia's is now. Not medically, ethically acceptable, but legally. And so you introduced that phrase, and that got me to thinking, well, what about the way the law was prior to the enactment of HB 481, where there was still a carve out for medical emergencies, and I assume there was, I don't know, and for rape and incest, but the line wasn't cardiac activity, it was viability.
Right.
And you're saying it is less ethically defensible because, one, you're increasing the time frame during which an innocent life is taken.
More lives are taken. Yeah.
More lives are taken.
Fewer lives are protected.
Okay.
Yeah.
Okay, just one final question, Dr. Curlin. So just to be clear, in your mind, if a 13-year-old girl, God forbid, is raped and ends up pregnant, the ethical outcome is for her to carry the pregnancy to term.
In my view, the horror of the tragic and awful and evil assault that results in someone being pregnant through sexual violence is not remedied or resolved by killing the fetus.
So
the fault does not, in my view, belong to the fetus, and therefore the best response, and by best I mean the most reasonable response, is one of lament, vigorous prosecution of the person who caused the violence, and every manner of support that can be brought around that young woman who has suffered so terribly, which would include supporting her in bringing this innocent, tiny little human being to term, and then helping her care for that baby or give it up for adoption or whatever other choices are possible.
thank you, Dr. Curlin.
Sure.
Mr. Bartolomucci, any redirect?
No, sir.
All right, Dr. Curlin, I appreciate very much your time and our exchange. Are you flying back to England immediately? You're going to make it.
I'm going to make it.
But I would leave soon.
I will.
All right. All right, why don't we take a break? Let's try to be back as close to 4 as we can all make it, assuming Ms. Stevenson will support us at 4 o'clock. Is Ms. Neesmith next?
Yes.
And that's it?
I believe the state of Hollywood.
No, we have Dr. Jeffrey Wright.
Oh, I didn't mean to cut anyone out. So who is next? Is it Ms. Neesmith or is it Dr. Wright? Nesmith. Okay. All right. And then Dr. Wright. Oh, look at that, Dr. Wright.
Hey, Julia. How you doing? Thank you. No, come on, let's go. I was just saying, no, you didn't have to. It's over. Yes.
You're having to yell there. You might take the mask off. You get you a gavel. So before we get going with the next witness, Stevenson has noted that the exhibits need to be uploaded to something called Planet Depots or Depots. Stone's nodding her head. I don't know. Yep, Mr. Field. Okay, great. From yesterday and today. I don't think that has to happen now, but I just want to make sure everyone knows their homework assignment, not from me, but from the court reporters you're technically paying. They're somehow giving you work, but that's a good gig. Make sure exhibits are being uploaded. All right, let's press on. Is Ms. Nesmith here?
Yes, Your Honor.
Great. You get two witnesses.
I do.
All right.
Your Honor, Alice Wong again from the Center for Reproductive Rights, and plaintiffs would like to call Gloria Nesmith to take the stand.
All right, Ms. Nesmith, come on up, please.
Your Honor, if I may.
Mr. Prince is requested to be admitted to the Zoom.
I just noticed he was back in the waiting room. I don't know what happened.
Internet dropped, Your Honor.
All right.
Can you raise your hand? You swear affirm that testimony you will give the truth, the whole truth, and nothing but the truth, so help you.
I will.
Go ahead and say and spell your name for the record.
My name is Gloria. My last name is Nesmith. Gloria, Gloria, Nesmith, Nesmith.
Good afternoon, Ms. Nesmith.
Good afternoon.
Thank you so much for coming back to join us for a second day. Where do you work?
I work at the Atlanta Feminist Women's Health Center.
Hold on one second.
Could we state who is doing the questioning of the direct and cross on this witness, please?
Sure.
Yes, Ms. Stevenson, this is Alice Wong from the Center for Reproductive Rights for Plaintiffs.
And who will be handling it for defendant?
Chris Bartolomucci, Your Honor.
Great. 3 witnesses.
Could you restate that person's name, please?
Mr. Bartolomucci, same person who handled the last witness.
Thank you.
You bet.
Ms. Nesmith, you were in the middle of answering the question, where do you work?
I work at the Atlanta Feminist Women's Health Center.
And what is your role at Feminist?
I work as the ultrasound technician.
How long have you been the ultrasound technician there?
I've been the ultrasound technician there about 25 years.
And what are your responsibilities as ultrasound technician?
It's my responsibility to date the pregnancy, give that woman the information, to make sure there's no abnormalities that might interfere with her having a safe procedure, and also give information about maybe birth control, as well as just other health information that answer questions. I've been working there a long time, so I get lots of questions.
How long have you been working at Feminist?
This is my 31st year working at Feminist.
What other roles have you had before you were ultrasound technician?
I worked there as a health educator. I worked there as a clinic coordinator and a telephone counselor and a clinic supervisor.
You've worn many hats at the clinic.
I've worn many hats there.
And Ms. Nesmith, what inspired you to go to work for Feminist?
I needed a pregnancy test in the 90s, and a friend of mine told me that I could go there for a free pregnancy test. And when I went there for the pregnancy test, there was an army of protesters out in front of the building. And that's when it occurred to me that not only did they provide, women's health services, they also provided abortions. And it reminded me of my own experience having an abortion when I was younger. And I didn't have to go through that. And it kind of bothered me that I had to go through that just to get a pregnancy, just seeking a pregnancy test. So I inquired about how I could volunteer because they had some escorts to help women get into the building safely. And the informational session led to an opportunity to work there. And it's been 31 years.
Thank you for sharing that, Ms. Nesmith. If you feel comfortable, will you briefly share the circumstances around your making the decision to have an abortion?
Well, I would say that the decision was both traumatic and very private. And I was 18 and about to go off to college. And it was the best decision I could make for my life at that particular time.
And why is that? What would having a child at that time have meant for your life?
I would probably have gotten stuck in that small town I was in and never been able to just advance my life and my career, my, stretch my eyes and arms and go to college and have those opportunities that I've had. It's nothing I regret. I feel like it's one of the best decisions I could have ever made for my life at that particular time.
And do you have any children now, Ms. Nesmith?
I do. I have a 29-year-old, I have a 24-year-old, and I have a 22-year-old.
Do you work anywhere else aside from Feminist?
I do. I work at Emory. I work with the School of Nursing as a research coordinator and interviewer as well. So I work with people who are living with HIV, who are struggling with medication adherence.
And aside from your jobs at Feminist and at Emory, are you pursuing any other work?
Most recently, I have become, I'm going through training to become a birth doula. So that's been another rewarding thing that I've done to just contribute to women's reproductive health. I became really concerned about the maternal death rates in our state, which are really high in Georgia. And I saw that our reproductive rights were going to be under attack. So I figured I'd get ahead of helping women be able to have babies safely and without the high statistics of the death rates in Georgia, particularly how they affect women who are African American and women who live outside the metro Atlanta area. And I'm both of those things. I'm African American and I live outside of the metro area where the rates are naturally higher in Georgia.
The rates for maternal complications or maternal mortality.
Yes. Thank you, Ms. Nesmith. I'd like to now transition to talking a little bit about the law at issue in this case, Georgia's HB 481, which prohibits abortion at detection of cardiac activity around 6 weeks of pregnancy. If I refer to HB 481 as the ban, will you know what I'm talking about?
Yes.
Have you administered ultrasounds at Feminist since the ban took effect in July of this year?
Yes.
And has your job as an ultrasound technician changed since the ban took effect in July?
I would say definitely and significantly. I think my job has definitely become more stressful. Typically, I'm dating a pregnancy and giving women that information with the expectation that they will move on to have the procedure they've consented to have. But this tissue reminds me of the fact that I change out my tissue box more than I typically would ever these days. I think that we have more of an instance of women who cry, maybe tears of complete relief, as well as having to tell women that they're going to need to be referred to another state. It's typical that women can be sad sometimes. Having an abortion is a pretty complex issue, and women come to us with a variety of reasons. So tears are normal, but I see a whole lot more lately because of the ban.
To your knowledge, Ms. Nesmith, has Feminist made any changes to its schedule since the ban took effect?
Yeah, we used to provide services 5 days a week, and we're only providing services now 3 days a week. I can't assume that women are going to other states. That might be the assumption, that women have to go to other states, or they are just too far to be able to receive services at our clinic. So one of the other things are happening.
Do you know whether Feminist screens patients seeking abortion prior to their coming into the clinic to determine whether it's likely that cardiac activity will be detected?
Yeah, we do a telephone screening. That's as much as we can do, is to find out when their last normal period was, to make the best decision about if a woman should come to us as opposed to going to a state where they might be more sure that they can get the procedure done. A lot of times the phone counselors are looking at, what their resources are, how easy is it for them to travel, with what's going on in some other states. It might be easier for her to fly here, but not all women can fly here and then plan to go somewhere else if they're too far. So they'll just plan to go somewhere else, first. But we try to get as much information as we can when they're on the phone to give them the best possible scenario for being able to acquire their abortions.
if it becomes pretty clear to the telephone consultant that the woman is 10 weeks pregnant, just very clearly past 6 weeks, is there a set dialogue of, we can offer you lots of advice, but we can't offer you services because it's plain that you're at 10 weeks or 12 weeks?
Absolutely. Particularly looking at the complexities around women coming, if they're coming particularly from another state, if childcare is an issue, these are things that could waste their time and financial resources if they came to us first. So we try to give them the best possible scenario that would make it most easiest for them to get abortion services.
So to piggyback on Judge McBurney's question, are the patients that you're administering ultrasounds to at the clinic the ones that are screened in over the phone based on that conversation?
Yes.
And are you personally seeing fewer patients for ultrasounds per week since the ban took effect?
Yes.
Since the ban took effect, have you personally had to inform patients that you detected cardiac activity so they're too far along to have an abortion in Georgia?
Yes, that's probably one of the harder parts of the job. That one of the things that's different. And for lots of circumstances, I had, particularly, I can think of a case in just the last few weeks where I had a woman who, she came in, well, she had an appointment to come in and she couldn't make that appointment. She had childcare issues and was not able to come, and rescheduled for a week later based on her last normal period. Rescheduled a week later, and once again ran into having a childcare issue. So she ended up coming in 3 days after that, week later. And it turns out maybe she was about 6 weeks and 4 days or so, and cardiac activity was detected. And she was devastated. I mean, devastated, like inconsolable, devastated. My room is about the third room down the hallway. And after I calmed her down enough to get her to a room where one of the counselors were, that's like 3 rooms down. And I could still hear like audible wailing. She had no other option for childcare. And the thought of her having to figure out how she was going to go to South Carolina, I think was where we would refer her to, was just not something that seemed doable. For a lot of our patients, their childcare is what happens in between putting their kid on the bus in the morning and picking up their kid in the afternoon. And there's no time to go to South Carolina when something like that, if you've got to get a medical procedure in between that little gap of time. So women's situations vary. I had another patient who wanted time to think about having the abortion and felt like she had the time based on her initial ultrasound. And we are always going to not do an abortion if someone's ambivalent in any reason. And she felt like the ban was rushing her and to make a decision, and she really needed the time. So she decided to take some additional time. And then of course life happens. And by the time she came back, ready to terminate her pregnancy, doing the ultrasound again, because we repeat the ultrasound on the day of service. What we didn't see the first time, because she was quite early, was that now that there was one pregnancy, now there's 2. So that put that woman in a situation where she took the time to think about terminating a pregnancy, and now she's got cardiac activity and twins. So for her, that was pretty devastating. So those things make the job a lot harder than it used to be.
I can only imagine, Ms. Nesmith. Thank you for sharing those stories. Approximately how often have you had to turn patients away based on cardiac activity on their ultrasound since the ban took effect?
Every clinic day, typically we turn women away. I don't have all the numbers just because I don't count patients like that, but I don't have all of the numbers, but we do turn women away, at least one or two a day, sometimes more. It depends on the volume of patients that we see.
And Ms. Nesmith, you also mentioned seeing tears of relief since the ban took effect. Do any such patients stand out in your memory who cried tears of relief upon finding out that they could get their abortion at Feminist?
I had a patient recently that, and this one sticks out in my mind particularly because she, when I called her to back to the room, she was very disheveled and she was like physically shaking. And at first I thought maybe she had some type of physical disability until I realized she was just that nervous. So I thought it was nervous just about, being there. And so after I explained to her what I was going to do and that she could relax, she kind of never stopped shaking. I had to take the things from her hand and put them on the table. And so I performed her ultrasound and she kept saying, "What do you see? What do you see?" And I finally said, "So you can relax. It looks like you're about 5 weeks." I said, "I'm only seeing a very small sac. There's no cardiac activity." And she kind of grabbed my wrist and she just began to sob. And it was at that point I looked at her and I noticed that she did have a scarf on her head and she didn't have eyebrows. And she began to tell me that she was an ovarian cancer patient and not, being pregnant would have been an issue with her continuing her treatment. That was like a major thing for her. And that really sticks out because she needed life-saving treatment and being pregnant would have been just another thing. And another case that sticks out is one I can relate to a little bit because this woman was in her 50s and I'm in my 50s. And she said to me that she felt different and her husband had been moving their son into college, her last child. And she felt different and she'd only felt that way before when she was pregnant. And she was like, "I'm 50. My doctor told me that I was going through menopause. She'd had her IUD taken out like 8 months prior and did not think she could get pregnant." And she says, "I only felt this way when I was pregnant." And so she said that her husband thought she was complete nut. And they went to CVS. She got a pregnancy test and she was pregnant. And, she's 50 and took her last kid to college. And she was really relieved that she did not have to go to another state or have to deal with the decision even of having to make a decision that was already more difficult by there being cardiac activity, but there was no cardiac activity and she was completely relieved. And once again, relied on that box of tissue that I have that lives on my counter. So I think I get both sides of tears since the ban, different types of tears since the ban.
Thank you for your testimony, Ms. Nesmith. I have no further questions.
Mr. Bartolomucci.
Thank you, Your Honor. Ms. Nesmith, my name is Chris Bartolomucci. I'm one of the attorneys representing the state of Georgia in this case. Could we put our exhibit up on the screen and I'll pass out hard copies.
Thank you.
Now, Ms. Nesmith, I've just given you, and we have on screen an article. Do you recognize this?
It looks like the article I did with the Lily.
Got your name in it.
A Washington Post article. And it looks like my room where I work, my favorite picture of the sunflowers that all the patients comment on.
No box of tissues.
My box of tissues, you can't see the box of tissues. It would be like in that on the desk area that's behind the chair there.
So the author interviewed you, correct?
Absolutely.
And quoted you in the article.
Absolutely.
Okay. Your Honor, I would move this exhibit into evidence as defense exhibit number 621.
Any objection, Ms. Wong? 621 is admitted.
Ms. Nesmith, on page 1 of the article in paragraph 2, it says that on the day you were interviewed, you were wearing a T-shirt that said "Feminist Forever." Is that true?
Yes.
Was that a reference to the name of your clinic or feminist beliefs or something else?
Well, we're a feminist health center, so
Okay.
it's a little bit of both.
All right. And if we could flip to page 3 in the second paragraph, there's a discussion about the women who come into the clinic. And the article says, quote, even if they know they're pregnant before the 6-week mark, she says, it will often take weeks for them to make the decision, talk things over with the father, and raise the money, anywhere from $400 to $1,800, end quote. Is that what it said?
Yeah.
Is that what it costs to get an abortion at the clinic?
That was an approximate. I don't work in the insurance part. I don't work in the finance part. So I'm not sure the exact cost of the abortion procedure.
Bless you.
Does the clinic make women pay for their abortions up front, or may a woman pay after she receives an abortion?
I don't do a lot of the finance part of it. I typically send women after they've gotten their ultrasound to finance. I'm not sure I don't work in finance, so I don't know.
Okay, I appreciate you don't work there, but do you know whether a woman has to pay up front or can pay later?
I think those things are specific to the woman and whatever her personal situation is, whether it's insurance, self-pay. That's not something I would know.
Okay, now also on page 3 here, there's a photograph. Is that a photograph of the workspace at the clinic?
That's a photograph of an office at the clinic, but that's not my office.
It's not your office, but you've seen this.
Yes, I've seen, we have beautiful artwork throughout our clinic.
Okay, there's one thing I gotta ask you. Near the bottom, there's this bumper sticker that's cut off. The top says, "May the fetus you save turn out to be a," and then the bottom half is cut off. Do you know what the rest of it says?
I absolutely don't. Like I said, that's not my personal office. And I typically go in the ultrasound. In fact, that office is not even an office that's upstairs in the clinic. So that's not an office that I would frequent.
Okay, let's go to page 4, where it says in the first paragraph, before clinic administrators issued a formal rule against it, she would sometimes invite out-of-state patients to stay overnight at her house, or if they were young and traveling alone, offered to stay the night with them in a hotel, end quote. Did you see that? Now, did you in fact stay in hotels with young women traveling alone?
Yeah, we did that back in the 90s when it was okay to do that, before there were different privacy laws, before HIPAA. Those things are newer in healthcare. They were not an issue in the 90s. And yes, we had volunteers, volunteer organizations. Women travel from other states and are alone. And that part of our services, not as healthcare providers, but as volunteers and people who care about women, is to not leave them alone.
So at some point, the clinic said, you can't do that anymore.
Exactly. There's HIPAA, privacy laws, safety, the state has different regulations and things that they implement throughout the years. Healthcare changes. HIPAA wasn't a thing several years ago either.
So let's turn to page 5, where we have another photograph. Is this a photograph of the office of the executive director, Ms. Jackson?
It's possibly an office of, there's a lot of artwork throughout the clinic. And what you must know is the administrative offices are different from the clinic. So I don't go in every office in the clinic. I frequent the clinic, not necessarily the administrative offices.
Have you seen this space somewhere in the clinic before?
I've seen lots of artwork in the clinic. I could not recall where I saw this, if I saw it.
Okay.
It's, I mean, like I said, there's artwork all over our clinic, particularly on the first floor, which I don't frequent. I'm not a part of the administrative staff. I'm a part of the clinic staff. I spend most of my time in the ultrasound room.
Do you recall seeing this poster that says, fuck the system, spelled CISTEM, and death to capitalism?
I've never seen that before. To
Okay.
say that I've walked past it and seen it in the clinic. I've never seen that before. I can't say that it's not there, but it's nowhere that I frequent in the clinic.
Okay, so on page 6, if we could go to that, in the first paragraph, there's a line that says, Nesmith hasn't told many people that if the bill goes into effect, she plans to stop administering ultrasounds, end quote. You didn't quit your job at the clinic, did you?
I didn't, that was in 2019 when we did this article that was right after the ban. And just as anyone who's grieving and shocked that something's happening, that change is coming, it's only a normal reaction to grieve a little bit. And I think that statement was based on just some grief. But what I realize now is that women need us more than anything now. And they definitely need people with experience and people with commitment and longevity like myself.
Now, it also says on that page, it's up to Nesmith to analyze all the information she's given and decide whether an abortion is legal. Now, when you make a decision about the gestational age of a fetus, does that get reviewed by anyone else, like a doctor?
Absolutely. There's not an ultrasound that I perform that doesn't get reviewed and signed off by a physician.
Okay, so it's not your sole decision.
It's not my sole decision. That's not my quote either.
Now, you testified that women you turn away because they're past the gestational age or, maybe devastated or inconsolable, right?
Mm-hmm. Definitely.
Now, do you keep in contact with the women you have turned away after they leave the clinic?
No.
So you don't check on them weeks or months later to see what their mental state is?
No, that's not my job as
Okay.
as an ultrasound technician.
Is it possible that some of the women you turned away decided not to have an abortion?
That's very possible.
Is it possible that some of the women you turned away later gave birth?
That's possible too.
And is it possible that some of the women you turned away later gave birth and loved their babies with their whole heart?
That is possible too.
Thank you. No further questions, Your Honor.
Any redirect, Ms. Wong?
No redirect, Your Honor. Thank you.
Ms. Nesmith, thank you for being here. 2 different days. 8D, you're always welcome to come by. All right, I think that leaves us with Dr. Wright.
Judge, would you mind telling us how much time is left so we can plan accordingly?
Yes, great question. You have 35 and a half minutes and plaintiffs have 30 minutes and 7 seconds. So about a half hour each.
Perfect.
Which works just right.
I do. My name is Jeffrey Wright, Jeffrey Wright.
Your Honor, for Dr. Wright's benefit, I just handed him a copy of Dr. Bedell's 2 affidavits in the case, which I believe have already been distributed to the rest. Dr. Wright, my name's Ed Trent. We've obviously met before, but that's for the benefit of the court reporter. Could you please introduce yourself to the court?
And so the court reporter knows Ms. Stone will be doing the cross-examination?
Yes.
So we've got Trent and Stone.
I'm Dr. Jeffrey Wright. I'm a specialist in maternal fetal medicine. I did pre-medical studies at the University of Houston, medical school at the University of Texas, Health Science Center at San Antonio. From there, I went to Wilmington, North Carolina to seek training in rural OBGYN and a residency in Wilmington. After 2 years there, I realized I really wanted to be a maternal fetal medicine doctor. So I returned to San Antonio, Texas, completed my residency, completed the fellowship, and after that returned to Wilmington to work in an underserved area.
And how long have you been practicing?
32 years.
And are you board certified in that position?
Yes, I'm board certified in obstetrics and gynecology and maternal fetal medicine.
Now, can you describe for us what a maternal fetal medicine specialist does? I know we heard from Dr. Bedell earlier. Is there anything different between the way you practice and the way she does?
No, the maternal fetal medicine, other people call it high-risk pregnancy. It covers women with medical illnesses prior to pregnancy. It covers illnesses that are unique to pregnancy, occur only in pregnancy. And then it covers a lot of fetal diagnosis.
Now, the court has your CV as Defense Exhibit 23, but on there it has a title, FACOG. Can you tell us what that is?
I'm a fellow of the American College of OBGYN.
And in your position as OBGYN and maternal fetal medicine doctor, have you had training then and experience on the development of human fetal development?
Yes.
It's something you learned in medical school and have known intimately?
Started in college, then medical school, and of course, through the rest of my training.
And have there been points in your career where you actually performed abortions?
Yes.
Now, your CV also mentions that you develop best practices for general obstetrics and inpatient high obstetrics. Can you briefly describe what those are?
Well, basically, the concept of best practice means that there is an evidence base for the way medicine is practiced, and through thorough research of the literature and using guidelines from ACOG, from the Society for Maternal Fetal Medicine, and in fact, worldwide, you can develop a pattern, a plan for best managing complicated pregnancies. And so I started that really back in the late 80s. And now there's somewhere 100 to 200 of those that reside in our electronic medical record.
Things that you created?
Yes.
All right. And in your training, are you familiar with multifetal reduction?
Yes.
Your Honor, I would tender Dr. Wright as an expert in maternal fetal medicine and fetal development in clinical medicine.
Ms. Stone, any objection?
No objection.
All right, Dr. Wright, you are qualified as an expert for the purposes of this trial in the field of maternal fetal medicine and the other words Mr. Trent said.
Dr. Wright, do you have a medical opinion on when human life begins?
Human life begins when the sperm fertilizes the egg, the moment of conception, when that new human being becomes a genetically distinct person.
So why is that the start of human life?
That's the start because that is when that distinct, unique person is formed.
Now, is there any medical or scientific debate about the process of human development beginning at the time of fertilization?
There's no real debate about that. The human embryology was worked out for the most part years ago.
Now, is this
Can you say for the most part? I mean, just technical stuff on the edges or what wasn't worked out for the most part?
I don't want to say that 100% of things, because I'm sure there's some embryologists applying for a grant about
that needs more study. Okay.
The majority of embryology, it's not really new. It's not something that's working on right now. They had that figured out when I was in medical school in the 80s.
So the conclusion that human life begins at fertilization isn't something simply relegated to religion and philosophy. It's actually a medical conclusion.
That's correct.
I'm going to show you what's been marked as Defense Exhibit 25. Can you tell me what this exhibit is?
This is a chart from the CDC that I found while trolling the internet.
All right. And it shows basically the development post-fertilization, starting with weeks 1 and 2. That would be then beginning at the time of fertilization. If we put it in terms of last menstrual period, do we simply add 2 weeks to these numbers?
That's correct.
And so it shows in the development of the human heart, beginning in week 3, but being developed in weeks 4, which would be 6 weeks LNP.
That's correct.
And is that human heartbeat detectable in that 6th week?
Yes, it's 6 weeks. The heartbeat is detectable.
Now, have you reviewed the Life Act, the Georgia law at issue here?
I have.
Now, if human life begins at the moment of fertilization, what does that tell you about the Life Act that gives legal protection to that baby only when a heartbeat is detected?
Well, I think the Life Act is a compromise between different viewpoints.
I'm going to show you Defense Exhibit 26. Can you tell me what this exhibit is?
Well, there's an image of a 6-week embryo, and you can see the heart, and then this 9.5-week little baby That I believe is a hysteroscopic picture. And then the picture of the 23-week baby, that's a 3-dimensional ultrasound.
Now, references here that by the time the heartbeat is detectable by 6 weeks, the heart typically beats between 105 and 160 times per minute.
Yeah, I think that's accurate.
So relatively rhythmic process for this baby's heart.
Yes.
And is that the same heart that will beat for this child all the days of its life until it dies, even if at 100 years old?
That's correct.
Are you familiar with an ultrasound in a 6-week-old unborn baby?
Absolutely.
And have you conducted many of those?
Many.
And what's the purpose of conducting an ultrasound that early in pregnancy?
We look for how many fetuses there are, how many gestational sacs. We look for where those gestational sacs are located. Are they located within the uterine cavity itself? Or are they located outside of the uterine cavity? And then, of course, we look for heartbeat.
Now, if a pregnancy is outside the uterine cavity, what do we call that?
Ectopic.
And are those dangerous?
Yes.
And does the Life Act speak to how ectopic pregnancies are handled under the statute?
Included from the Life Act.
Now, you mentioned that determining the presence of a heartbeat is part of what is done that early in pregnancy. Is that part of standard of care established by ACOG?
Yes, it is. There's a variety of organizations, even radiology organizations that make those standards of care. And there's always, as part of that, is examining the heartbeat.
All right. I believe that's set out in Defense Exhibit 339, the ACOG Bulletin 175. If you reviewed that in preparation for your testimony?
Yes.
And that would be consistent?
Yes.
I'm going to show you Defense Exhibit 28. Sorry to move so fast on you, Mr. Prince.
Can an ectopic pregnancy come to term, or the fetus has no chance of surviving because it's outside the uterus and it's just bad news for the mom?
Well, I wouldn't want to say, no chance. So I have seen an abdominal pregnancy delivered at term, a 7-pound baby located in the abdominal cavity. And so, the human body is what it is. There's always going to be some crazy things. And there is a phenomenon called a cesarean scar ectopic pregnancy. There's a lot of debate because those babies can often survive, but at the cost of the mother's uterus, blood transfusion, intensive care unit stuff.
Now, for Defense Exhibit 28, have you reviewed this exhibit?
It's not showing.
I think we're going to try and get that up. Just pause it. Can you tell us what this is?
That's a 6-week baby. You can see the heartbeat visually, and then, of course, you can hear it with the Doppler.
All right. As it plays, can you describe for the court what we're seeing?
You're seeing the heartbeat. You're seeing cardiac muscle contracting under the rhythmic coordination of the electrical system of the heart.
Okay. And those were the lines that were to the right of the screen here. And what's in the middle of the screen? Is that inside okay? It's a baby inside the uterus?
Yes.
Now, if we can go to the part of 1 minute and 15 seconds, there will be some writing on the screen. Can you tell us what the CRL is?
Crown rump length.
And what does the 0.77 centimeters represent?
That represents the length from one end of the embryo to the other.
And in the ACOG bulletin that we looked at, 175 earlier, that we referenced Defense Exhibit 339, does it indicate that's about the size you would expect to find the heartbeat?
Yes, exactly.
And then the gestational age that was listed said 6W, 5D, plus or minus 4D. What does that tell you?
6 weeks and 5 days, and the range of error in the measurements 4 days.
Now, the baby's heartbeat that was, were you able to actually see that on this picture?
Yes, you can see it in the 2-dimensional image, and you can see it in the spectral Doppler display as well.
Is that heartbeat simply electrical impulses through some cells that will one day become a heart, or is it something more definitive?
No, there's a heart there. Now, that heart hasn't finished developing, but there's a heart there.
Now, when we heard the sound at the beginning of the ultrasound, what was that?
That was the heartbeat.
All right. And does that sound actually originate from the child that's being played back through the ultrasound?
Yes, it is.
Now, I'm going to show you Defense Exhibit 27, which will be a second ultrasound a little bit closer up on the unborn child. Recognize this?
Yes.
What is that?
That's a fetal heartbeat.
That's the moving pixels to the left of the screen.
Yes.
Simply the way the technology shows it. All right. The sound we're hearing?
So I need you to stop the video for a second. The court reporter can't hear what people are saying when it's playing. So great to play it, but then need to pause it for questions and answers.
Okay. I think we've heard it. So the sound we were listening again is what?
Is a heartbeat.
Is there any really debate in the medical community about the fact that at 6 weeks, the baby's heart is developed to the point that it's begun pumping blood through its body?
There's no debate about that.
And if the baby had died, would the ultrasound pick up a heartbeat either visually or audibly?
No, the lack of a heartbeat defines death.
Now, in your research, have you reviewed any studies on why women seek abortion?
I have. I've reviewed a number of those over decades.
Now, in paragraph 22 and 23 of your affidavit, you cite a finer study,
Yes.
Defense Exhibit 512. And I believe in chart 3, it indicates the primary reason for women selecting abortion. Can you tell us what those primary reasons were?
I think you need to look at the next page.
Chart 3. Up here at the top left.
It's a little blurry over here.
I think he's going to try and enlarge it. There we go.
Oh, there we go. Thank you.
Now, this was between 2004 and 1987. Let me ask the question a little bit differently. What percentage of women indicated in this study that they selected abortion or chose abortion due to fetal health concerns?
That would be 3%.
And what about for maternal health concerns?
4%.
Is it true that by looking at this chart that over 85% of the abortions that were performed were primarily due to reasons that were not health reasons, or what we might call non-medical personal reasons?
Yes.
Now, looking also at this, indicates for a victim of rape is what amount?
Less than 0.5.
Now, in your training as a medical doctor, are you trained in state laws that require you to report sexual abuse of minors?
Yes.
So if a 13-year-old appeared pregnant, do you have an ethical and legal obligation to report that to law enforcement?
Yes.
In her report, Dr. Bedell talks about selective reduction when a woman is pregnant with higher order multiple children, usually 3 or more. Are you familiar with that process?
Yes, I am.
And do multiple pregnancies automatically endanger the mother's life?
No.
From your reading of the Life Act, are multifetal reductions now prohibited in the state of Georgia, as Dr. Bedell testified?
Not to my reading.
And why is that?
Well, a multifetal pregnancy does pose a substantial risk to the reproductive tract organ function. So if you think about it, if we just look at triplets, and I don't want you to think I'm promoting selective reduction, but in terms of the law, if you look at the woman's reproductive tract and whether or not her uterus can perform its function of carrying the pregnancy, then the presence of that third fetus represents a substantial risk of impairment to that function. And so following that line of logic, I believe it would be legal in the state of Georgia under the Life Act to perform a selective termination.
So I'm confused a little bit. I thought one of your answers maybe 6 questions ago was multi-fetus pregnancies are not an issue. And that may have not been what you meant, but that's sort of how the question was phrased. And now you're saying multi-fetus pregnancies. If you had 3, you're already at a pretty serious risk of harming the reproductive system, which we probably would all agree is a major bodily function. Hence your answer that I think the Life Act would allow the Multi-Fetus Reduction Act to occur. But let's rewind to now multi-fetus pregnancies don't pose a risk to the mom. And I'm not putting words in your mouth. That's just sort of how I heard it come out.
So, and you did hear it that way.
Okay.
So you ask a question that does it pose some unreasonable risk to the mother?
No, I apologize. I think the question was, does it automatically create a risk to the mother?
Yes, and the answer to that question is no.
Okay.
So then he asks a little different question, because the presence of the third fetus endangers the mother's uterus's ability to do its job in gestating the other 2, right? And so the purpose of the multifetal pregnancy reduction is to terminate one fetus to give the other two fetuses a better chance to stay in utero longer. So it's a risk to that function of the uterus in terms of gestating those fetuses. Now, the tricky thing about triplets is you actually have a higher loss in the pre-viable period, right? So if you just look at triplets, it's about a 4% pregnancy loss before 24 weeks. If you do the selective reduction, it's more like 8%. So by doing the selective reduction, you have fewer preterm babies, but you have more babies that don't survive. So there's a trade-off there.
And then in looking, this is why I guess coming down to your reasonable medical judgment and evaluating your patient, you reference in a report or a study from South Korea, Defense Exhibit 518 in your affidavit about managed care of triplets can sometimes provide better outcomes for the women.
Well, provide better outcomes for the babies. So with expectant management, right? Not managed care, expected management. There's a certain percentage of those babies are going to be born preterm. And this study is a newer study. And I looked at that study because the study that's referenced in our major textbook, Creasy's text, is from 2006. And again, it involves a lot of, that study does include a lot of different countries, but Korea is a developed nation with a modern healthcare system. And so we can look at that and we can say, well, wait a minute, the patient who expectedly manages triplets has a better chance of a take-home baby, right? And of course, a lot of that has to do with the fact that, a third of the babies weren't initially sacrificed by the selective reduction.
And from your reading of the Life Act, which kind of goes back where Judge McBurney came in, is there anything in the Life Act that limits your Georgia doctor's ability to manage a higher order multi-fetal pregnancy than they did before the act?
I don't think it changes it in any way.
I'm going to talk briefly about pregnancy complications. Could you describe generally the kinds of complications that you see as a maternal fetal medicine specialist?
Well, it goes back to that three areas. We have the people who have a pre-existing medical illness, heart, hypertension, diabetes.
You take down there's like this black screen. Get the witness back up. Thank you.
Heart disease, hypertension, diabetes, variety of other stuff. And then you've got another group of people who are going to encounter a problem during the pregnancy, preterm rupture of the membranes. A lot of stuff in pregnancy is breaking your bag of water, bleeding because your placenta has a problem, and then blood pressure stuff, right? And then the third area, of course, is fetal birth defects.
Now, in treating most of the complications that women may present with during pregnancy, is abortion the preferred or required course of treatment?
No, we would generally, just in general, prefer to not perform an abortion.
Now, in paragraph 29 of her report that you have in front of you, Dr. Bedell states that the Life Act, quote, does not relieve us of our duty to provide the standard of care in which we are trained. But if it remains in effect, our ability to provide the standard of care will be in question. This is borne out by countless reports of pregnant people in states where abortion bans have recently taken effect, being denied medically indicated abortion care, end quote. Do you agree with this opinion?
I do not.
Now, she relies on a paper from Dallas, Texas, reviewing 28 patients who came in. It concludes that the fetal heartbeat law, quote, led to an increased rate of serious maternal morbidity, including life-threatening complications such as uterine rupture and hemorrhage. Do you agree that a fetal heartbeat law creates those sort of extra risks for mothers?
I do not believe that the Life Act does.
All right. And did you review that study that Dr. Bedell relies on?
Yes, I've looked into it.
All right. And that was Plaintiff's Exhibit 144. And how were those conditions, as you review the literature that was provided, would be managed in accordance with the language of the Life Act?
Well, one of the cases in there, there was a hysterectomy involved, and that patient presented with a uterine rupture, bleeding into the peritoneal cavity. There's just no other management besides an emergency surgery to control the bleeding. That it shouldn't be included in the paper, right? When you look at the other complications, you realize 26 out of 28 are this preterm rupture of the membranes. That is sort of the most common time when we run into a situation in the middle of pregnancy when a pregnancy-associated complication has occurred that could has the ability to endanger a major organ system, right? But setting that aside, the other one is severe hypertension, right? And it's very well established that when you have severe hypertension in the pre-viable time that the only treatment for that is delivery, right? There's nothing new. There's no change in that standard of care. And that standard is there because that disease threatens the mother's life. And then when you look at the preterm rupture in that group, right? Preterm rupture of the membranes can lead to the primary concern is infection, right? I mean, actually, time out for just a second. The most common thing it leads to is just labor and delivery. So if you just kind of chill out and wait, there's just a vast majority, the baby's just going to deliver and there's no real decision to make. It's not a big decision point. But the things you're concerned about are primarily infection and then a little bit of placental abruption. Now, clearly, both of those pose a clear threat to the function of the mother's uterus, not just right now, but in terms of her future ability to reproduce. And so, again, those would qualify under the Life Act. And then the authors, I wish you'd put it up there.
Could you pull up plaintiff's 144, please? Be at the top of the article, the bottom of that first paragraph.
If you look at the bottom of that first paragraph, they say, the current national standard of care of women not in labor presenting with rupture of the membrane before neonatal viability allows expectant management or immediate delivery. So, to be clear, we don't make people do stuff, right? So, but the expectant management is just a nice way of saying we're going to kind of wait and see what happens, right? We're going to give some antibiotics for very close observation. We want to keep this patient out of trouble, but we're going to kind of wait and see what happens. Or immediate delivery. Well, why is immediate delivery the part of the national standard? Because of the infection risk and the abruption risk. So clearly, I'm not an expert in the Texas laws, although I've read them, right? I don't understand how this applies to this case at all, because clearly that threat to the mother's reproductive tract justifies a legal termination of pregnancy under the Georgia law.
So as you review the case data as referenced in this paper, nothing in the Life Act, in your opinion, would have prohibited abortion had the patient selected that as their course of treatment when they presented.
That's correct. That's correct. Now, to be honest with you, most of us wouldn't call it an abortion. We would call it a labor induction.
Now, in paragraph 11 of Dr. Bedell's report, she states that the Life Act, quote, places physicians in an impossible position, forced to choose between risking prosecution for providing timely, medically appropriate abortion care or miscarriage management and subjecting their patients to unnecessary suffering and risk to their health, end quote. Do you agree with her opinion?
No.
Why is that?
Because it doesn't. This law specifically states that it's the judgment of the physician involved regarding whether or not there is a risk to the woman's life or endangerment to an organ system. That's very clear. And another thing,
But tell me the part that's so clear. You say organ system, but that's not what the statute says. And I know you're not a lawyer. I'm not a doctor. But what the law says for the medical emergency exception to apply, there has to be either the risk of death, that's clearer to me, or substantial. I don't know what's so substantial. Irreversible, I get, can't fix it. Physical impairment of a major bodily function. I think reproductive system fits. Renal system, probably. Well, what about my pituitary gland? You could probably survive without that. I don't know. The endocrine system, what about one eye versus two eyes? I mean, I'm coming up with a parade of horribles, but who knows what that doctor is going to find in that situation? And I your answer, because it's not. Other smart, trained physicians have come in here saying, there is this weight on my shoulder of handcuffs and a judge and being prosecuted that is affecting the way I weigh this, because this language to me isn't so clear. So I'm curious to know what clarity you see in this, such that if you were an OBGYN in Georgia, you'd be fine navigating this. It wouldn't give you pause.
Right. So this issue, not in this case, I didn't realize there was a Georgia law, right? Until one of these people called and said, what do you think about this?
Oh, yeah, that's why you're here. There's a Georgia law.
Right. But I've been thinking about it for a couple months, and I'm like, I don't see how this is so confusing, because there's a number of these laws across the country, and these elements, it's in the physician's judgment, and they all have similar similar. So substantial and irreversible physical impairment of a major bodily function. All right, so I substituted organ, right?
No, you did, but organ's not in there.
Right, so major bodily function, right? So every day as a maternal fetal medicine doctor, every day I'm making those judgments all day long. You know, is this situation, do we continue this pregnancy or do we end this pregnancy?
But where you practice, if you get that wrong, maybe malpractice, do you also go to jail if you get it wrong? If a jury decides that your medical judgment was incorrect because it wasn't substantial impairment, or that's really not a major bodily function. We don't think that the endocrine system is so major. Appreciate your view on it. But the prosecutor trots in 6 experts, and you've seen it here. There are experts who say X and experts who say opposite of X, and they're both smart and credible. The jury believes opposite of X. You go to prison.
So what we're used to in the medical world is, first of all, doctors just love to cannibalize each other. So they love to criticize each other's management. So that's one, it's just part of our culture. And then another thing is there's a series of various regulations. Like there's a regulation that involves whether or not you can induce labor before 39 weeks. And if you violate that, you get all kinds of harassing emails about how evil and bad you are. And so that's the kind of thing we're used to. And this question though, right? And I know that you're the boss on this, but in a criminal statute,
I wish.
it's not just people picking at each other. This has to be demonstrated beyond a reasonable doubt. And the fact that the American College of OBGYN has a practice guideline that says ending the pregnancy is appropriate. I'm not a lawyer, but I suggest that it produces at least a reasonable doubt.
It's a good defense.
Yes.
Okay, thank you.
Turning to one final thing on that, you also
Actually, the doctor has one final thing.
Can you ask what about eyeballs? What about the pituitary gland? It isn't that big a list. So the stuff we deal with, right? It's cardiac, it's kidney, right? It's preterm rupture, it's abruption, bleeding stuff. Do you see what I mean? It's
a pretty fixed universe with which you're very familiar.
Yes, and it's a fixed universe that you can just pop open my guideline and our medical record and bingo, it's right there.
that same sort of analysis apply when treating a woman's chronic health condition that she had as she became pregnant.
Yes, absolutely.
Heard before about a patient who had ovarian cancer and then found herself pregnant. Nothing in the Life Act would prevent you from providing appropriate medical care to her.
Correct.
Looking at birth defects or conditions that are incompatible with sustaining life after birth. Can you talk about?
Is that a patient?
That's the hospital's emergency system.
Do we need to pause?
No, I just didn't realize I couldn't override that.
Probably a good thing you can't override the emergency system. Just saying.
I'm sorry, the scene from Caddyshack is going through my head, but I'll continue to move on. In your report, you talk about life-limiting anomalies versus lethal anomalies. How would a life-limiting anomaly apply in applying the medically futile standard as contained within the Life Act?
So the Life Act allows for terminating the pregnancy for medical futility. And what they're describing there is what in our language we used to call lethal, but now we call life-limiting.
And would life-limiting conditions in general be incompatible with sustaining life after birth?
Yes.
And these are things you can evaluate as you monitor the woman?
Yes.
I'm going to talk briefly then, before we conclude, about your role as a physician. What do you understand your role to be when treating the pregnant women who come to you?
Well, I have two patients, right? I have the mother and I have the baby. And so my duty to them is to evaluate both of them and to make recommendations, to perform various testing. Some of that's blood work, some of that's imaging, other kinds of testing, and then to make recommendations about the best course of treatment.
And does abortion undermine the recognition of the unborn child as a patient?
Elective abortion does, yes.
Now, if elective abortion was unavailable because of the Life Act, do you think Georgia doctors will be hindered in their ability to treat patients?
No, I think they can still provide that same medical care.
Now, I assume you keep patient charts?
Absolutely.
When you perform a procedure, do you justify what you've done in terms of the care provided to a patient?
Absolutely. That process we were describing of the evaluation and the thought process of the decisions that were made and the discussions we had with the patient. And very key is that we document the consent of the patient, that she understood and agreed to the course of therapy. And those records are kept, for a tremendously long period of time.
Does the fact that someone might review your records alter the way that you treat your patients?
Not at all. In fact, we're all aware that our records get reviewed by all kinds of people.
Even if the government or a third party might see them?
Yes.
Now, the Life Act imposes a reporting requirement of when an abortion is performed. Are you familiar with that section?
I've read that, yes.
Now, in your opinion, what effect would that requirement have on responsible physician, how that person treats their patients?
I don't think it's going to affect it. We have other reporting requirements. We diagnose gonorrhea and we have to report that.
Do you see any benefits to the medical profession from the Life Act?
Well, I think it better defines that this unborn child is a person. And I think that allows us to focus more on the care of that unborn person.
And when you care for a patient, you're focusing on the patient, not on whether or not a law is going to prevent you from caring for them?
Yes, both patients.
I don't have any other questions, Your Honor. Thank you.
You're welcome. You have 3 minutes left. Ms. Stone.
Two seconds.
Of course.
All right, it should shut up now.
You ready for me, Judge?
Ready.
All right. Dr. Wright, good afternoon. My name is Julia Stone. I'm with the law firm of Kaplan Cobb here in Atlanta, and I'm representing plaintiffs in this case. I appreciate you being here, and I don't know if you were here yesterday, but I know it's been a long 2 days for most of the people in this room. You have served as an expert witness in other cases related to state abortion laws. Is that correct?
Yes, one other case.
And that was the Indiana case?
Yes.
And that was a challenge to an Indiana law that prohibited D&E abortion procedures in certain circumstances, correct?
Yes, it prohibited D&E abortions with a live fetus.
And you testified for the state in support of that law, is that correct?
Yes.
Now, you mentioned in your affidavit that you were a former abortion provider, correct?
That's correct.
And you provided abortions for 13 or 14 years, roughly?
Yes.
And you performed DNC abortions?
Yes.
You've performed D&E abortions?
Yes.
You've performed installation abortions?
Yes.
Would you agree that all those methods of abortion are safe for the pregnant person?
I think they're reasonably safe. There's no perfectly safe medical procedure.
But when you were counseling patients, when you did provide those abortions, you didn't counsel them that there was an unreasonable risk to them in undergoing that procedure, correct?
That's correct.
In your report, if we could pull it up, which is Defendant's Exhibit 22, and go to page 4 of the PDF and paragraph 21. In paragraph 21, which is a section you're talking about why women seek abortions, and you've got some information about the rate of abortion in the United States. Do you see that?
Yes.
And in footnote 4 and in footnote 5, and we can scroll down to footnote 6 if we need to as well, I believe. But you're citing to information from the Guttmacher Institute for this data. Is that correct?
That's correct.
Did you find the Guttmacher Institute's data reliable for the rates of abortions?
Well, I'll be honest with you. I looked at the data. I didn't do some great deep dive into how they obtained the data. So I just took it at face value.
But it was sufficient for you to make this opinion or to give this opinion?
Yes, I think that that's a reasonable source for giving us an idea of what the rate of abortion is.
You are a member of APLOG, is that correct?
That's correct.
That's the American Association of Pro-Life Obstetrics and Gynecologists, or Obstetricians and Gynecologists?
Yes.
You're also I think I heard you testify on direct exam that you're a fellow of ACOG?
Yes.
Well, and ACOG publishes the Green Journal. Is that correct? It's also the Obstetrics and Gynecology Journal is its official name. Is that right?
Yes.
And Dr. Scott earlier today testified that the ACOG came up with very good clinical guidance. Would you agree with that characterization of the clinical guidance that ACOG puts out?
I think very good is a good way of describing it. So don't take that to mean perfect.
It's typically evidence-based, peer-reviewed literature.
Yes.
If you're done with the exhibit, let's take it down.
We can put that down. Sorry, thank you. And do you consult articles from the Green Journal when doing research?
Absolutely.
And ACOG also issues practice bulletins and committee opinions. Is that right?
Yes.
Do you consult those in your practice as well?
Yes.
And Dr. Wright, you are not licensed to practice medicine in Georgia, correct?
I am not.
And you've never practiced medicine in Georgia?
Correct.
I assume you probably don't have any plans to practice medicine in Georgia in the future.
Not that I know of.
And I want to walk through a couple of the opinions that you've offered in this case. If we could pull back up Defendant's Exhibit 22, go to page 2, just paragraph 13.
Dr. Wright, you still practice, and I followed your chronology as best I could. You're still in Delaware.
No, Wilmington, North Carolina.
Oh, Wilmington, North Carolina, not Delaware. Okay, so you're still in North Carolina. And what is the state of play of abortion regulation there? Is it Life Act, more restrictive, less restrictive?
There's a cutoff of 20 weeks that goes back. I mean,
So it's a viability line rather than a fetal heartbeat line, closer to viability.
yes.
Okay.
In paragraph 13 of your affidavit, you say, from a scientific standpoint, life of a human begins at fertilization. That's consistent with how you've testified on direct examination as well, correct?
Yes.
And to support that statement in footnote 1, you're citing to an article from the American College of Pediatricians. Is that right?
That's correct.
Now, the American College of Pediatricians is different than the American Academy of Pediatricians, correct?
Correct.
So the American Academy of Pediatricians is a professional organization of pediatricians, right?
Yes.
And the American College of Pediatricians is an advocacy group. Is that right?
I don't know that I'm qualified to define them one way or another.
You just don't know one way or the other.
Right. I've just read what they wrote and thought, wow, that sounds really good. I'll use that.
So you don't know that the American College of Pediatricians is an anti-abortion advocacy group?
Oh, I'm aware of that. Yes.
Are you aware that the American College of Pediatricians has been labeled a hate group by the Southern Poverty Law Center?
Oh, I'm not aware of that.
Could we pull up Right 8? This is from the Southern Poverty Law Center and about the American College of Pediatricians. And if you see underneath the sign, it says extremist group info, SPLC designated hate group. Do you see that?
Yes, I do.
And that's because it advocates against adoption for LGBTQ families and advocates for conversion therapy. Is that right?
That's what it says. You're well outside my area of expertise. At this
Understood.
point.
But you didn't do any research into the American College of Pediatricians before citing it in your report?
Regardless of who they are, they wrote a nice paragraph and I thought it sounded good. So put it in the report.
We can take that off. I want to turn to talk a little bit about multifetal pregnancies, which you talked about in your report and here earlier. You would agree that preterm birth is far more likely with multifetal pregnancies than with a singleton pregnancy, correct?
That's correct.
And you would also agree, I presume, that preterm birth can raise a whole host of complications for the baby, correct?
Sure.
Cerebral palsy is one.
Yes, but to be fair, the vast majority of babies that are born preterm do just fine with modern NICU care.
But it is an increased risk of preterm birth.
Yes.
Chronic lung disease is an increased risk with preterm birth. That's yes for the court reporter.
Yes.
Stillbirth is an increased risk of preterm birth.
I think you're trying to say neonatal death.
Well, neonatal death, I think is separate. Do you distinguish between stillbirth and neonatal death?
The properly monitored multifetal gestation, stillbirth is pretty uncommon. So, I mean, technically there may be some tiny increased risk, but for the most part, we've got a handle on stillbirth. But there is an increased risk of neonatal death that's related to the preterm birth.
And would you agree that a multifetal pregnancy reduction reduces the likelihood of preterm birth?
Yes.
And so it therefore would reduce the risks associated with preterm birth.
Yes.
Are you aware that ACOG has issued a practice bulletin that multifetal pregnancy reduction reduces a lot of other risks as well?
Yes.
Including lower that, actually, if we could just go ahead and pull it up, which is Plaintiff's Exhibit 124. And page 3, this is the ACOG practice bulletin.
Right.
And I'll tell you that the highlighting in here is not from me. It is on the version that's available online.
I think those are the areas that were adjusted with this new iteration.
And if we go to underneath the multifetal reduction, selective fetal termination, that paragraph going on to the next, it says that a Cochrane review found that women who underwent pregnancy reduction from triplets to twins compared with those who continue with triplets were observed to have lower frequencies of pregnancy loss, antenatal complications, preterm birth, low birth weight infants, cesarean delivery, and neonatal deaths, with rates similar to those observed in women who spontaneously conceived twin gestations. Did I read that correct?
You did.
Do you agree with that statement?
Well, I would say it's generally accurate. It's somewhere in here. Hopefully, they talk about the potential for a procedure-related loss risk.
And this statement is based on a Cochrane review.
Correct.
Sorry. And that refers to the Cochrane database of systematic reviews.
Mm-hmm. Yes.
Are you familiar with the Cochrane
Yes.
database? And it's the leading journal and database for systematic reviews in healthcare. Is that right?
Yes.
So because of the risks associated with multifetal pregnancies, and we can take this down, ACOG recommends that OBGYNs respect patients' autonomy, whether to continue or reduce a multifetal pregnancy. Is that right?
That's correct.
Do you agree with that recommendation?
Yes. I mean, we discussed multifetal pregnancy reduction for all multiple gestations.
So it's an option that you counsel your patients about and let them make the decision.
Yes.
I want to talk briefly about the Lee study that you talked about on direct and mentioned in your affidavit as well. And I believe you said that the Lee study showed that it was better for the fetuses not to undergo a selective reduction. Is that?
I think the real summary of the Lee study is the patients who were expectantly managed were more likely to actually get, and I don't mean to be crude about this term, but to get a take-home baby. Okay, so that's what the study shows.
That at least one fetus survived the multifetal pregnancy.
Yes, exactly.
Could we pull up the Lee study, which is Defendant's Exhibit 518? Is this the Lee study that you were referring to?
Yes.
And could you go to page 2, please? Now, this study, if you look under material and methods in that first paragraph, which we could pull up the whole thing, this study looked only at patients who were pregnant with triplets. Is that correct?
Yes.
And it didn't look at patients who were pregnant with more than 3 fetuses.
Correct. This was restricted to trichorionic, triamniotic triplets.
And you would agree that the higher order a multifetal pregnancy is, the higher the risks are, correct?
Yes, that's correct.
And so you'd agree that this study doesn't really have any bearing on multifetal pregnancy reductions for multiples greater than triplets.
Correct.
And as you just mentioned, it's a trichorionic, triamniotic triplet pregnancies. Is that right?
Yes.
I think the judge is probably going to want to have some explanation. Trichorionic means there were 3 placentas for each of the 3 fetuses, right?
Chorions, yes.
And triamniotic means then there were 3 separate gestational sacs.
So these are genetically 3 separate babies as opposed to 1 baby and then a set of monochorionic twins.
We can take this down. Now, are all triplets trichorionic?
No, you get situations where there's a kind of a 1 baby and then the other 2 are identical twins.
So you have dichorionic triplets, is that?
Exactly.
And would you agree that dichorionic triplets are at a higher risk of perinatal mortality and morbidity than trichorionic triplets?
Yeah, so they contain a pair of monochorionic twins. All the risks associated with monochorionic twins are incorporated into that triplet pregnancy.
So the Lee study wouldn't have any impact on dichorionic triplet pregnancies?
That's correct.
We also talked about, or you talked about on your direct examination, other maternal complications that you see as an MFM. You, I think, mentioned, well, actually, I'm going to pull up your report, if we could, which is Defendant's Exhibit 22. And if we could go to page, let's start at page 6, paragraph 31. In paragraph 31, you're talking about, hold on, maybe, a substantial hemorrhage from the uterus indicating miscarriage in which a fetal heartbeat remains. Do you see
Yes,
that?
I do.
And that's a maternal complication that you've seen in your practice before.
Yes.
And if we go to paragraph 44. Which is on page 8 and into 9. We don't need to blow it up, I don't think, but here you're talking about the WHO cardiac class conditions.
Yes.
And if we continue down to, and you've seen patients with class 3 cardiac conditions in your
Yes.
practice. And in paragraph 46 and 45 and 46, we're talking about renal failure or potential renal failure, correct?
Yes.
And you've seen patients with potential or actual renal failure in your practice?
Yes.
And in all of those situations, do you agree that the standard of care indicates that you counsel the patient about the risks of continuing the pregnancy and the option of termination?
Yes.
And then you let the pregnant person make the choice of what's in her best interest?
That's correct.
And it's the patient's choice in those situations because it's not strictly necessary. Aborting a pregnancy isn't strictly necessary to save her life. Is that right?
Well, I mean, there's shades of this. So if a woman with a cardiomyopathy, when you're speaking with her, he's trying to catch her breath while talking to you. And she tells you that she can fold half a load of laundry before she has to sit down. That patient's cardiac output will not be able to meet the needs of the pregnancy, and she's going to go into heart failure and likely die. And so in that situation, I mean, I want to be clear that the patient makes the decision, right? But there are shades of this. So that patient, I'm going to say, I really think you need to end this pregnancy or I believe you will die. Now, in a different situation, I've seen some crazy stuff. I've seen people with WHO class 4 who skated right through, right? So in the class 4, that is the class where there's sort of, we all agree that those people shouldn't be pregnant, right? Now, that doesn't necessarily mean we're going to try to, I don't know, kind of make them have a pregnancy termination, right? I don't want you to think that, because that is not the way it works. It's the patient's decision, right? But when you get down into class 3, we might say to them, look, you're not a class 4, but you need to understand that you might have some very significant cardiac events during this pregnancy, and those can lead to harm to you. You might be halfway through this pregnancy, go into heart failure, get low on oxygen, cut off the oxygen flow to your baby, and have a terrible outcome. And so the patient needs to be made aware of that range of possibilities. And then, fundamentally, she decides which way she wants to go. And while I'm having that conversation, you realize all these WHO people, they all have cardiologists. And many of these people, it's a 25-year-old patient who's had this disease for 25 years, her entire life. So, many of these people know far more about their cardiac disease than the obstetrician does.
In your opinion, I believe you indicated on direct that if you have a class 3 or a class 4 cardiac condition in a patient, if you have a patient who's showing creatinine levels of 1.4, if you have a higher order multifetal pregnancy, in your opinion, in all of those circumstances, HB 481 clearly allows the termination of the pregnancy. Is that right?
Yes, I believe that's true.
And that's based on your opinion that those conditions create a substantial and irreversible risk to the pregnant person?
That's correct.
And I heard you use that phrase several times in your direct testimony about a substantial risk to the patient. Are you aware that the phrase substantial risk does not appear in the text of the statute?
Yes, I am. What's interesting about the way the statute is written is it mentions preventing, right? The word prevention is in there. And we don't know the future. We may, there's some leeway in diagnosis, first of all. Diagnosis is not perfect, right? But in terms of prognosis, there is certainly a range of error in that, right? And so when you say we need to prevent this outcome, we need to prevent this patient with this significant heart lesion from going into heart failure, right? She has a substantial enough heart lesion that there's a substantial enough risk. The only way you're going to prevent her from going into heart failure related to the pregnancy is to terminate the pregnancy. Now, that doesn't mean it's required, right? But if you say we need to prevent a significant and irreversible, I hope I got the verbiage right.
Yep, you're doing well.
Right. To a major bodily function, you've got to do that in advance, right? You can't wait, you can't wait until you're already in the middle of it.
Because then you haven't prevented it. It's happened.
Yes. And so that's why I use the word risk. We use the word high risk pregnancy, or at risk for this or at risk for that, because we recognize that we really don't know exactly what's actually going to happen to you, because that's the future, right? So if you want to prevent that from happening, you have to take action before it.
Could we pull up the language of HB 481, which is Plaintiff's Exhibit 1, and go to page 4? Because I agree with you that the language prevent is in there. But if we look at it, and I understand you're not a lawyer, you are a doctor, but if we blow up section 3, please.
Just for your time management, you got about 8 minutes.
Okay, perfect. It says that a medical emergency is a condition which an abortion is necessary in order to prevent. So at what point in the percentage of a death, percentage risk of a death, or percentage risk of substantial and irreversible physical impairment is an abortion necessary to prevent those things from occurring?
Right. So in the practice of medicine, rarely do we have enough data that we can assign percentages. And in fact, all these things we're talking about are, uncommon in a reproductive age woman. right? And so when you say, well, what's the percentage of that? Well, we don't have a study of, 1,000 women with your cardiac lesion, right? We don't have a study of that. So we really can't give you a percentage. All we can do is say, this is a really big risk, right? We can't put a number on it. And then, an abortion is necessary. So we back to this, we want to prevent that from happening. Well, you're not going to prevent a pregnancy associated death or a pregnancy associated substantial and irreversible impairment of that major bodily function. You're not going to prevent that without performing an abortion. Now, again, I'd just call it a pregnancy termination, the labor induction. I wouldn't use the abortion word, to be honest with you. But nevertheless, the ending of that pregnancy is necessary in order to prevent that outcome.
Even if there's a 15% chance that the person could survive and deliver at term, an abortion would still be necessary to prevent the death of the woman at that point.
Right. We don't have the data set to give you that number.
Right. Are you aware that the state hasn't issued any binding guidance or regulation confirming your testimony here today that a cardiac level 3, class 3 condition, renal failure, 1.4 creatinine levels, severe hemorrhaging with PPROM, that any of those circumstances would qualify as a medical emergency? Are you? Are you aware that I'll rephrase it, that the state has issued any guidance to doctors in Georgia confirming your opinion here to say, you know what, don't worry about it. You can perform an abortion in all these circumstances.
Right. I'm not aware of that now.
And I want to.
That it would actually confirm Dr. Wright's opinion, but the point is there aren't guidelines saying this is okay, i.e. necessary, a situation where it's necessary. This isn't. There aren't any rules yet.
Okay.
I want to very briefly talk about fetal anomalies. And in your affidavit, we could take this down, please. Thank you. You talked about trisomy 13 as a serious fetal anomaly. Do you recall
yes.
that? And you would agree that it's a severe genetic condition.
Yes.
And you would agree that the vast majority of children who are diagnosed with trisomy 13 would die within the first year of birth.
Yes,
right?
they often die in utero.
Only about 10% would make it to a year of life. Is that about right?
Something like that.
And those who do would have a host of medical issues that required care throughout that year.
Yes.
And in your affidavit, you said, though, that HB 481 would allow, but not require, the termination of a pregnancy where the fetus has been diagnosed with trisomy 13. Is that right?
That's correct.
And what's that opinion based on?
That it fits the definition of medically futile.
And if we could pull that back up, I told you to take it down, which is plaintiff's exhibit 1 again. And also back to page 4. And if we look at paragraph 4, medically futile means in reasonable medical judgment, an unborn child has a profound and irremediable congenital or chromosomal anomaly that's incompatible with sustaining life after birth. Did I read that correctly?
Yes.
So how do you balance the fact that 10% of children born with trisomy 13 are going to survive with the idea that it is incompatible with sustaining life?
Well, as you pointed out, the vast majority have passed away by 1 year of age. And so, I would not consider that sustained life.
And are you aware that the state hasn't issued any binding guidance or regulations saying that trisomy 13 qualifies as a medically futile pregnancy under this exception?
No, I believe that they wrote the law very clearly to put that decision in the hands of the physician in the reasonable medical judgment.
But there's no, to your knowledge, there's no guidance from the state about that other than this section.
Correct.
And again, Dr. Wright, you don't practice in Georgia.
Correct.
And so there's really no chance, there's no risk to you of being prosecuted under HB 481 for making the wrong judgment here, right?
No, I would be, if I'd taken action to terminate a pregnancy after 20 weeks, I would be liable for prosecution in the state of North Carolina.
And on direct examination, I think it was some questions from Judge McBurney, you talked about how doctors get pushback from the medical community a lot. And he said, you know, if we induce pregnancy or induce delivery before, I think he said 39 weeks, we might get a whole host of nasty emails from others. You're not suggesting that getting a nasty email is the same thing as being prosecuted and put into prison, are you?
No, I'm not suggesting that at all. I'm just suggesting that physicians are used to being criticized for somewhat petty reasons. And fortunately, this statute requires proof beyond reasonable doubt. And so we don't need to worry about a bunch of petty emails related to this.
I have no further questions.
All right. Any redirect?
Just briefly, within the 3 minutes.
Did I say 3 minutes? All right, it's rolling.
All right. Dr. Wright, are you familiar? The criticism of the American College of Pediatricians was because the Southern Poverty Law Center labeled them as a hate group. Are you familiar with the Southern Poverty Law Center?
I've heard that name. I don't know anything about them.
You familiar with the fact they've been sued by a number of organizations because they label them as a hate group?
I'm completely not familiar with that.
Because the Southern Poverty Law Center labeled the Family Research Center or Council as a hate group. Someone shot up their building in Washington, D.C.
I'm not aware of that.
Okay. They're not a medical organization as far as we know.
Yeah, I don't know exactly what they are.
We can pull up Plaintiff's Exhibit 124. On the third page, right above clinical considerations. See where it says here that the unintended loss rate of the pregnancy is increased when women with higher order multifetal gestations undergo selective fetal termination in comparison with women with twin gestations who undergo the procedure. You see that?
I do.
Is that similar to what you were discussing before?
Yes, that when a patient opts for a selective termination, she of course needs to be counseled that there are some procedure-related losses that can potentially occur.
And Dr. Wright, in order to exercise your reasoned medical judgment in caring for women in these high-risk pregnancies, we're talking about significant medical complications due to pregnancy that may impact their life or major bodily function. Do you need state guidelines to tell you how to do what you've been trained to do and taught to do?
No, these state guidelines are just a spec compared to our education, 4 years of medical school, 4 years of residency, a fellowship, and then all the reading associated with that, 2 sets of, for specialists, we have 2 sets of written exams, 2 sets of oral exams. It's a very extensive training and it needs to be because we make gut-wrenching decisions all day long, every day. When I answer that call, it ain't going to be kitty and puppy, right? It's going to be another gut-wrenching decision. And that's what we do as maternal fetal medicine specialists.
The Life Act doesn't prevent you from making those decisions in the best interest of your patients, correct?
No, not at all.
Nothing further, Your Honor.
Dr. Wright, thank you for your time. Appreciate it. Sorry, I confused Wilmington, Delaware with Wilmington, North Carolina. Well, you did it. All the witnesses you listed, it's 5:30, 2 days, very impressive. We have some endurance runner court reporters to keep up with everything. Why don't we get on the record what the parties' expectations are for the briefing process? I know we talked about that in a pretrial conference, but I want to confirm that the dates that we had discussed still work, or if anything has changed, and if there's anything else procedurally that we need to take up. So I'll start with plaintiffs.
Your Honor, nothing procedurally. My understanding is that we were going to jointly submit post-trial briefs on November 4th. Next Friday? Yes, simultaneously. And then I don't have the date for the 10th, and then having a opportunity to respond to each other's post-trial briefs on November 10th.
Right.
And that still works for us.
Okay. Mr. Scher?
And that schedule still works for us, Your Honor.
All right. Still works for me. So what we'll do then, and when we said simultaneously, meaning was there like at noon, everyone has to drop the briefs, or meaning submit briefs? I just wanted to be clear so there's not a panic on the 4th of November. Like, well, we did something at noon and the other side didn't. I'm neutral on that. If everyone is submitting something by close of business that day, meaning 5 o'clock, that's fine. But I'm also happy to say, no. It needs to be, well, just by when.
Your Honor, we've done, I think, a pretty remarkable job of conferring with the lawyers on the other side and coming to an agreement. So maybe we should talk about it. And
I'll leave it with you. Yeah, I didn't mean to speak over you. I'll leave it with you all. And you've also done a remarkable job when you can't agree on something, reaching out to Ms. Niles, and then we get together. So neutral, it may be 5 o'clock, doesn't matter. Just make it the 4th. And then same process for November 10th. Mr. Scher, anything procedurally from the state side?
Not procedurally, Your Honor.
Okay. Anything substantively beyond all the substance you've provided?
Well, Your Honor has already mentioned the cooperation between the two sides, and on behalf of our team, we do want to thank the lawyers on the other side for the cooperative way in which they've managed what could have been a very difficult situation for this trial. And we want to also thank Your Honor for your graciousness to both sides, and to the humor and pleasantness with which you've conducted the trial. Thank you.
Well, you're very welcome. And it has been an honor to work with the professionals on both sides. The subject matter with which we are dealing sometimes lends itself to shrillness, and we haven't had that, which is good. We've had substance and passion, but there are lots of things to be passionate about on both sides of this discussion. But that passion hasn't led folks to get out of bounds. So I appreciate that. Other than whoever that was on our first Zoom session who really had to yell about things. It sounded like it related to a criminal case, which was odd. It has gone very smoothly. So, and that's a testament to all the lawyers on both sides, and to Ms. Niles and our court reporters. So if there is nothing else, we'll wrap it up, and I'll await the briefs. If something comes up, we need to move these deadlines around and it's mutually acceptable, just let Ms. Niles know and we'll work through it. Okay. Thanks, everyone.
Judge.
Yes, ma'am. Up. No one go anywhere. I mean, if you're in the gallery, you can, but lawyers know. Yes, ma'am.
So I need just a moment before you close the Zoom, because I want to post the link for the attorneys to submit their exhibits to plaintiff depots. I can put that in for them, but if you close the link, you'll lose it.
I won't close the link till you post what you need to post. Okay. Is that something you can do real soon?
Yes, so I'm going into my email to grab that, and then I'll post it. So.
Thanks for having me. I really appreciate it. Safe travels.
So I know it's loud in here. We're off the record, but I need someone from both sides to stay on the Zoom, because Ms. Stevenson is gonna, but last time you didn't do what you were supposed to do.
We got it this time.
Okay. She's gonna post something about where these documents go.
Okay.
All right, so there is a link now in the chat section. I want to make sure everyone sees it. Mr. Prince, you see it? Great. And BME, you see it? All right, thank you, Ms. Stevenson.
Thank you.
Sorry. It's nice to meet you all. Nice to meet you again. It's nice to meet you.
Let me know when I can shut down the Zoom.
Thanks, Brian.
You got it? BME, you got it?